Morning, people. Morning, people. Let's get our Young Thug Rico trial screen going. And we are live. How's everybody doing today? How's everybody's weekend? How's everybody? Let's see. GM. Good morning, Papa Bear. Good morning, Roxy Louise. Good morning, Lightfoot. Yeah, we're supposed to be getting going here. Should be starting in the next couple of minutes, I would imagine. Grand Rising. Yeah, I know that's the new thing. Grand Rising. Probably kind of a cool way to say it. I'm not mad at the Grand Rising. Critical Conversations. Good to see you again. Herbert Jordan, good morning. Is that Love to Travel? Morning. Semper, morning. From Texas. Callie in the house. Kim Ricks, you up early? It's before 6 a.m. there in Cali right now. How's my audio, y'all? Every time I come on here, I need to do an audio check. Mona yourself. Is that Philippa Oliver? Morning, people. Good morning. Good morning. Lakia. Is that Nikita? You know, sometimes it's hard to read these names here. Herbert. Audio good. Very good. Very good. So, y'all, what are we looking out for? Did anybody have a chance to see the Monk Tunk video from yesterday? Did y'all see the Monk Tunk video yesterday? It was, I guess I would say, to be.
I mean, honestly, the motion in limine is basically saying, can we make sure that we follow 24/7/704, which we will. But in terms of preventing testimony short of something that would violate that statute, it's denied short of that. So it's not going to change any of the previous rulings about what various experts can testify to. All right, motion in limine 65. Let me look at the response again real fast. I printed those out, but I didn't bring them with me this morning. So give me a second. Actually, I think they're arriving right now. So the contours of Investigator Viverito's permissible testimony have already been established as well. And so we won't be changing the ruling on that either. And then we've got motion limine 66, which concerns Mr. Lamar, Rich Homie Quan, and neither side really should be able to say. It seems that the defense wants to bar the state from being able to say the defense didn't call this witness at trial, which obviously they concede they have no right to do and say they have no intention of doing, and they would not be permitted to do such. But at the kind of flip side of the same coin, the defense seems to maybe be suggesting that they would like to present that the state could have but did not call that witness. And I would not permit that either, because we're clearly nowhere near, unfortunately, the end of the state's case. And obviously, Mr. Lamar has now passed, and so we don't know whether they would have called that witness or not. So I wouldn't permit the defense to make that kind of a presentation either. So I trust that everybody understands what they would not be permitted to do. And then we have, yes, sir.
Speak to that for a moment.
Yeah.
Good day, Your Honor, and good day, everyone.
Good morning.
So I understand your ruling obviously abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us lists of witnesses on a short list that they were going to call Mr. Lamar, who's a performer known as Rich Homie Quan. This was well before September 5, 2024, when he, God forbid, passed unexpectedly. So to me, and the state has put in evidence over objection that starting in the fall of 2014, Mr. Lamar and Jeffrey Williams don't get along, and Mr. Lamar is with Mr. Donovan Thomas, who doesn't get along with Jeffrey Williams. And it's all, to me, it's all made up. It's not supported. Obviously, the jury can make that determination. But I think that it is important that the state, in writing, put the predecessor court, as well as the Mr. Williams et al., on notice that they were going to call Mr. Lamar. They filed their service of a subpoena, and they don't call him to support this, supposed beef. And I can't do anything about his prior statements now because it would be frivolous under 24-8-807, which is rarely used. It's frowned upon, and it has to have the same guarantees as a dying declaration or something. It's not like that. He gave interviews throughout all the years talking about his close relationship with Jeffrey Williams. And if you let that in, that's great with me. But I'm assuming you're not going to let it in, so I wasn't going to try to get it in because I don't think that that's a dying declaration type of statement. So I'm stuck. So I would like the jurors to know that unfortunately he passed, and the state stated that they would call him as a witness and subpoenaed him. And if the state has reasons that they didn't call him, that's fine. I understand I'm opening a door, but that's why I put it in writing. That's my motion.
All right. Well, I mean, if the state's case were over with, then that would be a different argument. But it is not as though the state's witness list has stayed in anything like any semblance of order during this trial. So, I mean, I don't think that if you can get a concession out of the state that they weren't going to call him even if he stayed alive, that would also be different. But I don't think that we've got that situation.
I understand the ruling.
All right.
Thank you, Your Honor.
Okay. And then we have this issue of the state wanting the court to reconsider its ruling striking whatever day that was, that one day of the detective's testimony and the defense response. And I believe, and Mr. Armstrong, I see you standing because you might want to argue, but I think that the waiver argument that is presented in the defense response is meritorious. I think that the arguments that the state made after that they were waived because they certainly were not made at the point in time when I could have done something about it. But in addition, the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, I mean, it seems like this whole issue is moot. You may be.
May it please the court, Kevin Armstrong for the state. First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor referred to, is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's one of the things that the state filed the motion for reconsideration to avoid. And so the state is asking that for other issues and for whatever issues that have not already been addressed, the state be allowed to recall Detective Dennis to testify about other matters that were not the offending statement, which the court appropriately excluded from evidence. And one of the things the defense brought up in their response was confrontation. I want to make it absolutely clear that there was no intention in the motion for reconsideration to have state's evidence in that they didn't get the right to confront. And so that was not part of the issue. But the issue isn't only the testimony that was struck from that day, it was his future testimony, precluding him from testifying in the future. And while there are other means to get in some of the testimony, I don't believe that is all the testimony that the prosecution team intends to get in through Detective Dennis. And so essentially it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective is not going to be testifying to, because she got was qualified to be able to testify to the meaning or her opinion as to the meaning of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
Thank you, Your Honor. Detective Dennis testified to a statement regarding defendant Kendrick, in which Investigator Underwood was not present for that interview. And so he testified to that. He also testified further regarding the Quindarius Zachary interview, in which Investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through Investigator Underwood. And I believe those are the three primary things that Investigator Dennis was able to testify to previously that was struck that Investigator Underwood would not be able to introduce during her testimony. And course indulgence for one moment.
All right. Thank you.
Thank you.
Okay. So, Mr. Steele, I guess you sort of led the charge on this, if I'm not mistaken. What do you say to the state's position that the court's decision to strike and prevent further testimony of this witness isn't a remedy that is permitted to the court by statute or the Constitution, and understanding that if this were reconsidered, the state would be, I mean, the defense would be permitted to cross-examine?
So I believe that you have the authority, jurisdiction, and power to prevent a witness from testifying when that witness shows that they are not capable of providing a fair trial and intentionally, and that's my word, but it was clear to me sitting there that when Ms. Hilton asked retired Detective Dennis, tell us about this photograph that has Mr. Kendrick standing on top of a car, his initial lead into that answer is, well, Mr. Kendrick just got out of prison. And, that affects Jeffrey Williams. Mr. Kendrick, as the court may have heard, is signed to Mr. Williams' record label. Mr. Kendrick, as you will learn, is at Mr. Williams' home on May 9th, 2022, when Mr. Williams and Mr. Kendrick are arrested. And it is just not that simple to unwind that instruction. It was an intentional, obvious infliction to denigrate this trial and prejudice Mr. Williams, Mr. Kendrick, and all. So you then have to do something about it. And what you asked to do is declare a mistrial. And you said, I'm not doing that, but there will be a sanction. So what are you going to do? So to me, that was the second time. The first time the court, I'm not saying it's not accurate.
So obviously, considering that I'm the one that imposed the sanction, I think it was an appropriate sanction. Address the state's argument that a trial court doesn't actually have the authority to impose that sanction.
I think that's wrong based upon, let me give you, and I put it in my response, but Illinois versus Allen, 397 U.S. 337, it's 1970. What happened there, and the U.S. Supreme Court took down, that was an accused right to be present at a trial, constitutional right. And there's a dissent in it saying the accused, no matter what their conduct is, they could be gagged and bound. They have to be in the courtroom and watching the proceedings. Otherwise, it's a constitutional violation. But the majority said, this is ridiculous. Courts have to have the power to ensure that the trial is, and I'm quoting, conducted with dignity, order, and decorum. They are the hallmarks of a court proceeding. And then I found a case, I just found it amazingly similar. California versus Navarrete, Navarrete. Your Honor, it's 181 California Appeal 4th, 828, 2010 case. And in that case, a detective is testifying, and there was a suppression motion granted. There was no Miranda rights given to Mr. Navarrete. And the detective testifies on the witness stand and said, well, the reason I didn't follow up on this DNA swabs is based upon the client's or Mr. Navarrete's statement. The judge did exactly what you did. The judge called the prosecutor, well, a little different, called the prosecutor and defense counsel in chambers and yelled at the prosecutor and said, I'm demanding, what are you doing? And the prosecutor said, I didn't know that would happen. Just like here, I'm not saying that it was Miss Hilton eliciting that on purpose. I had no information that she would ever do that. But the judge said, well, this detective knows better. I find the detective is trying to harm this trial. The detective is barred. His testimony is struck. The direct is gone, and he can no longer testify. And the state did exactly what happened here. The state in California, the prosecution, the people, they called the next witness. To me, it's on all fours. The appellate court, Mr. Navarrete is, God forbid, convicted, and the appellate court then reversed and said, that remedy did not go far enough. That had to be a mistrial, that intentional conduct. And here, I'm asking the court, I believe that you have total authority. There is no way that anyone will convince me, I'm not the one who needs to be convinced, that Detective Dennis did not realize. It came out of nowhere. What difference does it make that Mr. Kendrick was released from prison 5 weeks earlier? What difference does it make? He did that to bring out to the jury that Mr. Kendrick was in prison for, and I'm telling you, it's a federal offense, a gun charge. There was no basis. So to me, to say you don't have the authority to do that, I believe you have every authority. If a witness comes in here and starts cursing, I'm using an example, I would assume, you are going to say, this is just not decorum. You can't curse. The witness curses again. You're going to do something. You're done testifying. Courts have that power. So I believe that the state's argument that you have no power to control the proceedings is not backed up by the U.S. Supreme Court.
All right, thank you.
May I respond?
You may.
There was a defense attorney who raised their hand.
Good morning.
Good morning, Your Honor. I want to be very brief because I don't think what I'm going to add is truly what Your Honor is looking for. But
Jay Apt, Your Honor, good morning, on behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers at any particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses. And so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court has sent a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority, and Mr. Steele has done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Thank you. Mr. Armstrong.
Yes, Your Honor. I would agree with Mr. Apt to the point that I would like the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come in the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court the court appropriately struck the testimony that was at issue. We are asking the court to go further with other testimony that was not the offending testimony. Now, People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite. And that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here. And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case. And the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402, the exclusion of evidence can't exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we're just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this. All right. I think that the next thing that we had to do was the sort out the remainder of what we're calling the Ryan evidence. So if y'all want to present what you've come to agreement on and what still needs to be litigated. And thank you, Mr. Armstrong.
Thank you, Judge.
Yes, Your Honor. And one small matter that's in this act we can address
Okay.
is in the CAD report. Okay. Never mind, Your Honor. Counsel and I have been discussing stuff in frequently. So
Yeah, I know.
I will turn to all that's left to my understanding is the last little bit of Blaylock's Instagram.
Okay. And do y'all want to give me some kind of, I don't know if it's written or whatever, indicator of what y'all have agreed to, or just put it on the record, or what's in, what's out?
Your Honor, I'm trying to think.
Or I guess, you know, if you don't have something at the ready, then I would assume y'all are on the same page about it and will abide by whatever it is you agreed to.
Your Honor, I believe that is accurate.
Okay.
I think what the state would be moving to enter into evidence is things that we've agreed upon or the court has already ruled on.
Okay.
Besides what it is we need to discuss this morning.
Okay. All right. And so what is it that needs to get discussed this morning?
This morning, Judge, we're going back to content in Mr. Mr. Damone Blaylock's Instagram messages between him and third unknown parties. Your Honor had asked me to take a look as far as co-conspirator hearsay.
Okay.
From what I can tell, every instance I've found requires evidence really from the outside, that basically you could ignore this entire statement and there's still something to indicate participation in the conspiracy. I don't have any sort of law stating one way or another that that is what is required. I would just point back to the statute, Your Honor, that I think what Your Honor had referred to, I would say kind of are indicia of reliability, that they're talking about things that a person who's a member of the conspiracy would know about. And just simply, that's not what's articulated in the statute. If it was supposed to be indicia, then I think we would be there. But that's not what the statute requires. So I don't think that would be sufficient. I think it truly does have to be from outside of that hearsay statement.
All right. And is there further argument from the state on that? And I know there was one, and there might have been two that we had already looked at that were kind of outstanding. And I had given a preliminary ruling subject to further argument on this. And the second one, I think I already brought up, and I don't know, Ms. Abbasi, if you were here that day, but that I didn't think there was enough, so I have excluded that. But the other one, does the state have any further argument or authority on that?
So, Your Honor, I don't have, the state's argument was in looking at 801 D2E, just the basic building blocks of if the court finds through the four walls of a statement, evidence in trial, or some other evidence the state would present. Ultimately, it is the court has to find that other party, whoever they are, to a preponderance, are part of the same conspiracy against who it's being used against. And I will use, I don't have a specific case for this principle, but I think it illustrates this point the state is making, is if you take aside a gang conspiracy, say you had a murder committed and the defendant's phone, they get a search warrant, they extract it, and he is messaging someone after the murder that you do not know who they are. And he says, I need you to go to my house. The murder weapon's in my back bedroom in the second drawer. And they respond back, yep, the police, I can hear the sirens coming down the street right now. I'm going to go grab that gun. Where do you want me to take it to? And they have this whole conversation. You don't never know who he's speaking with. By my reading of, or an understanding of co-conspirator, that conversation, if you had it in that trial and were trying to introduce it, I believe a court could find from the four walls, so to speak, of that conversation that person they're speaking with to a preponderance is a co-conspirator. And by that same analogy, if you have in the conversation that the unknown party, so to speak, whether it's their Instagram handle, the fact that they're referencing specific individuals, or that gang APD detectives have referenced are, say, YSL members, or they're discussing locations, or they're using gang identifiers in a private conversation, coupled with the evidence that hasn't came in yet, because no evidence about Blaylock to the jury has came in, but when APD gang detectives to speak about Blaylock and his Instagram and public and private conversations indicative of his own membership in the YSL criminal street gang, all of those the court can use or not use in making that determination. And so I don't have a seminal case that says you need more than the statement itself. I think oftentimes the statement itself, absent this kind of, in a gang context, there's other information versus when you have just, say, a murder case, you would, other than the factual analogy I just gave to the court, it would probably be hard to decipher. If you just had a single text with an unknown party, you wouldn't know who they are unless it was like the analogy I used. So the state doesn't have any additional case law. I always will cite, because I think it's a seminal case and important for a criminal street gang conspiracy, which all of Blaylock's are, the state's arguments related to them are not tethered to the murder of Jamari Holmes. They're tethered to the YSL criminal street gang, at least the ones that are in dispute, I should say.
All right, so can somebody remind me where it is that we're going to find the statement specifically that we had been paused on before?
I don't know if this, I'm sorry, excuse me. I don't know if the state sent to the court a new link, or we're
I'm
still on
sure
the
there was
prior
a
one.
link that y'all sent me at some point.
I can create
Over and over again, I know, I'm
Yes.
sorry.
for a,
The most recent
If,
one, I
if
don't
you want
know.
to just remind me when that was, I could probably find it.
The-
Or what folder it was in.
yes, Your Honor. The initial folder was 9 October centralized motion folder in Dropbox. For efficiency's sake, I can
Okay,
quite quickly create and
that would be
send.
wonderful. A new link,
Yes, Your Honor.
okay. And I guess it'll be easy enough to see once we're all looking at it again, but I cannot remember whether in this particular one that we were talking about, there was anything like the other speaker's handle or anything like that that would have been outside of the statement itself. So I guess when we get the link, we can look at that.
And Your Honor, I'm going to try initially to email, because Blaylock's Instagram is 28-page PDF. So I think that should be small enough to send via email.
Okay.
That email has been sent, Your Honor. I utilized the Zoom link email that Ms. Percival had sent. If anyone does not get it, please let me know.
Thank you.
Y'all, so while we have this little bit of a break, just gonna pop in to let everybody know who wasn't watching. Judge Whitaker heard arguments from the prosecution and the defense about keeping Detective Investigator Dennis barred from the trial. She has sustained her order. Dennis will not be returning to this trial. Y'all, you might underestimate how big of a deal this is, but this is a very big deal. This is a very big deal. And it is a very severe penalty. And not only that, but remember, the prosecution has been in trouble. Many of you would say not enough trouble, but they've been on the hot seat many times with Whitaker. They just faced a severe penalty. If you know, like I know,
All right, so it was at some point after the 293 one. It may have been the one directly after that.
I
Yeah.
believe we had the court's preliminary ruling of admissibility pending additional case law from defense ended on 344.
Right.
And so there's only, I believe, 5 PDF pages left for
Okay.
Blaylock. And so it will start in PDF page 13, Instagram page 359.
Right, but my preliminary ruling pending the additional case law is still a preliminary ruling. And
Yes, Your Honor.
so the conversation, if you will, that starts on
342.
342 and goes through 44?
Yes, Your Honor.
Okay, that's the one that it was only a preliminary ruling. And so the person whose true identity is unknown, is their handle Snake Life Maniac?
Yes, Your Honor.
Okay. All right. And did I understand your argument to be that the court could take into consideration in determining something outside of, if there's anything outside of the statement itself or the conversation itself that would indicate kind of a co-conspirator nature, that the court could and should take that into consideration?
Yes, Your Honor. And what the state's referencing in regards to that is the totality, specifically or almost exclusively from APD gang detectives, which started with Detective Belknap, the first witness in the trial, in terms of, like, for example, and there's also, they're discussing, someone references Pokey, which has come up periodically in this trial and is one of the individuals that Quindarius Zachary mentions was participated in the shooting of Miss Reed's home, right? When he's discussing Kenneth Copeland returning. And also when this Snake Life Maniac, when Blaylock, who's One King DO1, states he was stamped into the street gang by Pokey, the individual responds, he's been locked up a good 6 to 7 years. When did you get stamped? And he's kind of checking to see if that story checks out. And so the state's argument, and then it of course continues on, but and the Snake Life Maniac says, I never met the young rock crew. There's been a lot of testimony about
Right,
rock.
but if
Yes, Your
I'm,
Honor.
if I have to find something outside of the statement itself, then that would indicate, I think, that I can't take into consideration the contents of what this unknown person is saying to make that necessary determination, right? So,
The state's understanding and argument is that you can use, whether it's this statement itself alone, the court just has to find to a preponderance that this
well, we
individual
know
is
that the
a
statement
conspiracy.
alone can't establish the existence, or I'm sorry, the participation of the declarant in the conspiracy. I mean, that the statute itself provides that much information.
And I guess my argument, Your Honor, is the testimony in trial is in addition to the statement. As in, like, if you just had this in a vacuum and I presented no other evidence of why what they're saying is significant, if you didn't have APD gang detectives who've testified about what these indicate or mean.
So because we have outside of this statement testimony about pokey and testimony about how people get included in gangs and things like that. Is
Yes,
that
Your Honor.
your argument?
That's the
And
state's
in
argument.
addition to that, this person's handle itself indicating their connection to YSL.
Yes, Your Honor.
All right. Okay. A preponderance is really not that high of a standard burden to meet. So I am going to find that this one does meet that outside of the statement alone. So that entirety of that can come in. So we then need to move on to whatever was left. Is that right?
Yes, Your Honor.
Okay. All right. And so the next one would be on page 430, or are there some that y'all have?
359, Your Honor.
Oh, that's a different one? Yeah,
It's
I'm
a different
sorry.
one.
Yes. Okay. So 359.
So what's highlighted is Blaylock stating you have to pay the dues January 15th. That's the day you got stamped. And then the individual responds back, essentially like he will pay him when he sees him. The state, I will, because this conversation is so brief in terms of comparatively to the one before, the state will concede or not utilize 359.
Okay. So I'll withdraw that one.
But with yes, Your Honor,
Okay.
430.
Mhm.
So the individual that Blaylock is messaging, YSC Prince,
Mm-hmm.
he says he's leaving at YL up to you and me. YL is Young Loyalty. So when YSL, the criminal street gang, you have remnants of, Young Loyalty is essentially a subset of that. And so when he said he's going to leave YL up to me and you, he said when he gets out, it's still going to be YL, but we're going to take it over basically. Let's push up next weekend. The state wanted to include that because of direct reference to Young Loyalty and someone having to take it over. This would be in conjunction with, which I don't believe or do not recall, testimony thus forth in trial, as in through Detective Belknap, or will be when Detective Viverito testifies about Young Loyalty YL. But that was the state's request or argument in terms of this would have to be, the court would have to deem YSC Prince making that statement is in furtherance of the conspiracy to admit this as an exception to hearsay.
Okay. And you're saying we don't thus far have any evidence about YL or the meaning of YL? And are we going to get any?
Your Honor, yes, the state, I am drawing a blank if Detective Belknap addressed that when he first testified in this trial. I just do not recall as I'm sitting here. But if he had not, the state would proffer that Investigator Viverito would discuss that at a future date. I do not have any additional
And
evidence.
YL is, how is YL furthering this conspiracy? I'm not following your argument. I'm sorry.
So Young Loyalty YL is a part and parcel of YSL. It's like a subset. And so the state, by him saying we're going to take over specifically YL, that is trying to assert leadership over Young Life or Young Loyalty, Your Honor. So
That one seems a bit, I don't know, far afield.
understood, Your Honor. The state will
Okay,
not
I'm gonna-
utilize
all
430.
right.
And
Okay.
the last one, Your Honor,
Ms. Atkins, do you mind if Your Honor, can I just interject?
Sure, I mean, they're withdrawing it and or I'm excluding it,
Okay.
but, so do you need to?
No, I
Okay.
thought it was still up in the air.
All right, so 2145,
and Your Honor, the last thread of this nature is when you go to page 446, there's just one line where Blaylock is discussing, he says, "You're not slime." And on 447, they go back and
I don't see a 446, 447.
it is PDF page 15, Your Honor, and PDF
Okay.
page 16.
Okay.
And
sorry.
the key, the statement that the state is seeking to introduce is when Blaylock on page 447 states, "I stamped you in slime behind the blue house," talking about the, bringing that individual into the gang. The 446 is only included for brief context to that. The state would not necessarily have to use 446, but the argument is that when Blaylock states, "I stamped you in slime behind the blue house," to this individual, when they're going back and forth about if that individual is slime, that statement, the state believes there's two arguments for this statement in terms of Blaylock definitively stating that he brought this individual into a criminal street gang, and he references the blue house of just a specific location to remind him where he stamped him in. That statement is a co-conspirator statement, but in addition is a statement against interest. And the best example of why it's statement against interest is the case of this nature. Is, and if Blaylock was in this physical courtroom right now, that statement he made there is against his interest in terms of definitively asserting he has enough rank in a street gang to stamp someone in, and would be evidence that could be used against him in a criminal street gang or RICO predicated on a street gang trial. And so the reason that the state articulates that this is 801 D2E is because when he's telling someone, "I stamped you in slime behind the blue house," it's a conversation between, he's asserting in this statement that he brought this person in the gang. And so those kind of conversations, they have to be able to speak freely amongst each other, and they're discussing criminal street gang activity in terms of he's referencing when he brought him into the gang. And given the liberal standard of admissibility from Kemp and its follow-on cases, and that fostering cohesion, also, the direct reference to the exact criminal street gang conspiracy that the state is alleging they are a part of, feels that Blaylock's statement, "I stamped you in slime behind the blue house," should be admissible under either of those two bases, Your Honor, is the state's argument for why it's not hearsay.
All right. Why? I think that one passes muster. Yes, sir.
I believe that a statement against a penal interest, as articulated by the prosecutor, if it only goes to Mr. Blaylock, that we would get a limiting instruction.
I think it comes in as a co-conspirator exception. The "I stamped you in slime behind the blue house."
Okay, and understand the court's finding, then I would ask you to decide whether 24-8-805 hearsay within hearsay would apply, because I don't see the exception on the other end of the conversation. I don't see "I stamped you in The other person's statement is also 801 D2E.
The other person's statements, frankly, are GMFU and you not.
So how did
I mean, I don't
that conversation
think
further the
it
interest?
seems, I don't think it does, but I don't think those statements are being offered for their truth.
That is correct.
All right. All right, so what's the next one?
Your Honor, that, and correct me if I'm wrong, Ms. Bassi or Ms. D. Williams, but all of the remainder of this are conversations we have discussed that are pertaining to the February 23rd, 2019, the day of the murder itself, not gang co-conspirator statements. They're tethered to, they're ones we've discussed of no issues with. Unless
Okay.
defense counsel corrects me.
That's right?
Accurate.
Okay. All right, and so is that it for?
That's the entirety of Mr. Blaylock.
Ryan evidence. All right, and when are we, we discussed before about how we need to get to this kind of grouping of evidence before the end of this month. Is that going to happen?
Your Honor, there is yes, Your Honor, the state, we could reach this case today.
Okay. All right, sounds good then. And then how about the Mr. Arnold scheduling? Is that gotten nailed down? Okay.
So y'all, I was saying earlier that Judge Whitaker has kept Detective Dennis barred. I don't know if y'all got to see this. I'm going to show y'all this. I'm going to show y'all something from our video from yesterday. I'll probably put this on again during lunch as well. But y'all, check this out. Let me get past this commercial. So I don't know if y'all saw this video from yesterday, but I'm about to play this. Let me show y'all this.
Is 15 SC 138994. That is a.
So now we were all watching the Monk-Tunk status hearing or probation revocation hearing, I should say. We were watching this on, what was that, Friday? And if y'all remember, Andre, you'll remember this because we were watching this live together. If y'all remember the situation where it seemed like this lady here, she read a particularly troubling charge about Monk-Tunk. If y'all remember that, she read a particularly troubling charge about Monk-Tunk, which I'm about to play now. I want y'all to just take a listen to this. I do have the trial on. Again, y'all know I always have a second or even third monitor. So we got a nice little setup here. So I'll know when they're back. Y'all just watch this. Watch this. I made this video yesterday.
The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery.
I was saying, did she say 6 battery? I was hoping she said 6. I was hoping she said 6.
Aggravated sex battery, aggravated battery.
And we are back, and we are back. Go ahead and hit that like
By the
button,
way,
y'all.
hit the like
We have
button.
a very
the like
informative
button.
and eye-opening video today, and it's a short one, so you should be able to watch
I'm gonna
the
speed it up.
whole thing. Now, we all remember a couple of days ago, Monk Tonk was sentenced to prison. We all remember just how terrible it felt to see Monk Tonk locked up and about to go straight to prison to serve anywhere from maybe up to 5 years, probably less, but he had 5 years of his probation revoked right there before our very eyes, and we felt terrible for him. Now, part of having Monk Tonk sentenced to this 5 years was the reading of his rap sheet that happened right in court in front of everybody. I want you to take a moment. I want you to listen to this entire thing. Listen again. Okay. And you can see on your screen why I'm asking you to listen to this, because someone on Twitter, on X, BEA_L. I'm not going to try to pronounce it, but y'all need to go follow her. You can see her Twitter page on the screen here, BEA_L. She went and pulled up the actual charges. She pulled up the rap sheet. She pulled up the document, at least one of them that was referenced by the probation officer, and she found something very interesting. One of the most heinous crimes that the probation officer mentioned when she was telling Judge Whitaker about Monk Tonk's previous criminal history, one of those crimes is not how she said it. The way she mentioned it out of her mouth and the way it comes up on the rap sheet is two different things. So I want you to listen, watch and listen to everything she says first, and then we're going to come back.
All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
The
lucky.
DeKalb,
Since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry. He used his first offender. The second case, 04SC23883. That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all 3 times, he used his first offender. The next case is 15SC138994. That is a
All right, court is coming back, so we're going back to court now. Court is back, so we're going back to court.
Able to form the, and this is obviously hypothetical, but we need to sort it out. The sole overt act that a jury finds in support of guilt on count 1, the Rico count. So open up that argument. And I know y'all both wrote briefs, but if y'all can brief me, that would be helpful.
Your Honor, I think this was the state's argument for why that would be acceptable.
I think you're right. And it may be that, I don't know if anybody in court right now is ready to argue that, or if y'all need to call Mr. Armstrong back or somebody else from the DA's office. Okay. All right, why don't we take a recess while whomever's going to argue that for the state arrives, and we'll be back in a few minutes.
Dang, so they just came back to recess again immediately. All right, so someone here, let me see here. Yeah, y'all hit the like button, hit the like button. So Reginald Johnson, you said that it's on his document 4/28/2015. So the document that I saw yesterday, it's definitely not on that document. I'll see if I can pull it up. I will see if I can pull it up. So it's definitely not on the document that I was looking at yesterday. So Reginald, if you have a source to what you're talking about there, certainly want to pull that up. Thank you for that, Karen Jones. We do try to have a nice chat. We try to keep it nice and civil. You know, we try to keep it civil, funny, fun, even though we're watching a serious trial and things do get serious for sure. We try to keep it nice and civil in here. So Reginald, if you have a source for that, I definitely would appreciate it. Silver Creek, what's wrong with their mics? Sometimes they have a like on Law and Crime, they have the best microphone setup. And on the other channel, Fox and I think 11 Alive, something about their microphone setup, they have it only on one side. So like whenever I do a video, I have to dub the right side mic to the left side. So for some reason, I don't know, I think it's the same feed, but they almost always have it coming out on the audio only coming out on one side for some reason. He shot a gun and hit a woman's private part, and that was considered, yeah. So that is what someone said on X. They gave that explanation that he shot a gun. But wasn't the story that Monk Tunk was the driver? Wasn't the story that Monk Tunk was the driver? My understanding of that story was that Monk Tunk was the driver, that he wasn't the person who actually did the shooting, is my understanding. So I don't know about that part where, even the part where they're saying that it was Monk Tunk who did it. I'm not sure about that. See here, Andre. Yeah, the story, he drove and they charged him by association. Exactly. So even, it would be a huge stretch if you drive somebody to do a shooting, they do the shooting, you get charged with the shooting. I get that part. I totally get that part. If you drive somebody to do a shooting, they do the shooting, and then you get charged with that same shooting, that makes sense to me. If you drive someone to do a shooting, they do the shooting, and the bullet inadvertently hits somebody in a private area, and then you, the driver, get charged with an S battery, that doesn't make sense to me. That doesn't make sense to me. So I can certainly get getting charged with the shooting. I get getting charged with the battery, which the shooting is a battery. I get getting charged with any kind of result of the shooting, which might be someone dies or what have you. But I don't get if the reason you get charged with the S battery is because the bullet inadvertently touched somebody. I mean, come on, like nobody wants to go light on criminals, but we also want the charges to be reasonably connected to the actual act, right? So Monk Tunk needs to reach out to Miss Merchant office for assistance. There are people who have been saying that she probably couldn't represent him because she already represents another co-defendant in this trial. I'm not sure exactly how that would work, but also remember, Derek Wright said Monk Tunk didn't really have a lot of money. So I'm not sure I don't know what his pockets are looking like to be able to afford Miss Merchant or anybody else for that matter. If it's not for the truth, why do courts allow it in? Again, I guess you're talking about, are you talking about the charges or what have you? On the sheet that I saw, Monk Tunk's, the aggravated S battery was not there. So I'm going to pull this up. Since we have a little bit of a break on court. I'm going to pull this up so y'all can see it. People are really doing some really interesting work. Okay, let me share this tab here. All right, I'm going to make it bigger. Let me make it bigger so we can see it. Okay, so this is state of now. Might there have been some kind of change to this after the fact? Mr. Reginald, you mentioned, and I haven't kept up 100% with the chat, but you mentioned that it is on the charging document. This is 15 SC 138994, which she was referring to, the probation officer was referring to. Now, again, might this have been updated later? I know she was talking about something, but on this document, you have participation, you have aggravated battery, aggravated assault, aggravated assault, aggravated assault, criminal damage to property. So that would probably be the bullet holes, criminal damage to property, possession of firearm by in the commission of during the commission of a felony, participation in a criminal street gang, aggravated assault, criminal damage to property, and then possession of firearm, arm, or knife. So this is the document that that this person came up with. We want to give her, I believe this is a woman, want to give her credit. So this is the document she came up with. So we're basically just taking it for what it is. I think everybody, you're kind of working on a good faith system in a sense. So as you can see on this document, this looks like it is a plea, a negotiated plea deal document, and it does not mention the S battery. Okay, it does not mention the S battery. So is there an S battery out there somewhere? I don't know. You know what I mean? This is why I'm bringing it to the people. I'm certainly not trying to be provocative. I'm just trying to put the information out there on the platform and see what the people have to say. All right. So that's the purpose of bringing this up. Some people did comment on this. I brought this to people's attention yesterday. Hopefully that helped this lady get some additional comments. Some people did mention, one person did mention that the reason for the S battery was because the bullet had touched Miss Denise Bell's, I think it hit her in the back and came out the front. That's terrible, by the way, y'all. So, I certainly do not want to seem, I don't want to make light of that. It sounds like a just life-changing situation. I know this was 10 years ago, but it sounds very traumatic. But again, do we want to mischarge people on their criminal in the indictment just because we can? I don't know. So Reginald said he had seen it somewhere, or that it was somewhere. I'm not sure exactly where it was. So I do thank anybody who wants to donate, who wants to purchase a membership, who wants to give a super chat or a super sticker. As a matter of fact, I'm going to show you exactly how you can make that happen. Let me I need to pull up our stream on another screen, and I'm going to show you exactly how you can do it. So what do y'all think about that? I mean, now we don't know how much that really affected. We don't know how much that affected we don't know how much that affected Judge Whitaker's decision. So we don't know that. All right, y'all, check it out. Down here beside the chat. If you want to donate, if you want to purchase any kind of super chat or what have you, just click the dollar sign, and then you can decide what you want to do. We certainly do appreciate any kind of support y'all want to provide to the channel. So what do y'all think about that? I personally think that, and I'm very hesitant and try to be careful criticizing people that I don't know. But I can say if I were in Monk Tunk's shoes, this is what I imagine would have happened. If I were in Monk Tunk's shoes, this is what I would imagine I would have done. I would have either come into court with a different lawyer, because honestly, I think there are any number of lawyers out there in Georgia who would have represented him for free or for a low cost in this hearing because of the notoriety. So I would have either come in with a different lawyer. Papa Bear, please direct me to that. I'll at least put it in the description and in the comments, and do a pinned comment on that video so people can see it, because I like people to have all the information. So I would have either come in with a different lawyer who would have argued that my previous counsel did not give me effective counsel, and that whatever sentence or whatever penalty I incur should be significantly reduced as a result of that. That would have been one. Or I would have made sure with my current counsel that he was going to go in and say that I did not give him the best counsel, that something went wrong, and he was going to take a significant part of the blame. So however you slice it, I'm putting a lot of the blame on him. Either he's going to do it himself, and we know that going in, or if he's not okay with that, I'm getting somebody else who's going to do that, and they're going to put the blame on him. Okay? Georgia Department of Correction. Can you just, there's no way to just post the link here? Search his name. Okay, I'll take a look. Georgia Department of Correction. I'll take a look. Georgia Department of Corrections. So find an offender. Am I selecting find an? I guess it'll be an offender. Find an offender. That have to be an offender. Is that okay? So we're gonna do it now, y'all. Let's take a look. Let's do it. Sledge. Let's take a look. Hold up 1 second. Antonio. All right, so we can go with, I guess, the aggravated battery. Am I in the right place? Oh man, this guy was born in 1981, y'all. So he's what, 43 already? Am I in the right place? Let's see. I'm gonna just do a Control F. Okay, here we go. Yep, that is right. But you know what? It looks like this is a different case number than the one she gave. That's the thing. She gave a particular case number for this, and then it turned out that this case number is different from the case number she gave, is what it appears to be. That's what appears to have happened. So it's not that the information is wrong, as in the document that we looked at, this document here, this document has the criminal action number. I'm not really sure, to be honest, how that lines up with the case number. So that may be part of the confusion, where he has a particular case number here, and on this document, he has this criminal action number. Is there any case number here? Let me see. But don't all of these stem from that same? All of these seem to stem from that same situation on April 28th, though. 2015. So it's weird that you would have two different lineups. It's like two different lists, if that makes sense. All right, Karen Jones says, I'm not a fan of what he did in 2004. However, people grow up and it appears he has tried to turn it around. Is that Kla or Kia? Okay, it comes out different when I put it up here. He was used as an example, but God not sleeping, he going overcome this. Yeah, so some people were saying that they thought that she was sending a message with Monk Tonk. I will be honest, y'all. It is a very confusing message because she certainly has not, in my opinion, given any indication from what I've seen that she thinks that the defendants are guilty. Let's say this again. She hasn't given me any indication that she thinks that the defendants are guilty. She certainly has given an indication that she thinks this is a legitimate trial and that she thinks that it should go forward. All right.
Yeah.
Back.
It's Miss Love. I'm just trying to get her ETA, Your Honor.
Okay.
Oh, Miss
All
Love
right.
coming
So
back.
in the meantime, do we still need to sort out anything about the evidence that's going to come in with Wooney Lee? Because I see that witness is on our list for this week.
I thought we discussed everything that was in his folder, Your Honor.
Making sure.
I didn't know that we had gone through all of his Instagram posts. I don't know that all of it will be relevant, although it depends on what he says on the stand. I don't know if the state would agree or disagree with that.
Sure. Just want to sort out what we can while we've got time beforehand and not have the jury waiting, because Lord knows they have to wait on us enough as it is. All day today we're waiting on them.
You got it. You got it. Yeah. A lot of people didn't like the way she said, I hope this doesn't set you back. That really got to a lot of people. I think seeing Monk Tonk locked up there in front of your eyes, I think that was a part of it. I think the fact she said 5, if she had said 30, it would have just been pandemonium. If she had said 20 or 15, it probably would have been pandemonium. My take on it, I said 5 was the lowest amount of a lot of time. Anything under 5 could have been considered, people might have said it's unjust, but it wouldn't have been like a lot. 5 was the least amount of a lot. So I think when she said 5, that also was like, dang, man, 5 is if she had said 18 months, I don't think there would have been the same outcry, because people would have said, well, he'll be out in 9 months. He'll be out for the summer next year. But I think 5 was like, it seemed like it crossed the boundary of whatever. If you would say there's something reasonable, I think the feeling was 5 was over that. He'll do 2.5. Yeah, I think that the consensus is he'll be out in under 3 years with decent behavior. That's still, though, for a 43-year-old man. I mean, he has a family to support, y'all. I mean, again, I'm not so much arguing in his behalf, y'all. You know, I'm more looking at it from perspective of how much time is, let's say, 2 to 3 years for a 43-year-old man. That's a lot of time. You have responsibilities. You're going to be in prison. They have to take care of you, basically, send you money, worry about you, you know, worry about whether people are going to do something to you. And you really can't do much from prison to support your family. Yeah, being incarcerated
Where'd Misty Williams go?
100% sets you back. But you know, and y'all might get upset with me because I know a lot of people will disagree with this, but one thing I definitely want to do is be known for speaking my true opinion. I think she really meant that, y'all. I mean, this is the strange thing about Judge Whitaker to me, is like, I think on the one hand, she really did hope it didn't set him back, even though we can all say it's kind of a not very compassionate thing to say at that moment, particularly because there's probably nothing, I don't know, but I imagine there's nothing she's going to do to help him while he's incarcerated. So it's kind of like just words. Like if she said, listen, I'm going to help make sure this won't set you back. So I'm going to sign you up for this program. I'm going to sign you up for that program. I'm going to make sure your family has this. And that would be like, okay, well, she's trying to, you know, she's doing what she thinks is just from the perspective of the trial, but she's also trying to help this man out. If it had been like that, then it would have been okay. But it's kind of like just words. I'm going to give you 5 years. Hopefully it doesn't set you back. That's how people heard it. You know? Yeah, and you know, and then you got the snitch angle. Now, I've said this many times, and I'm gonna keep saying it. I don't talk the snitch stuff. I don't talk snitch talk. I'm, you know, thankfully have never been involved in any kind of criminal life. So I don't talk the snitch talk, but I get it. I do get it, you know, and I totally get it. So trust me, you know. I get where people are coming from with that. One thing I did say on the original stream, that paper that he signed, that hurts his friends, y'all. And I'm calling everybody on trial his friends, even though I don't know the status of their relationship. But that was a tough paper, y'all. That was a tough paper. When I say the paper, I'm talking about those factual acknowledgments that he started to walk back during the trial. But he did sign that paper and he verbally agreed to that. And, you know, he was basically saying, I have personal knowledge of a lot of stuff. And frankly, if what he said was true, then this trial is over. I mean, like, let's be real. If the jury believes Monk Tunk, then then the trial is over effectively. So from the snitch angle, again, that's not my thing. I'm not getting into that. But what I will say is that paper was tough. That paper was tough, yo. That paper was tough. So, you know, it did feel like he was trying to blunt or reduce the impact of the paper. When I say paper, I'm talking about the factual acknowledgement. So it's just easier to say paper. It did feel like he was trying to blunt the impact of the paper. It did feel like he was saying, hey, hold up now. I don't want to say that. But that was a tough paper, y'all. So let's keep it real on that one. And for the people who live that life, and let's be, Monton was in videos with guns, y'all. He was holding up guns on, you know, Instagram or what have you, like he was real. He was out there in the streets. He was like a real street cat. So, you know, you do have to think about that. You do have to think about the fact that he wasn't no spring chicken. He wasn't like, he wasn't 17 and just got out there and somebody caught him up and they scared him. When he agreed to that, he was already a 41, 42-year-old man who had been out there probably his whole life. So, but then you have the other side. This is what I always think about with the snitch thing, y'all. This is what I always don't get. People say snitching is wrong, snitching is bad from the street code. Okay, I get that. But they also say you can never rehabilitate yourself once you tell. My thing is this. If you can't rehabilitate yourself, then what's the incentive somebody has to, after they've told, what's the incentive they have to try to walk that back or to try to make it right? Like, to me, I get why you say you can never rehabilitate yourself because you want to prevent people from taking that route in the first place. But what about the people who already took that route who then want to try to make it right with the people they told on, or who they told during a plea hearing, but they still have to go to trial? Doesn't it seem like it's in the interest of the street cats to say, okay, well, if you go to trial and you don't cooperate, it's not as bad. You know what I mean? It seems like you want to give them some incentive to not go all the way, if you will. So I don't know. That's one of the things I don't get, but that's not my life. I agree the judge meant it nicely. It made me mad, but she was not warm and fuzzy, so it comes off bad. It showed revocation based on trial. But yeah, so I Whitaker is not. She is not a very affectionate person from the bench. But I just get a sense that she, y'all, don't we want judges who are impartial? Isn't that what we want? Don't we want judges to apply the law who just take the law into account? You know what I'm saying? And while I do think she went too hard on him, y'all, she had to do something. I hate y'all. Y'all are gonna be upset with me for saying that. She had to do something, because if she did nothing, then the next person who comes up to take the stand, who has a deal, could say, "Oh yeah." So really, my thing is more like the 5 seems harsh. The 5 seems harsh. He's 40 something. Anytime you give him in prison is probably going to come down on him like a pile of bricks. So if you gave him 2 years and he going to wind up serving 11 months or something, that's going to hit him hard. That's going to hit him hard. So the 5 seemed tough, but the idea that she would just say, don't do that again. Nah, that wasn't possible. That was not possible. It was impossible that she was just going to wag her finger at him and let him walk out of there. She would have made her entire courtroom a joke. She would have made her entire court and this entire trial into a literal joke if she hadn't done something. Now, I think it's the amount she gave him more so than the fact that she gave him something. Okay. Ocean Beach. This shows the fallout when the prosecution bases their weak case on forced immunity. Yes. So, but you know what, Ocean Beach, our entire system is built on this. So again, Judge Whitaker, she's not, y'all should have seen this by now. She's not the trendsetter. She's not the boat rocker. She's not the innovator, the judicial innovator from the bench. She's not the person who's going to say, I dislike the way the system works, forced immunity, so therefore I'm going to make a statement. That's not her style. We can't be upset with her for that. She's just doing things the way that judges have done them for years. She's following the book. She's just being a normal judge. If she had said, I'm going to make an example of this, I'm not going to give Monk Tunk any time because they shouldn't have forced this immunity on him in the first place, that would have been like, it would have been literally an earthquake in her career. In the grand scheme of things, it might not have mattered. But in her own career, she would have been taking a stance. Okay, she would have been making a statement about who she is as a jurist, as a judge. She would have been saying, I am the type of judge who wants to correct a broken system with my courtroom. We have no indication. We have seen nothing from Whitaker that's her style. That's her style. I think Love put her in a position exactly. Whitaker is forcing points of law. Correct. But that's what all judges do. Because remember, judges do not charge. They don't charge the defendants. The prosecutors do that. So all judges are in a position to referee the game that the prosecution called. The prosecution gets to point out who they want to get into a competition with, what the rules are, not all of the rules, but the severity of the consequences to the competition. The prosecution get to call the game, and they get to say what's on the line for only for the defendant, because the prosecution kind of doesn't have very much on the line except for maybe reputational damage, you know. So, but the defendant has their very life on the line a lot of times. So Whitaker has not shown us that she's going to use her courtroom to steer the judicial system in a particular direction. Okay? Y'all got it? So that is why we have not seen Whitaker doing more to the prosecution. That is why it took 2.5 months of constant problems for her to finally sanction the prosecution. And if you notice, she didn't sanction the prosecution so much as she sanctioned Detective Dennis. It just so happened that he was a prosecution witness. So she was more upset at him than she was at the prosecution. Okay? So Judge Whitaker is not a wave maker. She is a relatively conservative. When I say conservative, I don't mean politically. I mean the way she's running her courtroom. She's a relatively conservative judge who follows the law in a pretty rote manner, actually. And that's what people want. That's what people want. Okay? Y'all, if you want to become a member, work around for your iPhone. They make it difficult, but Miss Lily got you. Open your web browser, go to youtube.com. So you have to go outside of the app. Then you search for us on the channel icon, tap. You got to go to the tap. Is that AA request desktop? You will see the join membership. Y'all, come on, become a member. You get access to all of our lovely, I'm about to show y'all all of these lovely emojis we have. Wendell Taylor says, why is it Whitaker isn't calling a mistrial? Whitaker has not called a mistrial as of now because, in my opinion, and I mean, this is all opinion based, she wants this trial to go to a jury verdict. Her preference is that the trial goes to a jury verdict. And nothing has happened as of now that would give her an ironclad reason to call a mistrial. I'm gonna give y'all an example. I'm gonna just give you, I like speaking in examples and analogies and stuff. Let's say you have a kid, and let's say that when I was a kid, the worst punishment I would get would be go to your room. You have to stay in your room. You can't watch TV. You can't go outside. You can't play video games. You have to stay in your room all day, every day. You can only come out to go to school, use the bathroom, and eat dinner. And other than that, you cannot come out your room. And I got that punishment for up to 2 weeks sometimes. So that was like the nuclear bomb punishment. Room with nothing else. That was literally when I started reading books, because I found some books in my room. And I couldn't do anything else. I was like, might as well start reading. You know, I was probably like 10 or something, 9, 10, something like that. So I just started reading, and that's helped produce the man that you have before you today. But that was like the nuclear bomb punishment. So imagine there are different ways I can get this punishment, but that's the worst punishment for me. But imagine there are different ways I can get it. So I need to go to bed on time, blah, blah, blah. So one day my dad catches me out of bed. I'm not in bed by my bedtime, and I have an excuse. Oh, well, that's because mommy told me that if I feel bad in the middle of the night, I should go drink some soda and then make my stomach. It's like, he's like, okay, I almost got you. I saw you weren't in bed on time, but okay, you had an excuse. Okay. Then the next time is, oh, I thought I heard a mouse, and I know we got a mouse problem. So I was going to check the trap to make sure it didn't get away. And he's like, almost. So like every time I get caught doing something, I have this really good excuse. That's what the prosecution's doing. Now, I know y'all going to say, well, they don't have a really good excuse. That's not the point. In Whitaker's eyes, they have enough of an excuse to avoid the penalty, the nuclear bomb penalty, which is the mistrial. So that's why last week when Doug Weinstein said, Your Honor, there's no fixing this one, there's no getting around this one, he thought at that moment that was the time that they caught the prosecution in a nuclear bomb scenario where there was nothing that they could say to avoid the mistrial. But to Hilton's credit, it was actually a layup. It was actually a layup to avoid the mistrial. Avoiding the mistrial was a layup. All she had to say, which is what she did, was, Your Honor, Diamante Kendrick is a felon. We charged him with felon in possession of a handgun. That was coming out either way. Morning, hold me tighter. Welcome. That was coming out either way, Your Honor. So, and that was what neutralized the mistrial. That was what neutralized it. There was going to be a mistrial because Detective Dennis had testified to Kendrick's previous criminal history. Doug Weinstein said the jury cannot unhear it. The jury cannot unhear that, and he was right. But Hilton, as she should have, said, Your Honor, when she came back with her case law, which probably didn't matter as much, she came back, she said, Your Honor, they were going to hear that anyway, because on the indictment, he's charged as a felon. So the jury already knows he's been to prison. And Your Honor was like, that's what saved you from the mistrial. Andre says still isn't cured. Andre, they banned Detective Dennis from the trial. He's one of the 2 lead investigators for all of the evidence. He can't come back. So is it cured? I don't know. I mean, that's a difficult question. But did they suffer an immense, not quite nuclear bomb, but like a serious penalty? Yes. And don't forget, now the next level of penalty is there's only 2 things higher than what happened. Disqualify a prosecutor, which would not have been appropriate in that case because the prosecutor didn't do anything wrong, or mistrial. From what I can see, there's only 2 more things that can be more severe than this: disqualify 1 or more prosecutors or mistrial. So I think it was serious. And allowed, and Andre says, and then they allowed the 4th gang expert to replace him. Yes. What's she gonna say? Nobody can testify to that, though. If the lady is qualified to testify to that, then there's really no way to stop it. I heard Doug Weinstein do an interview Friday. He feels like he made a mistake by saying prosecution didn't. Yeah, I agree. I saw that interview as well, and he did make a mistake. He was being nice. He was being cordial. So from an interpersonal relationship standpoint, he didn't. He did the right thing. From a, I know y'all didn't do it on purpose from that, but from a strategic standpoint as it relates to the trial, yeah, he definitely did make a mistake by conceding that point. I agree. One of the big reasons is y'all have to understand, in order to get a mistrial with prejudice, the defense needs to show that the prosecution did something or did certain things such that they were trying to provoke or goad the defense into requesting the mistrial. The prosecution was purposefully messing up because they wanted the defense to ask for a mistrial. That is the standard for the defense getting a mistrial. So when Doug Weinstein says, I know she didn't do it on purpose, he kind of takes the whole mistrial off the table, because he needs to argue she's goading him, but you can't goad somebody and all at the same time not do it on purpose. Okay, so basically that was a mistake. I know he was in the heat of the moment. He said it. I hadn't thought of that until I heard him say it, but yes, he did say that. What testimony and evidence did he bring in that day? Because that got yeeted along with his sorry, but he was. I think he was just getting started that day. He was. A good part of the day was spent either showing the fight in Magic City Strip Club and defending himself as to his expert credentials. So he had shown the strip club. I think that's barred at this point. I don't think anybody else can talk about that. I think that's barred. And you know what? Let's go back. Let's watch this. On this morning.
So
I have the trial here. So when we're back,
Good day, Your Honor. Good day, everyone.
good morning.
So I understand your ruling, obviously abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us.
I don't think that if you can get is meritorious. I think that the arguments that the state made after that they were waived, because they certainly were not made at the point in time when I could have done something about it. But in addition, the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony, and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, it seems like this whole issue is moot. You may be.
May it please the court, Kevin Armstrong for the state. First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor referred to, is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's
all right, y'all, we're back. So we'll have to, that's the court's audio that's not on, by the way. It's not my audio. We'll have to come back around to that later. But yeah, you have the strip club fight. Court's audio is off for some reason. Double check my other feed just to make sure. Yeah. Oh, there's your favorite lady. There's your favorite lady who's back. Guess who's back? Back again. Y'all favorite DA with the coral blazer or the coral jacket on. ready to make all of your DA dreams come true. DA, as the lead attorney says, love. DA Love is back, y'all. So congratulations. I know y'all missed her. No sound is on in the courtroom, y'all. Okay, so don't freak out. It's not me. Oh, shoot. Heck. There's no sound on in the court. Y'all, there's no sound in the court. Okay, so I know people are probably like, what's going on? It is not me. It's the court. I have a different feed on. I have Fox on. I'm watching on my laptop in front of me. People are freaking out, asking why there's no sound. As a matter of fact, check it out. See if we can grab the comments too on Law and Crime. See, they're saying no sound. We can't hear. So it's not me. It's not just Law and Crime. It's Fox. I guess it's probably all the feeds. No sound. All right. So we just got to wait for them to. Are they going on another break? All right. Well, I guess it doesn't matter that there's no sound because they're going on another break. All right. So, again, I don't know what that's all about, but I guess it doesn't matter if you don't have sound if you're on break again. So, while we're on break, let's go back to what we were watching. I'm going to try to skip forward to where Hilton mentioned what Hilton had mentioned what was going
to get in through Detective Dennis. And so essentially it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective
This is
not
for you, Amy.
testifying to, because
Celeste.
she got was qualified to be able to testify to the meaning or her opinion as to the meaning.
So, Amy, this is to answer your question. Hilton's about to say the 3 things that Dennis that they're missing out on by not having Dennis.
Of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
Thank you, Your Honor. Detective Dennis testified to a statement regarding defendant Kendrick, in which investigator Underwood was not present for that interview, and so he testified to that. He also testified further regarding the Quindarius Zachary interview, in which investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through investigator Underwood. And I believe those are the 3 primary things that investigator Dennis was able to testify to previously that was struck that investigator Underwood would not be able.
Okay, so there you have it. You have a statement by Kendrick. You have I guess a part of an interview with QZ, and you have the Magic City stuff. By the way, y'all, court is like particularly, I don't know what's going on this morning, dysfunctional. There's no sound. We're supposed to well, I guess these aren't asides. These are breaks. What is this, the 3rd break we've taken already in the first 2 hours? They've been out of court more than they've been in court this morning. Y'all do hit the like button. Let me go ahead and spam my likes here. Hit the like button, please. If you are not a subscriber, do go ahead and subscribe. This is a labor of love, y'all, trying to build a community so that not only will we have a good community for this trial, but that we'll have a community going forward. Okay? So let me just go live. I see somebody's head popping around here. Remember, hit the ball, poor Lauren debacle. Judge denied mistrial because she did believe issues due to incompetence. Yes, I do remember that. That was the excoriation. That was the dressing down. That was the complete insultation of Miss Love, not only as a lawyer, but as a just competent human as it relates to keeping yourself organized. I do remember that. And this is where y'all. This is why the Monton situation, not Monton, excuse me. This is why the Detective Dennis situation also feels so significant. And this goes to you, Andre. When I say this goes to you, I think you felt like what she didn't go far enough. And maybe it didn't. Maybe you won't be convinced of that, but I'm gonna tell you something. She, by excluding Dennis, she stepped. So first there were threats. Now there's action, and that action is, I think most people would consider it, if not severe, then it's significant. If she has to do more, everything she has to do from a judicial order standpoint as a result of prosecutorial or prosecutor witness standpoint, everything raises the bar. So we're not just talking about the potential for appeal and all that stuff. We're talking about getting fed up. And if you know, like I know, every 7 to 10 days, something's going to happen on the prosecutor side. You can bank on it. Every 7 to 10 days, there's going to be something on the prosecution side that merits a verbal response from Judge Whitaker. Every 7 to 10 days in court, Judge Whitaker is going to have to comment on something that the prosecution did wrong. And I'm including in this Detective Dennis, who was a prosecution witness, who was a seasoned detective. He wasn't no rookie. He wasn't no new guy. He wasn't new on the block. So I'm including that in this. So I would say Detective Dennis' situation happened, Thursday? So Thursday of last week, sometime before the end of this month, I will predict there will be something else that Judge Whitaker will have to verbally address with the prosecution. Will it be a big thing? Will it be a little thing? I don't know. Okay. It could be just y'all still not ready. You still haven't done this. It could be that. Even that is kind of big when you add it all up. Okay. Will it be a big thing? Will it be a little? But my prediction is sometime before the end of the month, which we have approximately, including today, we have about 9 business days. So sometime before the end of this month, Judge Whitaker is going to be forced or compelled to say something else to the prosecution about something. Okay. And with that being the case, her having done this with Dennis is going to be like, I already went to this extent and there's still problems. You know what I'm saying? I already went to this extent and there's still problems. Andre, let's see what you said. I know what you mean, though. I get you. I agree. But whenever she goes hard, she kind of back. Yes, she does backpedal. Or she softens her tone. I agree with that. I also know the feeling. Again, I don't know the feeling of being a judge in this sense, but I know the feeling of just trying to stay composed. So I take it that Judge Whitaker is just trying to not do anything out of frustration or anything out of exasperation. So that's why I don't necessarily think that the next thing or the thing after is going to result in a mistrial. But I think that there will be something else. If not this week, then next week. Do hit the like button, y'all, please. Judge never allows a prosecution. But Andre, the thing with Dennis is a huge loss. They just took that L the day before yesterday, and she reaffirmed it today. She didn't back up. So Andre, let's just give her. I mean, again, if we're gonna give her credit, as spectators, you gotta give her credit. They came at her that day. Judge, would you please reconsider? No. They filed a motion and followed up with that today, and she said no. She could have backpedaled, but she didn't. She could have reduced it. Okay, well, I'll have a meeting with him to see. She didn't do any of that. She just said no. I stand by my ruling. Everything I said is what it is. So she did not give an inch. She didn't give a centimeter. Again, I'm not here to defend Judge Whitaker. I'm just trying to call it the way I see it. Okay. I'm just trying to call it the way I see it. Every other time, yes, she did backpedal. She did bring it down, bring the heat down, et cetera, et cetera. But this time, she didn't backpedal at all. And I'm happy to see it because I do think there have to be consequences. Queen says if she is at the point of being fed up, she needs to keep that energy. The next state screw up needs to be met with the same level of fed up. The good thing, okay. When she went off on DA Love, if she had called a mistrial, it wouldn't have looked good. Because it would have seemed emotional. So I agree with you, Queen. If she can give her ruling in a measured but significant way, I totally agree. The energy she gave Love when she kirked out on her, again, that's kind of like a DC area word. I don't know if y'all use that, but it just means go off on somebody. When she kirked out on DA Love, if she had called a mistrial right there, that wouldn't have looked good on her at all, on Whitaker. That would have looked very bad on Whitaker as a judge. Because you certainly don't want to appear like the person who's going to fly off the handle and just tank a trial. So while I agree with you on keep the same energy, the energy was the Dennis energy. That was inappropriate. That has no place in my court. I would like to bring him in here in front of the jury if I could and let him know that that's wrong. And because of that, this, and this. If she had done, Dennis shouldn't have done that, blah, 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 that's not the energy. So as long as you and I agree on that, I agree with you on that. Ocean Beach, Ramatullah, in bringing in Fort Whitney is a rare exception that prosecution did good lord and they figured out a way to fix Dennis. I agree that they attempted. Y'all, there's no way to fix Dennis because you got to think about the jury. The only thing we don't know, the biggest X factor that we don't know is how the jury, of course, we don't know how they are viewing this. So that's an X factor we all know that we don't know. But the X factor we don't know is that maybe we don't think about as much is how much is the jury really sticking to the rules? Everybody's talked about this. So we've thought about it, but most people just assume, oh, the jury knows this. We don't know what the jury really knows and what they don't know. Many people say, oh man, the jury probably, I'll tell you what, this stuff is on the news. I'll tell you what. The jury, I bet we're going to find out that the jury doesn't know a lot of stuff because these people are probably tired of thinking about this trial by the time they get home. I don't think that the jury, definitely not 12 people, want to go home after being in court all day and then sit down and go on social media and worry about this trial. Maybe some of them do, but some of them are like, yo, don't even talk to me about that. Like, I want to act like this trial doesn't exist until I have to go back to court. So I don't think that the jury necessarily has the same level of interest in knowing all of the details of what happened while they were out of the room. The first few days, you would want to know, what happened? They've been going at this like a year. They don't care anymore, a lot of them. I'm sure of it. I'm sure that when they went out of the room, they might have been curious at that moment, but by the time they get home, they don't want to investigate this. They don't want anybody calling them, talking about this. There just has to be a few jurors who just like, don't even talk to me about this case. So plus you're not supposed to anyway. So no, don't talk to me about that. I want to go home and watch my grandkids, or I want to go home and whatever. So what I'm saying is a lot of these jurors probably just whatever they saw happen. They saw that Dennis made a statement. They saw court get called. They know something was wrong. When they came back, he wasn't there anymore. And the judge made a comment about Dennis. So they know he did something wrong. Now they bring in somebody new to basically try to do what Dennis just did, but to do it right. How is that playing with them? We have no clue. They aren't even supposed to talk to each other about this stuff. Like when they go to the jury room, they're not even supposed to say, what do you think happened? So basically, we have no idea. It's impossible for anybody in our position to consider or imagine what it's like to be a juror. We have no idea. And that's the huge X factor that I'm sure we all have thought about. But the point is, we've only thought about it. Most people have only talked about it from, I know the juror knows this, or they're probably curious. We have no idea what they know and what they don't know. We have no idea how curious they are. We have no idea if they're sticking to the rules or not. We have no idea of anything. So it's hard to know how important anything that has happened really is, because they're the ones who are going to be making the decision. In normal court trials, what I've seen, if you mess up, that's it, basically not bending over backwards. Well, yeah, we saw that in a Rush trial. That judge wasn't playing no games. She was like, Brady violation, trial is over. Forget it. It's done. Prosecutors are going to try and get everything in with a new witness. I think people are upset with the prosecution. Some of the stuff people are upset about you just shouldn't be upset about, in my opinion, because it's just what you would expect. I would expect them to try to get the same testimony in with a different witness. Why not? People are upset the prosecution wants to use lyrics against the artist. How can you be upset about that? I mean, of course they do. I've been saying, I commented on this last week. As long as they are ethical, as long as they have a good faith belief that the lyrics have something to do with particular crimes or whatever, of course they should be able to use it. People say no. I disagree with that. You should be able to bring lyrics into a trial if there is a good faith-based belief and reason that such lyrics have to do with a particular crime. When I first heard about the concept, I was like, oh, that doesn't sound right. But when you think about it, of course, you should be able to bring artistic expression into a trial against a defendant if that artistic expression has a reasonable connection, or apparently has a reasonable connection to a real crime in the world. I mean, how could we say your artistic expression is going to be excluded? That doesn't make sense to me. I mean, it did when I first heard about it, but the more I think about it, of course, you have to be able to let that stuff in. Reginald Johnson, I kind of lost respect for this judge for not standing like everyone else when the judge enters the courtroom. Oh, the jurors? Oh, that's an interesting take. I'm going to pay more attention to that. Bro, you have to be I guess the most objective person on it. Y'all, I'm trying to be objective. I have my biases. I have my opinions. A lot of people are going to strongly disagree with me on the lyrics thing, but I think I can articulate it. I articulated it last week. Like I was in chat with somebody and I was saying, look, if I'm a painter, somebody comes to my house, I commit a crime against them, they're laying on the floor, and I paint that painting. I paint a painting of the person on the floor. Then the police come, they find the person on the floor, they find a painting that I painted. Are we going to say, you can't use that against them in trial because it's artistic expression. No, heck yeah, they're gonna bring that painting to trial. They're gonna be like, we found the person on the floor. We believe he did it. And we also found this painting of the person on the floor. Of course, they're going to bring that in. Of course, 100%. And they should be able to bring it in my opinion. Now, that's not proof that I did it. I also said this last week. It's not proof that I did it. I could have just found that person and just saw him. I thought, hey, that'd make a good painting. That doesn't mean I did it, but it's evidence I did it. It's evidence. It's not proof, but it is evidence. And of course, they're going to bring it. Ocean Beach. Whitaker is going to say things because they consistently show poor lawyering. She takes exception to that and rebukes. Of course, yes. That's why I said Whitaker is a relatively conservative, not politically speaking, but her judicial style is relatively conservative. Paralegal, after she came back from calming down, she still could have called it. I agree with that, but I think a better sanction at that moment probably would have been like what we just saw right now, or what we saw with Dennis. You can't use that exhibit, move on from that question, whatever the case may be. You're barred from continuing with this, whatever that case may be. I think that would have been better. But yes, it seems like after all that, Queen, she should have done something substantive. I totally agree. Okay, I'm objective. I do try to be objective, y'all. I am a relatively objective person, I think. At least I try to be, even in my private life or personal life. Jamie says the jury is over it. That was my point of saying they probably don't go home and check all of the most recent happenings. They were there. They saw what they saw. Once they get home, they probably aren't. I don't know if there aren't a few of them, but I imagine they turn that off until tomorrow, or whenever. I agree with you in a way, which you're saying her reasons for composing herself when ruling. She needs to keep that fed up energy. I agree with that. So this is one of the problems with her not having been. Y'all, I'll tell y'all what, if she had been on this trial from day one, this trial would have been over. If you line up almost everything that's happened, which is impossible because Glanville, his style directed the trial in different directions. She would have made different rulings. Different things would have happened. But if you could imbue Judge Whitaker, just somehow give her all of the emotions, the ups, the downs, the fed upness and blah, 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 that she would have had if she had been here the whole time, she would have called this trial by now, period. I mean, that's my take, because she was able to start testimony, I think it was beginning of August, so 2.5 months ago, with a fresh, she didn't have all of the exasperation and the emotions and the ups and downs that she would have had if she had been on it since January or November. So the prosecution kind of got a do-over in a sense. That's why we went back and did this mistrial miniseries, because it really does document how many times the defense has said this should be the end of the trial. And a lot of those were before Judge Whitaker was even on the stand. So she didn't get that buildup that would have been there, Queen. She didn't experience that. And she even kind of said when she took over the case, she kind of indicated yeah, that's over. That's the past. So we aren't going back. And it's like the prosecution kind of got a do-over. So whatever happened between, let's say, January and August, they got a do-over with Paige. So now they're building up that steam again. And that doesn't seem fair. Bruce Harvey talked about that a lot, but it is what it is. Wendell, the jury hasn't been honest. Remember, the judge asked the jury if anyone had a problem with erasing things out of their minds for the record. I agree with that. I mean, I don't want to say they haven't been honest, but I would say I agree with you 100% on the second part. Our brain is not. But one thing, Wendell, that I will say about this, though I agree that our brain isn't built that way, they might have a hard time remembering anything in particular.
So while they might not be able to affirm, I can proactively forget this, they still may be in a position to affirm, I barely remember anything anyway, so I'll probably forget this just like I forgot everything else. Does that make sense? So my point is, there's not necessarily just one way to be honest about that. It's not necessarily like I'm going to go in my what she seemed to be asking them to do is go into your brain, either take it out or turn that part off. But I'm saying there's another way to get to the same result. I'm just forgetting all of this. After this happens, 2 days later, something new has happened. I literally don't remember what happened 2 days ago. So the fact that you're asking me, can I forget it or can I not take it? I don't even know what I'm doing here. Okay. I have no clue. So of course, not only that, but all of it, I'm going to forget everything, Gustav, she's letting the DA hang herself. There's so much already. She's waiting for a tipping point. Gustav, I get that sense that not necessarily she's waiting as in anticipating, but waiting as in not quite yet, but not waiting as in I can't wait for it to happen, but more like you're close. You are close, And if you're saying it from that position, I agree. I can't see how anyone can have some type of bias towards the case. It's a cluster, whatever. Ricky. Again, Judge Whitaker and the jury the jury should be limited technologically as it relates to this case. They could be the most tech savvy people, but they're supposed to avoid all technology as it relates to this case. What does that mean? All social media, all news media, communicating with other people over any kind of in person or over the phone or by mail or whatever. And Judge Whitaker also seems to be personally limited, technologically speaking. There's no way for us to have any idea really what it's like to be on the jury or to be the judge. It's no way. The closest person would be the people in the courtroom. They might have some sense what it's like to be the jury, but most of them still go home and hop on X, hop on YouTube, hop on TikTok or whatever. And the jury's not supposed to do that. So we just don't know. This jury has heard the same instance over and over with a ton of repeat testimony. Let me see something. I want to show y'all something. Since court is not in session or whatever it's doing, I'm gonna look for a person that's called Mel. I don't know if I'm gonna be able to find her, but she brought up she showed an instance, and I probably showed this last time. She showed an instance where the exact same type of play-by-play that they did last week on the writing it out, they did that same thing previously. Okay, here we go. And y'all, this is another really good follow. Mel, I think she's I'm Not a Lawyer But on YouTube. Check this out. Now, what do you see here?
Basically, it was a drive-by shooting.
Which group did you investigate Kenneth Copeland as being a part of?
He was associated with YSL.
Okay, so this is Detective Dennis doing a timeline. We just literally did this exact same type of timeline last week with the I believe was it the new lady? October 18th. Yeah, which with the new detective. So cumulative, same stuff over and over. I don't know how these people don't just fall asleep. At this point, the daily drama and weird stuff is normal for the jury. Bless their hearts. Yeah, I agree with that. 100% agree with that. Andre says, defendant's lyrics, yes, not the whole world. What do you mean? What do you mean by that? I know that I'm late on the comments. I'm kind of behind because I've been on my rant.
Pat Huff says, I seen judge put Montone back in prison on Friday. That's why they closed early out of nowhere. What do you mean close early? You mean today? And if so, what's the connection? Jay Paladine, have smarts. We'll listen. There's always a good faith base for almost any evidence, so good faith is used all the time, even when it's not. Good faith, when I say good faith, I really mean from the intentions of the prosecutor. We need good people to be prosecutors, y'all. We need good people to be prosecutors. We need good people, because when they're good people, they'll try to seek the truth, and they could make a mistake with the lyric, but the good faith means that they thought they were doing the right thing. That's all we can ask, that a person tries to do the right thing. So I'm not saying good faith as in, a reasonable interpretation. I'm saying good faith as in the prosecutor really thinks this and believes this, even if they're wrong, because people get it wrong sometimes. This person says lyrics is art, YSL record label. Some lyrics are written by ghostwriters. So I talked about this last week. To me, the type of lyric that would come in is this. Somebody got shot on 22nd Street on April 25th. And then in a lyric, the suspected person says something like, on April 25th, gave him a gift on 22nd. Something like that. On April 25th, gave him a gift on 22nd. If you say something like that and somebody got shot on 22nd Street on April 25th and they think you did it, that should come in, period. That should come in. If your ghostwriter wrote that for you, then your ghostwriter is going to need to come testify to it. Okay? You're going to need to call. Somebody going to need to call the ghostwriter and ask that person, why did they put that in the song? And we also going to need to ask you, why did you sing those lyrics? Did you know what you were saying? But if somebody got shot on April 25th on 22nd Street, and you say on April 25th, gave him a gift on 22nd, that's just something I totally made up on my mind, from my mind right now. And they think you did it, not because of the song. They think you did it outside of the song, but this is like further evidence. That's gotta come in my opinion. So yes, it's artistic. Yes, your ghostwriter might have written it. We're gonna need to bring the ghostwriter in and question the ghostwriter. But it's got to come in. For us to say that doesn't come in just because it's in a song doesn't make any sense. Now, if you said something totally different and we need to twist it and contort it and, and blah, 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 and I'm not with that. I'm not with the contorting and all that stuff. But if you say something that a reasonable person could say, yeah, that sounds like it's connected. It's evidence. It's not proof. It doesn't mean you did it. But it means we get to, as the prosecution, they get to show that to the jury. It's not proof, it's evidence. So it depends on the good faith belief of the prosecutor. And again, if you have a ghostwriter who wrote that for you to say, and you said it, and you didn't have anything to do with that crime, you didn't even know about that crime or what have you, we'll bring the ghostwriter in. We'll question the ghostwriter. Ghostwriter will say, I wrote that for this reason. I heard about this crime. It just popped in my mind. I put it in a song. Okay, fine. And that'll be testimony. How can you determine what's true and false with rap lyrics when so many rap about money they don't have and crimes they yes, and Breezy, I agree with that. So this would be a potential defense. Like, I'm just rapping. This is not my real life. This is not something I really did. Isn't that what happens with confessions in the police station? Isn't that the same thing? Isn't that the same standard for all evidence where you seem to have said you did something? Isn't the standard that this is just evidence you did something? It's not proof. Evidence is, we're going to take this to try to help paint the picture and build the case and build the picture. That's evidence. We have different little pieces. When we put them together, we think that it points to this person. That's evidence. Proof is, look at this. You don't need to see anything else. Okay? Proof is, we caught you on tape doing the thing. Proof is, we got a picture of you. Proof is, we found the weapon in your locked car, and you are the only person with the keys to the car who could have put the weapon there or whatever. These are the type of things that are proof. Evidence is a lyric from a song. It's not proof. It's just part of a picture that we're trying to build. I think that should come in if it makes sense. Again, when I first heard about it, I didn't think so. So it's not like I don't get where people are coming from. I totally get where you're coming from if you don't like that. I totally get it. Totally, 100%. I think artists should be able to express themselves, etc. But if we think you committed a crime for a separate reason, not your song, but we have a separate reason to think you committed a crime, and we find out you wrote a song about it, the song should come in, or the part of the song that talks about it should come in. All right, tell them. Miss Love put the power, or shall I say pressure, on her back to do the dirty work and would have pitched a fit had she done any different. Miss Love is the pit bull of the prosecution. I agree with that. Should Edgar Allan Poe be on trial for his artistic expression as well as for murder? So, Ricky, this is the key thing. Maybe this is my key point. You should not go on trial simply because you rapped about something. You should not go on trial simply because you claim to have done something in a rap song. What I said is, if you're going on trial, then, and there are lyrics that line up with what you're charged with, those lyrics it's reasonable that they would come in. I'm not saying they should come in, but it's reasonable. So what I'm saying is, if there's a case against you without the lyrics, but the lyrics fit the case, then yes. What I'm not saying is, there is no case. We hear something on a rap song, and now we're going to just use that lyric to put a case on you. I'm not saying that. I don't agree with that. I think that's what most people, when they think about using rap lyrics, that's what they hear. They hear somebody's making rap music and they're walking down the street, and the police is going to jump out on them and say, "We heard what you said in the song," and they're going to arrest them. No, I don't agree with that. So I'm being very clear. It's, hey, so, such and such testified that you did this thing, and we got a warrant, and we searched your car, and we found a weapon, and and we got this other corroborating stuff with your credit card bill and blah, blah, blah. And now while we're reviewing, we say, oh, shoot, you also said something about it in a song. Yes, but it shouldn't be just or even primarily, we heard what you said on the song, we're going to arrest you and put you on trial with this song being the primary evidence. I don't agree with that. So hopefully that clears that up. Okay. Hopefully that clears that up. Anyone that says people that rap about crimes and music and are 100% true must be an accessory to those crimes, since everyone is so sure, right? Again, hopefully, I'm not sure if you wrote that comment while I was on my rant, but again, I think that the lyrics are additional evidence. I don't think it should be the primary evidence of the crime. Let me see here. Andre says, I agree, but my point is you can't use arbitrary lyrics. Example, using a Lil Wayne song to convict. Totally agree with that. Yeah, so I think if your boy raps about something that you did, or a rival raps about something that you did, or just a random person raps about something you did, I think it should be hearsay. I think that should be subject to the hearsay rule. And I don't think it should be allowed in trial. Unless maybe they say we, unless they say we did something, that might be different. But I don't think somebody just rapping about what they think or know you did should be included either. But that is, I guess you're saying that is okay. That is how rap lyrics are being used. Okay, so I'm making my point clear, right? I think my position is clear. If you have a case against somebody without the lyrics, so I guess my main point is this. There should be a case even if there were no lyrics. There should be a case even if there were no lyrics. And the lyrics would be evidence to support a case that could stand without them. Okay? And the lyrics should be used in good faith, as in they are reasonable person could see the connection. So I think maybe that's a good way of stating it. You could use lyrics to support an existing case. Oh, Miss Lily, am I ignoring you? I'm just going down. I'm trying to go down. And Miss Lily, what'd you say? No, I don't. I can't ignore Miss Lily. Come on. So Miss Lily, put whatever you were saying, put it back, and we'll get right to it. Okay, we will get right to it. I'm not ignoring you. I think lyrics can and should be used in some instances. This case has been an example of them doing it wrong, though, and maybe I should point that out. The little woody pop at your noggin and all this stuff. Again, I think it should be specific. I think it should be specific. Miss Lily, I'm glad you feel okay. I'm not ignoring you. I'm glad that it would matter if I'm ignoring you, though. That makes me feel good. Y'all, what the heck happened? So they came back. We had no sound. Are we just going till lunch or what? She was saying get someone to talk to from chat. Oh, y'all want to bring somebody up? You mean bring somebody up? Are you saying like put somebody on here to have a conversation? Anybody want to debate me on the lyrics thing? I mean, again, I'm gonna say this. If anybody wants to debate or make yourself heard on the lyrics conversation, a couple of things I want to make it clear before we do that. One, my position is there should be a case without the lyrics, and that the lyrics should be only used to support an existing case that could reasonably otherwise survive without the lyrics. They're additional evidence. I do not believe anybody should be on trial primarily because of a lyric. Okay, I don't think anybody should be subject to a trial primarily because of a lyric. So with me saying that, if anybody wants to disagree with me and say that lyrics should never be used, then come on up. I'll give you a platform. If your position is that it should be impossible to use a lyric, okay? Or if you have anything else interesting you want to say, yeah, we'll bring somebody up. All the attorneys have left and gone to another room. Y'all, let's take a look. Let's take a look at the chat on Law and Crime real quick. Let me see. Or should we go to Miss Sylvia? I'm gonna go to Miss Sylvia real quick because she's in the courtroom. If you're not a member, follow what come on, y'all. We haven't gotten any members yet. Y'all need to treat us well here. Yeah, Miss Sylvia is there. She's in the courtroom right now. Miss Sylvia is there. She's in the courtroom right now. Let me go back. I'm gonna go back on her chat and see what she said. All the jurors are not here. Oh, Miss Sylvia just said all the jurors are not here. They are in another room talking. Y'all give a shout out to Miss Sylvia. Let me give her a thumbs up at least. Miss Sylvia's in there doing her thing. Okay, y'all. So Miss Sylvia said all the jurors are not there and that the attorneys are in another room talking. Big Boom says freedom of speech. Big Boom. I don't think that the fact that your song lyrics could be presented as evidence against you means you don't have freedom of speech. I don't think that means you don't have freedom of speech. You do have freedom of speech. Queen, yeah, Miss Sylvia probably does have behind the scenes tea. Yeah. They're fighting hard for something, maybe mistrial motions. Why would they be in another room though? Why would they be in another room? Why would they be in another room? After watching that broadcast with Young Thug and what he said gives me the understanding that the lyrics are true to what they do. Andre asked, did Bob Marley shoot the sheriff? Thank you so much. Thank you so much for this question. My Jamaican brother. Thank you so much for this question. This is a perfect question. So let's give two scenarios. One scenario is Bob Marley innocently makes this song because he dreamt about it, seemed like it would make a good song. He makes the song, and he gets arrested for shooting a sheriff. And they use the fact that he made this song a confession. They use it against him, and it's their primary reason for arresting him. Because after all, he confessed. I would not be in agreement with that. Let's have another scenario. Bob Marley is suspected of shooting a sheriff outside of the song. Nobody's ever even heard this song before. Nobody's ever heard this song. He recorded it. It's still in his in his recording file cabinet or wherever he would save it. Nobody's heard the song, but he's suspected of shooting a sheriff for completely different reasons. And while going through his things and reviewing things, they find a song where he said he shot the sheriff. He's already under arrest for shooting the sheriff. They have independent evidence like witnesses and the gun and blah, blah, blah. And then they find this song that says, I shot the sheriff. Should they not be able to use that song when they already have him under arrest for that thing? I definitely think that they should. They should be able to use that song. Now, if he just made the song and now they're going to arrest him because of the song, I don't agree with that. But if they arrested him because of some other stuff and the song coincides with the kind of evidence they're looking for, then I do agree with that. So it just depends on what precedes it. It just depends on what precedes it. Andre, I don't think it's ex parte. This wouldn't be ex parte if they're all there. This would not be ex parte if they're all there. Y'all, is it wrong for us to spy on Miss Sylvia's channel? I don't want to. I almost feel bad about that. You know, I almost feel bad if we're spying too much. Now they don't want a mistrial. Okay, let's go back and see what happened. Let's see what we can glean from what happened. Let's see what we can glean from what happened. How long have we been on break, y'all? Have I been talking for an hour? I've been talking for 47 minutes. Y'all, if you haven't hit the like button, we haven't gotten any. We got a couple of super chats today from C. Lizzle or Clizzle. Thank you so much. No members. Can we get some members? Can we at least get some likes, y'all? I've been on here talking for y'all for 47 minutes straight. Really longer than that. Like pretty much like an hour. Over an hour. Let's see what happened here. Okay. Max Sharp stood up and said something that we could not hear. They never brought the jury in this morning that I remember. I bet there are many sheriffs shot around the time of the song, though. Not as a confession. Yeah, I don't think. Oh, now the idea that his song provoked people to shoot sheriffs would be something totally different. Max Sharp was talking. We just didn't have any sound. Yo, what is going on? Don't do it. What? Don't do what? Go to Miss Sylvia? Oh, only if Miss Sylvia catches me. No, Miss Sylvia is cool, y'all. I mean, listen, we're giving her credit, right? Hit the like, hit the like. All right, I'm gonna spy on Miss Sylvia's channel, but I'm not. Okay, she says there's not much to report, so there really isn't any reason to spy. Miss Sylvia, if you see this, hey. She said there's not much to report. Morning, Antoinette Bankhead. Good morning. It went left once. Love, yeah, Love has that energy, doesn't she? Love just, I don't know if this is her every trial type of deal, but it does feel like things. I mean, the detective dentist situation happened while Love was out, though. So, but it seems like however you slice it, Love does just bring that energy. Okay, you're putting what am I saying? Everything. I'm not sure what you're talking about, so keep it moving. No, they shouldn't be able to use the song because it causes jury to make a conclusion without other evidence. Social media should not be used unless direct threats. I don't get the idea that people will say you can't use song lyrics. I just don't get it. I get that you say you shouldn't build a case based on song lyrics. I get that. I get that you shouldn't necessarily be able to get a search warrant based on a song. But the idea that there's a song where somebody says they did something and you're saying it should be prohibited, I just don't get that. I don't get it. Miss Sylvia is cool. I'm not sure about the Bobby Schmurda, but I mean, again, I don't know. It just seems to me like, okay, well, let me ask you this. Let's go back to this. Pastor, we have different types of artistic expression. So if somebody commits a crime and then writes lyrics about it, that shouldn't be used. What if a person commits a crime and videotapes it? There are people who do things to other people and they record it. Should you say that the video recording shouldn't come in because that's artistic expression? Or if they take photos of it, the photos shouldn't come in because that's artistic expression? Or if they, or again, as I said, paint it, they sculpt it, whatever. We have a person who we think did something. Right now, Diddy is on trial or will soon be on trial, and there are claims that he videotaped certain things. So, Pastor, are you saying Diddy should be able to say, hey, I want to claim the pastor rule? The pastor rule says artistic expression cannot be used against me at my trial. And all those videotapes where I was doing things to people, they were all artistic expression. So you can't use them. Is that should that be the pastor Ihaza rule? Or should it stop at just song lyrics? See, now I'm getting into my thing here. And if it should stop at song lyrics, please tell me why we should not be able to use song lyrics, but we can use videotape where that also, hey, I'm a videographer. I'm an amateur videographer. I was videotaping things and it's artistic expression and it shouldn't come in. Because who actually wrote the lyrics? Who performed the lyrics? Who performed the lyrics? Listen, artists don't always write their own songs. They don't always produce their own music. A wonderful architect may have other people help him or her design the building. Other people will almost certainly build the building. Art is collaborative. So I'm asking you, Pastor Ihaza, should the videotapes that Diddy recorded, so allegedly recorded, of people being mistreated criminally, should he be able to keep all of those tapes out of his trial by claiming the Pastor Ihaza rule that artistic expression cannot come into a trial against you? Or does the Pastor Ihaza rule stop at lyrics? And if so, why is it that lyrics get the exclusion where other types of artistic expression don't? That's my question. Bro, I would debate you. I agree if there are circumstances, but if I've been said it shouldn't be arbitrary though. I'm not in favor of anything arbitrary. So I don't think anything arbitrary, haphazard, willy-nilly, that's not even within the conversation. I wouldn't support that or defend that for even 1 second. Would every person singing on the song be guilty? Ihaza, it is evidence. It's not proof. It's evidence. It is not proof. Evidence is just painting a picture. It's not saying that you did something. It's saying that this tends to help prove that you did it. Excuse me. It tends to help paint the picture that you did it. But so I mean, again, I'm trying to figure out, does this stop at song lyrics, or do we also include other types of art, what we might call artistic expression, include videography? Everyone thought 69 was a blood. The realist, come to find out, it was all just a play to get him in the door. I can tell you that's real. Okay, so if you're talking about 69 lyrics, I don't know that he had lyrics that they used against him, and I don't even know if you're referring to the ongoing lyric debate, but I'm gonna, even if you're not, I'm gonna flip it into that, and let's talk about 69. 69 was accused of certain crimes. You don't have to be a real gangster to commit a crime. That's one of the biggest things that I find interesting. Like, people almost feel like only street people commit crimes. That's not true. Yeah, they might commit more crimes, just due to the lifestyle. But so I don't know, CJRP, Ricky, if you are referring to the lyrics thing or not. But at the end of the day, I don't think you have to be considered real. You must not be talking about the lyrics thing. I'm going to keep it moving. Yeah, if a recording a song couldn't be used, more people would rap about all the bad things they did. I'm just saying so my point is not that it should be used. I'm saying it should be able to be used in a trial that has other compelling evidence. Miss Lely's staying out of this. Diddy did it, 50 Cent. You know what I'm saying? I'm confusing. I guess maybe I'm confusing. I'm not confusing anything. I'm just telling you my perspective. I'm not saying that that's what is happening in this case. I'm not arguing for what's happening in this case. I'm telling you my perspective on the general topic of using artistic expression against you in a trial. That's really what I'm saying. The video of murder or crime is different. A song can be written with others as well as not a direct threat. So if Diddy can prove that those videos that were recorded with other people, or that other people installed the video camera equipment, or that other people were involved in setting up the recordings, or that other people were involved, you're saying that by saying different people, that there's more than just one person involved, that should get that out of court. So Diddy says, yes, that's a recording of me doing things, but I worked in conjunction with other people to make the recording. So therefore, are they guilty too? According to the Ihaza rule, we don't know. So we have to exclude that because I wasn't solely in control of making the video recording. Is that the Ihaza rule? I'm just trying to nail down the Ihaza rule for using artistic expression against somebody or excluding it in a trial. And just, I'm just saying this playfully, okay? So don't get flustered or anything. But what is the rule? Because I imagine if Diddy only has to argue, well, I just want to argue that because I wasn't the sole person responsible for recording the video cannot come into trial. Or because I'm not the only person shown on the video, there are other people, then the video cannot come into trial. So is that what we're going to say? Artistic expression should be excluded when it can be proven that the artistic expression was made not only by the accused, but in conjunction with people who are not accused. Therefore, whenever that is the situation, it must be excluded. Then Diddy would only have to argue, no, it wasn't just I who made that video. I worked with other people, so we need to exclude it. Would that make sense? Like the song. He wasn't the only one on the song, so we don't know if he wrote the song. Did he perform it? Did he say those words out his mouth? Because I think he was the one who said it. You know what I mean? False comparison, video of a crime would be proof. I agree with that. Women are water. I agree with that to a large extent. It's not it is not a perfect comparison. I agree with that. It's the first thing that came to mind. I could come up with a much better comparison. But I don't know for sure that video of a crime is proof. I said something earlier like video is proof, so I'm gonna side with you, 90% on that. But we also have to think about it from the defendant's perspective, where there will be videos and they're going to try to argue that it's not proof. The defendant is going to try to argue that what you're seeing with your eyes is not proof of the crime. All right. So from the perspective of me thinking about it, I agree with you. From the perspective of what would a defendant try to say, they're not going to agree with you. They're going to try to figure out some angle, right? So you would want to get those videos excluded, wouldn't you? But I do agree with you. Overall, it's not the best comparison. It came to mind because Diddy's in the news right now. Come on now, sir. That is not the same. If there's videotape evidence of a crime, that is something different. A song is artistic expression. Video is proof. Okay, so you're saying the same thing. More or less, I already said that earlier, so I tend to agree with that. It's not the best. It is not the best comparison. Totally agree. My new rap song is I got the marriage and I turned around and choked the pastory. Pastory? I'm not sure what that is. Wendell. The state is dragging this case until they get that I got you moment. I don't know that that's going to come. The way the labels are set up, they ain't letting the people who really doing this stuff in studios. That's different. Of course, they should be used. Unless you mean an entertainment video, I'm unclear about what type of video you're speaking of. All right, well, I brought this up the other day, y'all. Okay, let's talk about this video. Hold up 1 second. I don't want to share it yet. I brought this up the other day. So I'm not going to play this. I'm not playing the song. All right, I brought this up the other day. Don't worry, y'all. We still have. I brought this up the other day. This is a better example. So this is a video. All right, so for everybody saying video should not be able to be used, so I said I agree with you 90%. This is the 10% where I don't agree with you. This is Threat. This is Woody's friend Threat back in 2020. July 8th, 2020. He was just killed this year. Tragically, RIP. This is Woody's friend Threat. I showed y'all this the other day, but I'm going to show it to you again. This is Woody. This is Woody's music video. Lil Woody Vivo. This is his music video. Now, I'm going to show y'all a picture of Donovan Thomas. This is a picture of Donovan Thomas. Let me see if we get it big. This is a picture of Donovan Thomas. Okay? This is a picture of Donovan Thomas. Now let's go back to the video. This is Woody. This is Threat in Woody's music video. The name of the music video is Homicide. He's rapping. And wouldn't you know, you get a guy who looks like this, a guy who looks like this, a guy who looks like this, and he has money on his head. Now, y'all really gonna tell me if they were to, and I'm not saying they should, and nobody, don't say that I said anybody did anything. I am not saying that. But you telling me if you a prosecutor and you think Woody and his boy Threat did something to Donovan Thomas, and you get a music video like this where they put money on this guy's head who they selected to be in this music video, and they literally put money on his head, and at the end of the video he winds up like this. You telling me you a prosecutor and you think these guys did it and they make this music video? You telling me that this shouldn't come in? That is for the person. Who was it that was going at me? And I said, I agree with you to some extent. I'm sorry, y'all. I got pumped up there for a second. I got pumped. No, there is not a person on this stream right now who can honestly say, if you thought they did this, which I am certainly not saying they did, but if you thought they did this as a prosecutor and you have this video, there is not one of you who would say, nah, we shouldn't be able to use that. Of course you should. Of course you should. Of course you should be able to use it. And this is a video. It's not video of the act. So that's where I said my Puffy example was not the best example for this artistic expression conversation. Okay, so I gave you that. But you can't tell me you wouldn't try to use this now. And you can't tell me that if this was your family member and you saw this video and you thought he did it. Now, that doesn't mean he did it. But if you thought he did it, and you see that there was beef, and you see that they did some shootings, and you see that there was this and that and back and forth, blah, 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 you can't tell me you wouldn't try to get this in. And this is a video, and this is artistic expression. Tommy Drake, it's a reach. What? It couldn't be anything. This couldn't. This is the exact opposite of a reach. You got the two people. You got the two people who shot up Rich Homie Quan father barbershop. You got a song called Homicide. You got a dude who is selected purposefully to be in this video, who has the same type of characteristics, physical characteristics of somebody who is now deceased, and you have him getting killed with money on his head. So is it proof? No. Is it evidence? If one of these guys were on trial, this would be evidence. They're not on trial right now, so it's not evidence. But you certainly cannot say this isn't evidence. Ricky, you say this isn't evidence, maybe because this isn't one of your family members. I agree with you. It doesn't prove anything. No. Big Boom, I agree. It does not prove anything. We're talking about evidence. It could just be clout. But if you think that he did it, Big Boom. See, this is where people, I think y'all aren't following me. If you already think he did it without this video, if you got cell phone records and you got shell casings and you got testimony and you got this and you got that, and you're like, we putting this guy on trial. Then you find out about this. Are you saying that you're going to be like, nah, we don't even need to show that? That's my question, Big Boom. My question is, if you already going to put these guys on trial for this, and then due to all the evidence you have, and then you find out about this video, are you going to say, we definitely need to show it? Or are you going to say, nah, that really doesn't help our case at all? That's the question. I bet Sarah Boone wish video was inadmissible. It doesn't prove nothing, but in this case, it does support their theory. That's the point I'm making. It's not proof. It is to support a theory, and a reasonable person could watch this and say, yes, I could see how this
could connect. It's not like a reach. It's certainly not a reach. Anybody says it's a reach, I can't agree with that. They're acting, no one was harmed into making a video. They need actual evidence of the crime. Are you serious? We're talking about artistic expression. Should it be allowed? Trolling, yes. Let them, again, I think the biggest issue here that people are not grasping is, I think y'all default is, should you be on trial just because you made this video? And the answer is no. I think that's what people mind stops at that part. I think people are saying, should they go to jail for that video? No. That's not, no. Of course not. Should they be brought on trial just because they made a video? No. If you think they did it for other reasons and you have a strong case without the video, would you as a prosecutor try to use this video as well? That's my question. If you have a whole set of reasons you think somebody did something and you think you have a strong case, but you also have this out there, would you try to use it? That's my question. So it's not about making the case based on the art. That's really what I think a lot of people are getting. That's why I think people are getting, that's why I think people are getting stopped up. I'm saying that you should be able to use this if you already have a case. I'm not saying I think you should be able to make a case based on this. That's the big difference. I saw you and you're definitely going to try to get that into evidence, and they should. I do agree. So that's my point. That's my point. No, you're 100% right. They for sure going to put it in, and they should. That's my point. If there's already a case. Now, if they say to Woody, oh man, we didn't know you did it, but we saw the video. And now we're going to, no. If they were like, oh, we thought somebody else did it, Woody, but now we saw the video. No. Or a song or whatever. Now, if it's a video of him doing it, that's different. That's why I fell back on that point with the Diddy stuff. I fell back. I said, y'all got that because that's different. But this is an artistic expression. Okay. So, y'all, we got a nice little conversation out of that. I think y'all see I try to be reasonable. And I think we've gotten somewhere. So I think as a community, as a group, as a chat, we can hopefully all say there are some times when a person who may have committed a crime may have also committed art, confessing or alluding to the crime. And there are certain limited circumstances where you should let that art in. Okay? There are times when a person who may have committed a crime also then commits art about it. And, it shouldn't always come in, but sometimes it should. Bob Marley's song only gets brought into evidence if he's already accused of shooting. That's my point, LTK. That is my point. He's already accused of shooting the sheriff with some kind of independent evidence. The song helps to bolster, if you will, the evidence. It's not like it's going to be the only thing or the primary thing. Back to points of law, video is admissible if relevant, authentic, reliable source legally obtained is admissible, just like testimony. That's my point. That is my point. I would have used that video. Anybody who's a prosecutor who wouldn't try to use this is loco. I'm sorry. You got to use this. Cat Knott Williams is showing something. Okay. Let's see. This is the Law and Crime. Cat started late today. She's probably showing what happened this morning. Cat started late today. She's probably just showing what happened this morning. Hold up. No, Cat's talking about no, Cat is not showing that. Cat is going over Mr. Williams' response to state motion for reconsideration. She's going over the stuff that they argued this morning. She's going over the motions related to
the Dennis hearing, but that's already over. That's already decided. So Kat's excellent, by the way. I really enjoy Kat. She's really good. Yeah, she's going over what Kat's reviewing right now. Look, we mentioned Kat, we lost 20 people. People like, yo, I'm out. Kat's on. That's okay. Kat is reviewing a motion, but that motion it's already decided at this point. Yeah, I know. I be getting pumped. I be getting pumped. It's nothing personal, you know that. Just getting my rant on. Just getting my rant on. Don't worry about it. 100% facts. We can't deny that it's possible. Don't forget, Miss Love wouldn't let Woody admit to it. Yeah. That's another thing. Miss Love would not. It was Miss Hilton who told him that, but the prosecution wouldn't even let Woody admit to it. So, but I mean, I'm not trying to go in the direction of did Woody do it or not. That's, again, my point is, if you were trying to put him on trial, would you use that evidence? And of course you would. There's nobody, I mean, I'm sorry, there's nobody on here who could honestly, with a straight face, say you wouldn't use that. And there's nobody who would say it's not relevant. It's not proof. Okay, that's where we have to stop. It's not proof. I feel what you're saying. A young lady got shot, and the guy who did it posted he did on Facebook. Crazy. What crazy does? Yeah. So like, that's another thing that I was gonna go into, Wendell. I almost went into that because I mentioned, a video of somebody doing it. But what about when somebody goes on social media after, either immediately or at some point after, and says something, should that be able to be used? At the end of the day, it's ultimately up to the jurors to decide. Correct? Hold me tighter is confused. I'm gonna pop back over to Miss Sylvia, see if she knows something. And for Miss Sylvia, we appreciate you being Lara in the court. She's on live stream. It's all dark on her side right now, so she looks like she is not actually streaming. I'm looking back to see if there are any messages from her recently. It looks like Miss Sylvia is off. So we're just going to keep the conversation going. This case is such a mess. State giving the killers immunity and pleas while trying to lock the rappers up for life. A lot of people say what they're going to say about Woody. I am not saying that. Okay, so let me be clear about that. I only brought that up because we were talking about video evidence. That video of you doing something is more akin to proof than it is to evidence. And I agree with that. But that was an artistic expression which depicted an act, not exactly as it happened, but an act that, she's reviewing motions. Why would they go to another courtroom? They've been reviewing all the motions in front of everybody. Papa Bear, what'd you miss? Nothing. We're just on break. Biggie had lyrics in song What's Beef saying he get, yeah. Do you think he's still alive testifying Diddy trial? Ooh, I don't know. We don't know who's going to testify, but I think it's a good point. I think it's a good question. I don't think that's specific enough. Honestly. Who is Kat? Kat is another streamer. She is weirdly good at explaining things, particularly for somebody who has no formal legal background. Kat is weirdly good, and that's to her credit, at explaining things about this trial, at remembering things, at connecting things. She's just good. Your passion and your arguments make the conversation highly engaging. No problems here. Yeah, I do go on a rant. I do rant. Yes, I'm a ranter. Anybody who knows me will say that. So it is what it is. So yeah, Grand Rising, Papa Bear. So we're just waiting for them to come back to court. We have not had court today, sir. They've been live and they argued like 2 motions, maybe. Judge Whitaker. Maybe we should just play this in the background for a little while. Judge Whitaker did sustain her. This guy came.
Made at the point in time when I could have done something about it. But in addition,
This guy kind of reminds me of he looks like somebody. He looks like an actor. Y'all, what is that guy's name on Breaking Bad? Do y'all remember when there was like a cleaning crew that came in and there was like a psycho, like the young guy from the cleaning crew, and he kind of joined Walter White's crew? He was a psycho. And he was a psycho. Anyway, this guy kind of runs.
the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, I mean, it seems like this whole issue is moot. You may be.
May it please the court, Kevin Armstrong for the state. First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor
Give me a
referred
second,
to,
y'all.
is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's one of the things that the state filed the motion for reconsideration to avoid. And so the state is asking that for other issues and for whatever issues that have not already been addressed, the state be allowed to recall Detective Dennis to testify about other matters that were not the offending statement, which the court appropriately excluded from evidence. And one of the things the defense brought up in their response was confrontation. I want to make it absolutely clear that there was no intention in the motion for reconsideration to have state's evidence in that they didn't give the right to confront. And so that was not part of the issue. But the issue isn't only the testimony that was struck from that day, it was his future testimony, precluding him from testifying in the future. And while there are other means to get in some of the testimony, I don't believe that is all the testimony that the prosecution team intends to get in through Detective Dennis. And so essentially, it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective is not going to be testifying to, because she was qualified to be able to testify to the meaning or her opinion as to the meaning of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
Thank you, Your Honor. Detective Dennis testified to a statement regarding defendant Kendrick, in which Investigator Underwood was not present for that interview. And so he testified to that. He also testified further regarding the Quindarius Zachary interview, in which Investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through Investigator Underwood. And I believe those are the 3 primary things that Investigator Dennis was able to testify to previously that was struck that Investigator Underwood would not be able to introduce during her testimony. In court's indulgence for one moment.
All right. Thank you. Okay, so Mr. Steele, I guess you sort of led the charge on this, if I'm not mistaken. What do you say to the state's position that the court's decision to strike and prevent further testimony of this witness isn't a remedy that is permitted to the court by statute or the Constitution, and understanding that if this were reconsidered, the state would be, I mean, the defense would be permitted to cross-examine.
So I believe that you have the authority, jurisdiction, and power to prevent a witness from testifying when that witness shows that they are not capable of providing a fair trial and intentionally, and that's my word, but it was clear to me sitting there that when Ms. Hilton asked retired Detective Dennis, tell us about this photograph that has Mr. Kendrick standing on top of a car, his initial lead into that answer is, well, Mr. Kendrick just got out of prison. And, you know, that affects Jeffrey Williams. Mr. Kendrick, as the court may have heard, is signed to Mr. Williams' record label. Mr. Kendrick, as you will learn, is at Mr. Williams' home on May 9th, 2022, when Mr. Williams and Mr. Kendrick are arrested. And it is just not that simple to unwind that instruction. It was an intentional, obvious infliction to denigrate this trial and prejudice Mr. Williams, Mr. Kendrick, and all. So you then have to do something about it. And what you asked to do is declare a mistrial. And you said, I'm not doing that, but there will be a sanction. So what are you going to do? So to me, that was the second time. The first time the court, I'm not saying it's not accurate.
So obviously, considering that I'm the one that imposed the sanction, I think it was an appropriate sanction. Address the state's argument that a trial court doesn't actually have the authority to impose that sanction.
I think that's wrong based upon, let me give you, and I put it in my response, but Illinois versus Allen, 397 U.S. 337, it's 1970. What happened there, and the U.S. Supreme Court took down, that was an accused right to be present at a trial, constitutional right. And there's a dissent in it saying the accused, no matter what their conduct is, they could be gagged and bound. They have to be in the courtroom and watching the proceedings. Otherwise, it's a constitutional violation. But the majority said, this is ridiculous. Courts have to have the power to ensure that the trial is, and I'm quoting, conducted with dignity, order, and decorum. They are the hallmarks of a court proceeding. And then I found a case, I just found it amazingly similar. California versus Navarrete, Navarrete. Your Honor, it's 181 California Appeal 4th, 828, 2010 case. And in that case, a detective is testifying, and there was a suppression motion granted. There was no Miranda rights given to Mr. Navarrete. And the detective testifies on the witness stand and said, well, the reason I didn't follow up on this DNA swabs is based upon the client's or Mr. Navarrete's statement. The judge did exactly what you did. The judge called the prosecutor, well, a little different, called the prosecutor and defense counsel in chambers and yelled at the prosecutor and said, you know, I'm demanding, what are you doing? And the prosecutor said, I didn't know that that would happen. Just like here, I'm not saying that it was Miss Hilton eliciting that on purpose. I had no information that she would ever do that. But the judge said, well, this detective knows better. I find the detective is trying to harm this trial. The detective is barred. His testimony is struck. The direct is gone, and he can no longer testify. And the state did exactly what happened here. The state in California, the prosecution, the people, they called the next witness. To me, it's on all fours. The appellate court, Mr. Navarrete is, God forbid, convicted, and the appellate court then reversed and said, that remedy did not go far enough. That had to be a mistrial, that intentional conduct. And here, I'm asking the court, I believe that you have total authority. There is no way that anyone will convince me, I'm not the one who needs to be convinced, that Detective Dennis did not realize. It came out of nowhere. What difference does it make that Mr. Kendrick was released from prison 5 weeks earlier? What difference does it make? He did that to bring out to the jury that Mr. Kendrick was in prison for, and I'm telling you, it's a federal offense, a gun charge. There was no basis. So to me, to say you don't have the authority to do that, I believe you have every authority. If a witness comes in here and starts cursing, I'm using an example, I would assume you are going to say, this is just not decorum. You can't curse. The witness curses again. You're going to do something. You're done testifying. Courts have that power. So I believe that the state's argument that you have no power to control the proceedings is not backed up by the U.S. Supreme Court.
All right, thank you.
May I respond?
You may.
There was a defense attorney who raised their hand.
Good morning.
Good morning, Your Honor. I want to be very brief because I don't think what I'm going to add is truly what Your Honor is looking for, but
Jay Apt, Your Honor, good morning, on behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers at any particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses. And so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court has sent a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority, and Mr. Steele's done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Thank you. Mr. Armstrong.
Yes, Your Honor. I would agree with Mr. Apt to the point that I would like the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come in the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court to, the court appropriately struck the testimony that was at issue. We are asking the court to go further with other testimony that was not the offending testimony. Now, People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite. And that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here. And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case. And the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402, the exclusion of evidence can exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we're just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this. All right. I think that the next thing that we had to do was the sort out the remainder of what we're calling the Ryan evidence. So
Y'all, we're
maybe
just
y'all
gonna keep it
can,
moving.
Present what's
Just gonna
what
keep
you've
it
come to
moving.
agreement on and what still needs to be litigated. And thank you, Mr. Armstrong.
I understand they're coming back at 12:45, so I'm gonna just let this play.
Yes, Your Honor. And one,
I'll be in the chat.
a small matter that's in this act we can address
Okay.
is in the CAD report. Okay. Never mind, Your Honor. Counsel and I have been discussing stuff in frequently. So
Yeah, I know.
I will turn to all that's left to my understanding is the last little bit of Blaylock's Instagram.
Okay. And do y'all want to give me some kind of, I don't know if it's written or whatever, indicator of what y'all have agreed to, or just put it on the record, or what's in, what's out?
Your Honor, I'm trying to think.
Or I guess, if you don't have something at the ready, then I would assume y'all are on the same page about it and will abide by whatever it is you agreed to.
Your Honor, I believe that is accurate.
Okay.
I think what the state would be moving to enter into evidence is things that we've agreed upon or the court has already ruled on.
Okay.
Besides what it is we need to discuss this
Okay.
morning.
All right. And so what is it that needs to get discussed this morning?
This morning, Judge, we're going back to content in Mr. Damone Blaylock's Instagram messages between him and third unknown parties. Your Honor had asked me to take a look as far as co-conspirator hearsay.
Okay.
From what I can tell, every instance I've found requires evidence really from the outside that basically you could ignore this entire statement and there's still something to indicate participation in the conspiracy. I don't have any sort of law stating one way or another that that is what is required. I would just point back to the statute, Your Honor, that I think what Your Honor had referred to, I would say kind of are indicia of reliability, that they're talking about things that a person who's a member of the conspiracy would know about. And just simply, that's not what's articulated in the statute. If it was supposed to be indicia, then I think we would be there. But that's not what the statute requires. So I don't think that would be sufficient. I think it truly does have to be from outside of that hearsay statement.
All right, and is there further argument from the state on that? And I know there was one, and there might have been two that we had already looked at that were kind of outstanding, and I had given a preliminary ruling subject to further argument on this. And the second one, I think I already brought up, and I don't know, Ms. Abbasi, if you were here that day, but that I
reviewed
didn't
it.
think there was enough, so I have excluded that. But the other one, does the state have any further argument or authority on that?
So, Your Honor, I don't have, the state's argument was in looking at 801 D2E, just the basic building blocks of if the court finds through the four walls of a statement, evidence in trial, or some other evidence the state would present. Ultimately, it is the court has to find that that other party, whoever they are, to a preponderance, are part of the same conspiracy against who it's being used against. And I will use, this is, I don't have a specific case for this principle, but I think it illustrates this point the state is making, is if you had, take aside a gang conspiracy, say you had a murder committed and the defendant's phone, they get a search warrant, they extract it, and he is messaging someone after the murder that you do not know who they are. And he says, I need you to go to my house. The murder weapon's in my back bedroom in the second drawer. And they respond back, yep, the police, I can hear the sirens coming down the street right now. I'm going to go grab that gun. Where do you want me to take it to? And they have this whole conversation. You don't never know who he's speaking with. By my reading of, or an understanding of co-conspirator, that conversation, if you had it in that trial and we're trying to introduce it, I believe a court could find from the four walls, so to speak, of that conversation that that person they're speaking with to a preponderance is a co-conspirator. And by that same analogy, if you have in the conversation that the unknown party, so to speak, whether it's their Instagram handle, the fact that they're referencing specific individuals, or that gang APD detectives have referenced are, say, YSL members, or they're discussing locations, or they're using gang identifiers in a private conversation, coupled with the evidence that that hasn't came in yet because no evidence about Blaylock to the jury has came in, but when APD gang detectives to speak about Blaylock and his Instagram and public and private conversations indicative of his own membership in the YSL criminal street gang, all of those the court can use or not use in making that determination. And so I don't have a seminal case that says you need more than the statement itself. I think oftentimes the statement itself, absent this kind of, in a gang context, there's other information versus when you have just, say, a murder case, you would, other than the factual analogy I just gave to the court, it would probably be hard to decipher. If you just had a single text with an unknown party, you wouldn't know who they are unless it was like the analogy I used. So the state doesn't have any additional case law. I always will cite, because I think it's a seminal case and important for a criminal street gang conspiracy, which all of Blaylock's are, the state's arguments related to them are not tethered to the murder of Jamari Holmes. They're tethered to the YSL criminal street gang, at least the ones that are in dispute, I should say.
All right, so can somebody remind me where it is that we're going to find the statement specifically that we had been paused on before?
I don't know if I'm sorry, excuse me. I don't know if the state sent to the court a new link, or we're
I'm
still on
sure
the
there was
prior
a
one.
link that y'all sent me at some point.
I can create
over and over again. I know. I'm
Yes.
sorry.
for a,
Most recent one, I
If
don't
you wanted
know.
to remind me when that was, I could probably find it. Or
The-
what folder it was in.
yes, Your Honor. The initial folder was 9 October centralized motion folder in Dropbox. For efficiency's sake, I can
Okay,
quite quickly create and
that would be
send.
wonderful. A new link.
Yes, Your Honor.
Okay. And I guess it'll be easy enough to see once we're all looking at it again. But I cannot remember whether in this particular one that we were talking about, there was anything like the other speaker's handle or anything like that that would have been outside of the statement itself. So I guess when we get the link, we can look at that.
And Your Honor, I'm going to try initially to email because Blaylock's Instagram is 28-page PDF. So I think that that should be small enough to send via email.
Okay.
Rules that in terms of, like, for example, and there's also, they're discussing, someone references Pokey, which has come up periodically in this trial and is one of the individuals that Quindarius Zachary mentions was participated in the shooting of Miss Reed's home, right? When he's discussing Kenneth Copeland returning. And also when this snake life maniac, when Blaylock, who's one King DO1, states he was stamped into the street gang by Pokey, the individual responds, he's been locked up a good 6 to 7 years. When did you get stamped? And he's kind of checking to see if that story checks out. And so the state's argument, and then it of course continues on, but it's, and the Snake Life Maniac says, I never met the young rock crew. There's been a lot of testimony about rock.
Right. But if
Yes, Your
I'm,
Honor.
if I have to find something outside of the statement itself, then that would indicate, I think, that I can't take into consideration the contents of what this unknown person is saying to make that necessary determination, right? So
The state's understanding and argument is that you can use, whether it's this statement itself alone, the court just has to find to a preponderance that this
well, we
individual
know
is
that the
a
statement
conspiracy.
alone can't establish the existence, or I'm sorry, the participation of the declarant in the conspiracy. I mean, that the statute itself provides that much information.
And I guess my argument, Your Honor, is that the testimony in trial is in addition to the statement. As in, like, if you just had this in a vacuum and I presented no other evidence of why what they're saying is significant, if you didn't have APD gang detectives who've testified about what these indicate or mean.
So because we have outside of this statement testimony about Pokey and testimony about how people get included in gangs and things like that. Is
Yes,
that
Your Honor.
your argument?
That's the state's
And in
argument.
addition to that, this person's handle itself indicating their connection to YSL.
Yes, Your Honor.
All right. Okay. A preponderance is really not that high of a standard burden to meet. So I am going to find that this one does meet that outside of the statement alone, so that entirety of that can come in. So we then need to move on to whatever was left. Is that right?
Yes, Your Honor.
Okay. All right. And so the next one would be on page 430, or are there some that y'all have?
359, Your Honor.
Oh, that's a different one? Yeah,
It's
I'm
a different
sorry.
one.
Yes. Okay. So 359.
So what's highlighted is Blaylock stating you have to pay the dues January 15th. That's the day you got stamped. And then the individual responds back, essentially like he will pay him when he sees him. The state, I will, because this conversation is so brief in terms of comparatively to the one before, the state will concede or not utilize 359.
Okay. So I'll withdraw that one.
But with yes, Your Honor,
Okay.
430.
Mhm.
So the individual that Blaylock is messaging, YSC Prince,
Mm-hmm.
he says he's leaving that YL up to you and me. YL is Young Loyalty. So when YSL, the criminal street gang, you have remnants of, Young Loyalty is essentially a subset of that. And so when he said he's going to leave YL up to me and you, he said when he gets out, it's still going to be YL, but we're going to take it over basically. Let's push up next weekend. The state wanted to include that because of direct reference to Young Loyalty and someone having to take it over. This would be in conjunction with, which I don't believe or do not recall, testimony thus forth in trial, as in through Detective Belknap, or will be when Detective Viverito testifies about Young Loyalty YL. But that was the state's request or argument in terms of this would have to be, the court would have to deem YSC Prince making that statement is in furtherance of the conspiracy to admit this as an exception to hearsay.
Okay, and you're saying we don't thus far have any evidence about YL or the meaning of YL, and are we going to get any?
Your Honor, yes, the state, I am drawing a blank if Detective Belknap addressed that when he first testified in this trial. I just do not recall as I'm sitting here. But if he had not, the state would proffer that Investigator Viverito would discuss that at a future date. I do not have any additional
And
evidence.
YL is, how is YL furthering this conspiracy? I'm not following your argument. I'm sorry.
So Young Loyalty YL is a part and parcel of YSL. It's like a subset. And so the state, by him saying we're going to take over specifically YL, that is trying to assert leadership over Young Life or Young Loyalty, Your Honor. So
that one seems a bit, I don't know, far afield.
Understood, Your Honor. The state will not utilize 430.
Right.
And the last one, Your Honor.
Can I, Ms. Atkins, do you mind if Your Honor, can I just interject?
Sure. I mean, they're withdrawing it and or I'm excluding it.
Okay.
But so do you need to?
No, I thought it was still up in the air.
All right. So 2145.
And Your Honor, the last thread of this nature is when you go to page 446, there's just one line where Blaylock is discussing, he says, "You're not slime." And on 447, they go back and
I don't see a 446, 447.
it is PDF page 15, Your Honor, and PDF page 16.
Okay.
And the key, the statement that the state is seeking to introduce is when Blaylock on page 447 states, "I stamped you in slime behind the blue house," talking about bringing that individual into the gang. The 446 is only included for brief context to that. The state would not necessarily have to use 446, but the argument is that when Blaylock states, "I stamped you in slime behind the blue house," to this individual, when they're going back and forth about if that individual is slime, that statement, the state believes there's two arguments for this statement in terms of Blaylock definitively stating that he brought this individual into a criminal street gang, and he references the blue house of just a specific location to remind him where he stamped him in. That statement is a co-conspirator statement, but in addition is a statement against interest. And the best example of why it's statement against interest is the case of this nature. As in, if Blaylock was in this physical courtroom right now, that statement he made there is against his interest in terms of definitively asserting he has enough rank in a street gang to stamp someone in and would be evidence that could be used against him in a criminal street gang or RICO predicated on a street gang trial. And so the reason that the state articulates that this is 801 D2E is because when he's telling someone, I stamped you in slime behind the blue house, it's a conversation between, he's asserting in this statement that he brought this person in the gang. And so those kind of conversations, they have to be able to speak freely amongst each other, and they're discussing criminal street gang activity in terms of he's referencing when he brought him into the gang. And given the liberal standard of admissibility from Kemp and its follow-on cases, and that fostering cohesion, also, the direct reference to the exact criminal street gang conspiracy that the state is alleging they are a part of, feels that Blaylock's statement, I stamped you in slime behind the blue house, should be admissible under either of those two bases, Your Honor, is the state's argument for why it's not hearsay.
All right. Why? I think that one passes muster. Yes, sir.
I believe that a statement against a penal interest, as articulated by the prosecutor, if it only goes to Mr. Blaylock, that we would get a limiting instruction.
I think it comes in as a co-conspirator exception. I stamped you in slime behind the blue house.
Okay, and understand the court's finding, then I would ask you to decide whether 24-8-805 hearsay within hearsay would apply, because I don't see the exception on the other end of the conversation. I don't see I stamped you in. The other person's statement is also 801 D2E.
The other person's statements, frankly, are GMFU and you not.
So how did
I mean, I don't
that conversation
think
further the
it
interest?
seems, I don't think it does, but I don't think those statements are being offered for their truth.
That is correct.
All right. All right. So what's the next one?
Your Honor, that, and correct me if I'm wrong, Ms. Bassi or Ms. D. Williams, but all of the remainder of this are conversations we have discussed that are pertaining to the February 23rd, 2019, the day of the murder itself, not gang co-conspirator statements. They're tethered to, they're ones we've discussed of no issues with. Unless
Okay.
defense counsel corrects me.
That's
Accurate.
right. Okay. All right. And so is that it for
That's the entirety of Mr. Blaylock.
Ryan evidence? All right. And when are we, we discussed before about how we need to get to this kind of grouping of evidence before the end of this month. Is that going to happen?
Your Honor, there is yes, Your Honor, the state, we could reach this case today.
Okay. All right. Sounds good then. And then how about the Mr. Arnold scheduling? Is that got nailed down? Okay.
That was it from this morning, except for the fact that we got DA Love back. So y'all, we hanging out for about 15 more minutes. About 15 more minutes. We're hanging out. Court is supposed to be back in 15 minutes at 12:45. Who waits 10 years to try a case? So y'all, this is why the detective dentist prohibition, banning, barring is so important, because this was his case. Oh, Oh. Let me show y'all something. Hold up. If y'all aren't checking out our videos, you need to be checking out our videos. Do hit the like button, everybody. I'm about to show y'all something so interesting. This, I have to thank certain people on X for pointing out. Was it Seti Nash? I think it was Seti Nash who said this, who pointed this out. A few people pointed this out. Y'all, check this out.
And do you remember?
Check this out. This, I don't know why this isn't one of the most explosive things in the whole trial as of right now. Watch this. We're gonna watch this until court comes back.
And do you remember stating?
I'm not gonna.
He did not witness.
I'm not gonna.
Check this out. I'm going to show you how I afforded this car. Okay, you ready? All right.
This back and forth.
All right.
Listening to or being present at actually interviews of Mr. Zachary, also known as Little D.
That's correct.
All right. And there's two Little Ds. Earlier I was saying Mr. Garlington, he's also Little D. Fair to say?
That's correct.
All right. I'm now talking about Mr. Zachary,
Yes.
also known as another Little D. All right. You were present at the April 13, 2017 recorded interview with Mr. Zachary. Fair to say?
Yes, I was there.
And you were there with other law enforcement, including Detective Thorpe, Detective Dennis, Detective Gaither. I believe if I'm leaving someone out, I'm not trying to.
Yes, that's correct.
You were not present for the August 5, 2015 interview with Mr. Zachary, but you've referenced it today with Mr. Body and you've reviewed that. Fair to say?
That's right.
That's also audio video. Fair?
That's correct.
In the August 5th, 2015 interview that you recorded, that you reviewed, that was recorded that you reviewed, did Mr. Zachary make it clear that Mr. Williams did not know about the killing of Donovan Thomas till afterwards?
From what I remember, yes, he did talk. Yes, the short answer to your question is yes.
In the April 13, 2017 interview with Mr. Zachary, did he say something similar?
I don't recall how much detail we went into him on that, but yes, from what I remember, he said the same thing. He had no point implicated Mr. Williams.
I'm going to ask you the same exact question, the same dates. We'll take them one at a time if it's okay with you. Start with the August 5, 2015 recording that you reviewed first. The tour bus shooting of a gentleman, phenomenal artist, Dwayne Carter, also known as Lil Wayne. You know who I'm talking about?
I do.
All right, that's April 26, 2015 date, the shooting of the tour bus?
April 2015. Yes, that's correct.
Okay. And is it fair to say that Mr. Zachary, at the August 5th, 2015 interview, you were not present for it, but you reviewed, said that Mr. Williams had no involvement in that whatsoever, and Lil Wayne, Jeffrey Williams idolizes Lil Wayne?
I don't remember, since I wasn't working on that case, but so I don't remember exactly what he said, but I do remember him mentioning it, and he did not mention that Mr. Williams was involved.
Same question for you, August or April 13, 2017. If it came up, tell the ladies and gentlemen jury, Mr. Zachary again stated Mr. Williams was not involved in the shooting bus of that tour bus.
That I don't recall it coming up during that interview.
Okay. Let me ask you this. Do you remember Mr. Zachary stating that Mr. Copeland was responsible for shooting TIG? Do you know what TIG Studios is? You know what I'm talking about?
Metropolitan Parkway?
Yeah, 675?
Mm-hmm.
Okay. Do you remember Mr. Zachary explaining that Mr. Copeland fired bullets into that establishment?
Objection, Your Honor. That's not.
Okay, I need you to speak up a little bit.
Objection, facts not evidence.
It's in the recording that was played for the jury, that was reviewed by Mr. Sprinkle And Mr. Abadi asked Mr. Sprinkle about that same interview.
It's not my recollection of how.
Sustained.
Do you recall Mr. Zachary stating that Mr. Copeland and Tay, do you know who Tay is? Tay, T-A-Y. I'm spelling T-A-Y.
Which Tay?
Threat.
No, I don't recall this.
You don't remember?
I do not remember this.
Do you remember Mr. Zachary stating that Mr. Copeland and another person were responsible for shooting Rich Homie Kwan's father at the barbershop? Different barbershop, not the January 10th, 2015.
No, I don't remember that.
Okay. All right. Let's talk about all the work that you talked about here and your studies, and I'm not mentioning everything, but your interviews, reviewing interviews, cell phone plotting, videos, all your work, okay? Then at some point, do you remember the date in 2018 you interviewed Mr. Kelvin Treadwell, O.J. Bentley? Do you remember that?
Which day was this again?
2018.
Oh, right. Yes, I do remember that. Yes. That was another matter, but yeah, I do remember it.
And do you remember stating that you can't understand why people think that Thug, I call him Jeffrey, had something to do with the killing of Nut, I call him Mr. Thomas? That doesn't make sense? That's the thing that always confused me about this case, because all these rumors started immediately that Young Thug had something to do with it. But yeah, then Young Thug put a picture of him on Instagram, Mr. Thomas. So I'm looking at these people saying, oh, you and Little Woody had something to do with it. The more investigated the case, the more I've investigated the case, I just don't, near as I could tell, Young Thug and Birdman were friends with Mr. Thomas or Nut. So I don't know why people say that he was involved.
Well, I recorded the interview.
I'm gonna play that one more time, y'all. I'm setting the scene. This is Investigator Sprinkle. He works. This is not just a witness, y'all. This is not like this is a DA. He's currently a DA. Now, when he was investigating this, I think he was a DA at that time as well. Investigator Sprinkle is a DA. He's like a colleague of Love and Hilton. And here, Brian Steele is quoting words from Investigator Sprinkle, who is investigating the Donovan Thomas situation. I'm using the word situation because of YouTube. And Sprinkle says, I can't understand why people think Thug had something to do with it. So this is Love and Hilton's colleague, co-worker, who is saying, I don't know why people are saying that Thug had something to do with this. Listen again. How is this not front page news? How is this not the biggest story out of the case last week? Sprinkle said, he didn't say it that day, he didn't say it last week, but Steele is reading Sprinkle's words where Sprinkle said, I don't know why they think Thug had something to do with this. Just listen up again, and then we're going to hear the way Sprinkle responds to this.
That you can't understand why people think that. Then at some point, do you remember the date in 2018 you interviewed Mr. Kelvin Treadwell, O.J. Bentley? Do you remember that?
Which day was this again?
2018.
Oh, right. Yes, I do remember that. Yes. That was another matter, but yeah, I do remember it.
And do you remember stating that you can't understand why people think that Thug, I call him Jeffrey, had something to do with the killing of Nut, I call him Mr. Thomas? That doesn't make sense? That's the thing that always confused me about this case, because all these rumors started immediately that Young Thug had something to do with it. But yeah, then Young Thug put a picture of him on Instagram, Mr. Thomas. So I'm looking at these people saying, oh, you and little Woody had something to do with it. The more investigated the case, the more I've investigated the case, I just don't, near as I could tell, Young Thug and Birdman were friends with Mr. Thomas or not. So I don't know why people say that he was involved.
Well, I recorded the interview, so I'm assuming that's a verbatim quote. I don't have everything I said during that interview memorized, but I'm assuming that, like I said, since you're reading from a transcript, that, yeah, I said that.
Y'all, Sprinkle just said that he said, I don't know why people think Young Thug had something to do with Donovan Thomas. Now, that doesn't get him all the way off of the Rico charges, but that is one of the, if not the biggest count on this indictment is Donovan Thomas. Thank you, Rachel, for becoming a YouTube member. So far, we've had, you got to tell me, is it C Lizzle or is it Clizzle? I'm going to say Clizzle. We have Clizzle, who's done 3 super chats. Much appreciated. We have Hyra. We have Alchemist. Oh, we have Alchemist. I'm just going to say Alchemist done a super chat. We have Rachel, who's become a member. Y'all, we have a few more minutes before we're back. We have about 4 minutes. I want to put this on, y'all. Oh, man.
Your child needs these 3 key factors to get into.
This is my channel, and they're running ads to me when I'm on my own channel. This is funny.
And he shoots, he runs by himself. In this parking lot, he's by himself.
All right, let's just watch this.
Sergeant Johnson, are you suggesting by your testimony just now that Christian Eppinger, when he was about to be arrested by this officer, that he shot Officer Rogers to increase his status in the gang and to get money for the gang? Is that your testimony?
No.
Okay.
It's not either or it's not both. It could be either or. In this situation, I would say the violence isn't increasing your status in the gang.
Or it could be just someone who was trying to get away from the police, right?
Yeah, could be.
And in fact, you're not in, I mean, I don't know Christian Eppinger. You don't know him either. You're not in his mind, are you?
No, I'm not in his mind.
Right. What you do know is that you see him in this parking lot. He's by himself, right?
When he leaves the group of 8 to 10 people at 221 Cleveland.
Yeah, I'm not asking you about 221 Cleveland. I just asked you about the apartment complex. He's by himself, right?
Objection, asked and answered, Your Honor.
Sustained.
You were asked about somebody named Durante Beebe.
Yes.
The picture that you were shown, the video, where was Durante Beebe in that video?
In the surveillance video, he wasn't in it.
He wasn't there, right?
No.
Okay. And so when you see Mr. Eppinger and he shoots, he runs by himself, right?
Yes.
Okay.
Yo, what was Adams on?
You hear him? Did you listen to the any of the videos, the body cameras, the dash cam, any of that?
No, I haven't had any audio.
Okay. While you were there and you saw this going on, and you saw him trying to get away from Rogers and shooting at Rogers, you hear him shout out anything like, "Hey, this is for YSL"?
No.
Yeah, it's funny, right? Because he didn't do that, did he?
Well, it's ridiculous. I don't think anybody would shoot a cop and then say this is for YSL. That's not how this works.
Right, right. And what is also ridiculous is you trying to determine that he was doing something that day to increase his status or to get money, right?
I'm not
Objection, argumentative.
Sustained.
Yo, Adams was going at him.
Bottom line is, your involvement here is you go to assist an arrest, and Officer Rogers tries to arrest him, and this guy shoots Officer Rogers, right?
Yes.
That's all.
Yo, Adams over. He was walking the line right there, y'all. Adams was on that line. He was on that line. He was on that line for sure. You got to tell me, is it C Lizzle or is it Clizzle? All right. But at any rate, thank you again for the super. When do you think they're going to actually show proof of Rico? Where's it? I don't know. That is the big question. I would think that they would have to show some kind of criminal conspiracy for some kind of gain. I was telling y'all the other day that I went to the Bahamas and we got off the ship. When you wanted to go from the cruise terminal to the town, there was only one group of taxis that were there and they set their price. Now, I'm not saying that's criminal, but you felt like it was criminal when they say it's going to be $100 round trip to just go like 15 minutes. You're like, what? $100? But that's because they set up a protected market where they obviously did not let other taxi cab drivers come in. They prevented other people from coming in because they would have taken you for probably $10 or $20, but they protected that area so that nobody else could come in so that they could name their price. Now, again, I'm not saying that's illegal, but it does feel like a racket as a traveler. When you get off that ship and you want to go to the beach or you want to go to the market or you want to go wherever, and they're like, it's going to be, whatever, they can name their price because they aren't letting anybody else come in. So that's the feeling you get with racketeering. Racketeering feels like a group of people who come together. They protect each other. They protect a certain kind of market. It's probably an illicit market, honestly, but they protect it for personal gain, for group gain, for money, for fame, for notoriety, etc., etc. They have not shown anything of the sort in this trial so far that I've seen. They have tried to elicit, like right here, where Adams was asking, so are you saying he was shooting at the cops saying this is for YSL? They haven't been able to do that. The prosecution has not been able to connect these acts of crime with some kind of conspiracy. To go back to the example with the port and with the taxi drivers, if a new driver tries to come in and somebody runs them off, that would be in furtherance of the conspiracy. Because you could say, well, they tried to prevent the new driver coming in because they wanted to protect their racket. Again, I'm not saying it's illegal. I'm just giving an example. So little crimes that are meant to protect this racket, this taxi racket, you will be able to connect it all back to something. What is that thing? They were making money off of setting the price and controlling the taxi at this port. We haven't seen anything like that in YSL. We haven't seen any money-making scheme. We haven't seen any kind of scheme for the furtherance of something of value. Yeah, like pharma, utility companies, exactly. Exactly. I mean, now there might be legal ways to do some of this stuff, but my point is that is where the prosecution is failing. And if they get a conviction today, not today, but in this trial, it's going to make it sound like, man, you could just do anything. All right, we're back finally, y'all. And we have Sam.
Can we get the state in, please?
All right, prosecution's not there, so we're not back.
All right, I assume we're going to be picking up with Detective Underwood. Okay. All right, if you want to go ahead and get her on the stand, we're going to get the jury out. Unless, let me ask, is there anything anybody needs to put on the record before we get the jury out and start with testimony again? Nope. Nope. All right. Okay, let's get Detective Underwood. And we can be getting the jury out as well. All right, the jury's going to be coming out also. I don't know. Sorry, I didn't write it. You know what? It's probably on this witness. Oh, you know what? It's Detective Underwood?
The volume
Oh,
is
maybe
all the
Ms.
way up, y'all.
Labonte's getting her? Yes.
Volume is all the way up. It could be just
No,
low in the
went out
court.
to get her. Good afternoon. Sorry to keep you waiting around. All right, thank you. Everybody can be seated, and we're picking up with Detective Underwood's testimony.
Good afternoon, Detective Underwood. How are you today?
Good.
All right. As soon as Ms. Knight gets set up, we're going to start with some defense exhibits that I want you to look at. Let me ask you this while we're trying to do this. Last week, you said that that some of the violence died down in about March of 2015.
Yes.
All right. I'm going to show you what's already been admitted as defense exhibit, Mr. Williams, number 19. Do you see what the cover of that says?
Rodeo tour,
And what's the year?
2015.
And I'm going to flip to, I believe, page 3 of that exhibit. What does that say?
Tour schedule.
All right. And can you tell Judge roughly when did that tour begin?
Look like Saturday, February 28th, 2015.
And when did it end?
Maybe it's the last date on this page is April the 3rd, 2015.
And prior to today, had you heard of this tour?
No.
Do you know Mr. Williams was featured on this tour?
I don't know. It just says rodeo tours, but I don't know who. It don't say who was featured.
I want you to go back to that tour date page.
Okay.
Do you see a stop on that tour for Houston, Texas?
Yes, March 23rd, 2015, Houston, Texas.
All right. I want to show you what's already been admitted as State's Exhibit 418Y. When you look at State's Exhibit 418Y, Do you see the caption on that picture?
Yes,
What is the caption on that picture?
we in Houston with this S word.
Okay. And are there emojis next to it?
Yes,
And are you able to tell what those emojis are?
snake emojis.
All right. And what's the date and time of this post?
9:43 p.m., 3/22/2015.
Okay. And in looking at that post, are you able to identify any of the individuals in that post?
Yes.
Okay. If you can. Permission for witness to step down?
Yeah.
And using this, the model board, you can just tell the jurors.
There should be a pointer somewhere and a laser
Oh,
pointer.
I got it. Just who you are able to identify now.
Vivian Darlington, Shannon Stillwell, Kelvin Treadwell, aka OG Bentley, Montavious Stevens, aka Tick, Jeffrey Williams, aka Young Thug. That's Demise McMullen, aka Nard. That is Antonio Sledge, aka Wintu. I'm not sure which sister this is. One of Williams' sisters. I don't know which one. He has a couple. I don't know who that is or that.
Okay, thank you. And did you say that the tour made a stop in Houston around that date?
Yes.
So based on this picture and the tour dates, is it fair to say that at least for this date in March, some people associated with YSL was in Houston, Texas?
Yes.
Now I want to go to what's been marked as the fence, I think Williams 220. And what we're going to do is we're going to scroll through Defense Exhibits 220A through XX. And as we scroll down, I want you to tell me the dates that are in January. And as you're looking at the dates here, and you can slow down a little. As you're looking at the dates, are these dates, let me know first, do they appear to be in chronological order?
I can't tell. My screen
Is
is not.
there a paper copy of this exhibit?
Right.
Would it be easier to let the witness look at the paper copy?
Well,
Unless I can make my screen a little bigger because it's kind of minimized.
And as I'm looking for the paper copy, if it's easier to turn around and look at the bigger screen to see if you can see the dates on the bigger screen.
I mean, I can see the date on here. It's just the actual window is not as big, I guess.
That's as big as it is on anybody's.
Yeah, that part is not. Is that all? Yeah, that one needs to be bigger.
But are you able to see the dates on the flyers?
I can.
Okay, we'll just keep scrolling until I can find the paper copy.
Okay.
Do they appear to be in chronological order as well?
Yes.
fine, Ms. Hilton. Y'all sorted out the issue with her
Yeah,
not being able to
I can see the
so
dates
she
on the
can see
flyers.
them.
It's just kind of smaller than what it probably should be.
And are these flyers now in the month of November?
Yes.
And now these flyers starting in December.
Yes.
Are we now in January?
We are in January.
Is this the first one in January?
Yes.
What's the date of this post?
January 18th, 2015.
And sorry, going back to this post, where is this show located, supposed to be performed?
Like I said, Tampa, Florida, at the bottom, maybe.
Is this another one in January?
Yes,
What's the-
January 21st.
And is that in 2015?
Yes.
Where is this supposed to be performance?
She moved it up a little. It looked like Santa Ana, California.
Are we still in January?
We in February now.
Okay. And I just want to keep scrolling down, see if we see anything else for January.
No, it's still February.
Now, I asked you earlier about the rodeo tour, remember?
You did.
Do you see the fence exhibit 220 KK?
Can she roll it up just a little, maybe? Okay.
And remember earlier I asked you who was on that tour?
Okay.
Who's on that tour, that rodeo tour?
Travis Scott and Young Thug.
And that's the same tour that's in the book that we just referenced a few moments ago?
Yes.
And where the group was in Houston, or where the tour stopped in Houston in March of 2015?
Yes.
Now, are we in March?
Yes.
Okay. Are we now in April?
Yes.
And are we now in June?
Yes.
And is that the 220XX? Is that the last of the exhibit?
Yes.
Were the only two January flyers January 18th and January 21st, 2015?
I think so.
Okay.
It wasn't very many January.
All right. Did you see any flyers for January 11th, 12th, 13th, 14th, or 15th?
No.
Did you see any flyers in Miami for the 11th, 12th, 13th, 14th, or 15th?
No.
Have you ever been to Tampa, Florida?
Yes.
Have you been to Miami, Florida?
Yes.
Do you know about how far the distance is between Miami and Tampa?
I haven't driven them. I know from Georgia, where my house south of Atlanta, it was like 10 hours when we drove to Miami, but I have driven to Tampa. It was like 6 hours.
Okay. So from Atlanta to Tampa was 6, from Atlanta to Miami was 10.
Right.
Now, in 2015, immediately following the death of Donovan Thomas, were there social media posts that appeared to threaten members of YSL?
Yes.
Can you describe to the jury the type of posts those types of posts?
Hearsay, best evidence rule.
Sustained as to best evidence.
Have you seen pictures of those types of posts?
Yes.
Permission to approach?
You may.
I'm going to show you what's been marked as Stacey Exhibit 546 Yankee. Do you recognize Stacey Exhibit 546 Yankee?
Yes.
How do you recognize Stacey Exhibit 546 Yankee?
I recognize it because back during the Operation Planners investigation, we actually had a war room at APD.
See the terminology? Don't take anything from the fact that they called it a war room.
It was like our meeting room.
I understand.
And we put all our pictures on the wall involving the Operation Planners investigation. So we would collect social media posts and we would put them all that was related to the actual investigation on the wall. So we had this particular one on our wall.
Okay. And does that appear to be a fair and accurate depiction of the one of the posts that you had on your wall?
Yes.
Your Honor, this time I say what I intend to say, Exhibit 546 Y.
Object under foundation and authenticity. Just because it's put on a wall does not mean where it was posted or found.
All right, sustained, but you may establish a foundation if you can.
Was this where were these posts?
On social media.
Okay. And was there a particular name or social media account that were posting these type of threatening posts?
Yes, I was named.
Reading from a document, not an evidence.
Sustained.
We're looking at that, refresh your memory as to what the name of the post was. Just look at it. If it refreshes your memory, look up when you finish.
Okay. Yes.
Okay.
The name of the actual account was Death to the State N-words.
And were there multiple posts on that website that you all gathered back in 2015 from?
Yes.
From that website. And is that one of those posts?
Yes, it is.
All right.
Your Honor, I'm going to maintain my objection, which was the same as Mr. Steele's, regarding the authenticity and foundation behind these posts.
Okay, overruled at this
and-
point. Go ahead.
My objection is we're talking about the collective, we did this, we did that, and I don't believe that this witness is the proper foundation for these posts. I don't believe this witness collected them.
Did y'all work together as a team to collect or view social media in order to assist with your investigation in this case?
Yes, we work as a collaborative group between Atlanta PD Gang Unit and ATF.
And as a part of this, is this one of the posts that you saw on social media at the time in which you all were investigating Operation Planters?
Yes,
And was this pulled from the site that you saw on social media?
yes.
All right, it's admitted.
Permission to publish, Your Honor.
You may.
And what was the nature of what the post would say? So not specifically, but what was the nature of the post when you all were pulling? And let me answer backwards. What made this of interest to the Atlanta Police Department?
I'll object to that phraseology. First of all, be hearsay and then talking for other people. I will object.
Sustained.
What was the nature of the post?
The nature,
Overruled.
actually, there were threats coming in right after Donovan Thomas's murder from this particular social media site, and it was towards only members of YSL. So it was significant for that reason.
Thank you. Now, after 2015, did you all continue to look at social media even after 2015?
Yes,
Specifically, I want to direct you to 2019. Did you have the occasion to look at a post of an individual standing on a car?
yes.
Permission to approach?
You may approach the witness freely.
Thank you. I'm going to show you what's been marked as Stacey did a 3TT. Without telling me what is contained in the picture, is that a picture that you've seen previously?
Yes,
And where did you first see this picture?
on social media.
And
Your Honor, I'm going to object to the authentication and foundation of this photograph. I don't think that this detective has the personal knowledge of who took the photo, who posted it. Whoever posted the photo should be the one laying the foundation.
Overruled. Go ahead.
And specifically talking about the picture itself, what was of significance, without saying what's in the picture, what was of significance of the picture itself?
Significance was disrespect from one gang to another.
Okay. And
Your Honor, I'm going to object to that response and ask it to be struck. That is beyond 24-7-704B. Talks about the significance of somebody's state of mind.
Sustained.
as a gang investigator, what was of note in that exhibit?
It was a individual standing on a vehicle.
Okay. And the vehicle, who did it belong to?
Objection, calls for speculation.
If it's within her knowledge, don't speculate.
It was Rayshawn Bennett's vehicle, YFN Lucci.
Okay. And the person on the vehicle, were they a member of, okay, were they associated with a rival gang of YFN Lucci's?
Yes.
Okay. And
Objection, Your Honor. There's been no foundation laid for how this detective has knowledge about someone's political.
Actually, yeah, there has. Overruled.
And it was that of note when you all first saw this picture back when you first saw it?
Yes.
You know, this time the state would like to admit Stacey Exhibit 3TT into evidence.
3 TT?
Yes, Your Honor.
All right, it's admitted.
Permission to publish.
You may.
Now, looking at Stacey Exhibit 3TT, is the car that you were just referencing this blue Maybach?
Yes.
All right. And was it of note of the individual standing on the vehicle?
Yes.
Okay. And do you know who that individual is?
Diamante Kendrick.
Okay. And again, was this posted on social media?
Yes, it was.
All right. As a gang expert, is there some significance of a person associated with YSL standing on top of a vehicle with someone associated with YFN?
It is significant.
I'll object under 24-7-74B about the significance of somebody's mental state.
All right, I don't understand it to be asking that question. Overruled.
What, if any, significance is that as a gang investigator when you see a post such as this?
It showed the, like I said earlier, the disrespect between, I felt like that this particular,
In your opinion?
in my opinion, this is a sign of.
Just a second.
Okay.
Your Honor, it's also calling for her to have.
She's been qualified as an expert.
I understand, but she's just because she's an expert doesn't mean she knows someone else's mental state.
And she's not testifying to their mental state. Overruled. Go ahead.
Working as a gang investigator and dealing with different actual rivalries and, you know, the gang problems that we have had in the city. When we saw this particular post, we saw that it was like a gang member taking a shot at another gang member by standing on his vehicle outside of one of our malls here in Georgia.
And what mall was this?
Lenox.
Now, we've spoken about this term gang culture. Can you just briefly explain to the jury, when we talk about gang culture, what, if anything, are we referencing when we talk about that term gang culture?
I think of gang culture as the behaviors, the actual gangs showing their characteristics, may it be whether they're displaying their hand signs, their colors, their tattoos, and just their way of life as gang members.
Can music be a part of gang culture?
Yes.
How?
A lot of the gang members, especially here in Atlanta, uses music to express themselves. They kind of, you know, talk about where they came from, how they came from it, things that they've done, their lifestyle in the music.
Do gang members sometimes use music to promote violence and fear of their gang?
Yes.
How?
Hypothetically, if gangs are beefing and even if they're local and they know that they listen to each other's music, they would take a shot. One gang would take a shot at another gang by saying disrespectful things or just letting them know that they are actually targeting them or talking to them through the words that they use.
Do gang members use music to promote allegiance to their gang?
They do.
How?
They brag about their gang. They glorify their gang. They glorify their gang members. They show the, like you said, alliances. It could be a blood gang that's, you know, really, really friendly with a Crip gang here in Georgia, and they will actually shout them out in music.
Do gang members use music to send messages to rival gangs?
They do.
How?
They send messages, you know, indirectly, maybe directly, just, you know, they might say, you know, I saw you at the club, or I jumped you at the club, and you are this gang, and they might call out that particular gang in the song, or they may not.
Do gang members sometimes use music to send messages to other members of the same gang?
I just want to note the way of objection under 704B. I believe this is all person's mental state.
All right, I don't think that anything I've heard so far is in contravention of 704B. You may have a continuing objection.
Do gang members sometimes use music to send messages to other members of the same gang?
Yes.
And do gang members use music to send messages to promote cohesiveness? So sorry. Do gang members use music to send messages to promote cohesiveness with their fellow gang members?
They do.
In your experience, what genre of music do gang members use to promote their gang?
Just from my experience, being here and working here in Atlanta for over 30 years, I've only seen the gang members use rap music.
Does it always have to be rap music?
It don't always have to be, but that's what I've seen over my career.
As a gang investigator, do you focus on music and hope that it leads to an investigation, or do you focus on the investigation and it may lead to music?
Sustained.
I'll ask first. As an investigator, do you focus on music?
No,
What do you focus on?
the crime at hand and the actual person that committed the crime.
And are there times in your investigation that music may have become part of your investigation?
Yes,
How is that?
because if it's a particular person that was maybe a singer or a rapper or whatever that may have committed a crime, that us looking at the crime, me looking at the particular crime will kind of lead me back to the music portion, or if they're a rapper, or if they, like a lot of gang members here in Atlanta, they call themselves rappers, but they're like studio gangsters, or they just put music out on YouTube. So we, even if they're not as big as most rappers, we still pay attention to what they're saying, the drill music that's going on, and because a lot of time it does lead to violence.
And you said drill music. What is that?
Drill music is kind of something new where the rappers, they kind of talk about, they rap about violence, and they mostly target, you know, the rival or the ops in that particular music. And it's really fast and really, you know, they actually, like I said, talk about violence, talk about firearms, talking about drive-by shootings. And that's been popular here in Atlanta as of recent.
And as you're listening to the music, are you in your mind thinking about your investigation and whether or not there are particular words in the music that match your investigations?
It depends. Every investigation is different. So if we do listen to it just to see if we can get any kind of, I guess, maybe confessions. Sometimes it's confessions in music, or any kind of thing that is said that relates back to our investigation.
Now, as an expert, I want to ask you a couple hypotheticals. If you heard a gang member sing a country song about putting 100 rounds in a Tahoe, and that song comes out a year after a rival gang member was gunned down while standing near his Chevy Tahoe, and that Tahoe was hit multiple times with bullets, would you consider that song in furtherance of the gang that gunned down that rival gang member?
Sustained.
Would that be consistent with something that's in furtherance of the gang? Not if you say
Overruled.
Like I said, each case is different, but if a country artist did do that and that country artist was a gang member, then yes, we would look at that gang member furthering the gang in that particular song.
what if a gang member had a calypso song where he said, I shot at his mommy, now he no longer mentioned me. And there was some information that members of that particular artist's gang shot at his rival gang member's mother's house. Would that be something that you would look at as being consistent with furthering the gang.
Same objection, Your Honor.
Overruled.
Would be element of the offense.
Reject this compound question.
Overruled.
Yes.
Now, when you're listening to songs, if they come up in your investigation, will the entire song be disrespect or have words of cohesiveness, or would it be portions of the song? What has your experience been when you were listening to the music?
My experience is it's not the entire song. It might be a verse, or it might be just a line or a couple of words or a few words.
In preparation for your testimony, were you asked to review 3 songs in preparation for your testimony?
Yes.
Mr. Steele? You're welcome. I'm going to show you what's been marked as State's Exhibit 535 Y Alpha, 539 Y Alpha, and 537 Y Alpha. And tell me if you recognize those as the songs that you were asked to listen to.
Yes.
First, starting with 535 Yankee Alpha. What is the name of that song?
Slime, S-word.
And who is the artist?
Young Thug.
Now looking at 537 Yankee Alpha, what's the name of that song? Oh, excuse me, 539 Yankee Alpha.
539 is gonna be Just How It Is.
And who is the artist?
Young Thug.
And then looking at 537 Yankee Alpha.
It look like it says Juice WRLD, Bad Boy featuring Young Thug.
Your Honor, this time the state would like to tender and admit State's Exhibit 535 Yankee and Yankee Alpha, 539 Yankee and Yankee Alpha, and 537 Yankee and Yankee Alpha.
What are Yankee? Because all she's testified to is the Yankee Alphas.
The actual song. So was 535 Yankee the song that you actually listened to prior to?
Yes.
Okay. That's true for each of those.
Is 537 Yankee the actual song that you listened to?
Yes.
And is 539 Yankee the actual song that you listened to?
Yes.
Your Honor, this time the state would like to tender and admit State's Exhibit 535 Yankee and Yankee Alpha, 539 Yankee and Yankee Alpha, and 537 Yankee and Yankee Alpha.
All right, those are admitted.
Same objection, Your Honor.
Overruled.
And permission to first publish 535 Yankee.
You may.
Stacy Exhibit 535YA. When did this song come out? Or when was the song at least posted on YouTube?
March the 25th, 2016.
And as an investigator and an expert, were there any particular words of note to you as you listened to this song?
Yes.
What were those words of note?
The 100 rounds in the Tahoe.
And why was that of note to you?
Because 2015, the year prior, we had investigated murder of Donovan Thomas where.
Hang on just a second. Yes, sir.
I'm going to check this point. This court, the trial court in this case, has previously ruled that.
Do we need to take this up outside the presence of the jury?
Yeah.
I'm going to excuse y'all for a minute, please. And Detective, I'm going to ask you to step out, please. Thank you. Go ahead.
Thank you, Your Honor. So there's a previous order in this case bifurcating that any expert who would be on the stand in this case, who would also be providing factual testimony.
Oh, yeah.
That would be
Splitting out the factual and the
And
expert.
so, yeah, and this witness is now, she's given expert opinions, which we've heard, but now she's testifying about factual information. And I think that's going to mislead and confuse the jury. And even if Your Honor doesn't believe so, there's a previous order that in this trial, we would have a bifurcation of those issues. So I'll object to her testifying about any factual information about what happened in 2015. I also think that I also want to raise an objection because the state has proffered this evidence as something that happened in 2016, when in fact, I think the state is misleading the jury because this particular song that they've now introduced to play with the jury was actually recorded 2 years earlier in 2014, prior to any murder of Donovan.
All right. Well, you'll be able to cross-examine on that. Can you address the issue of the bifurcation?
Yes,
I
Your
mean,
Honor.
not address the issue. I know that was the order. Address why this is or is not violating that requirement that the fact and expert testimony be bifurcated.
Your Honor, there is evidence already in about the shooting of Donovan Thomas. I believe as an expert, I could simply ask her, I can probably show her the evidence, the pictures of the evidence that we're discussing at this point to make sure that we don't violate her talking about her opinion as to why this song was significant.
Mm-hmm.
I'm thinking through when we have a medical examiner who is an expert, who can talk about the facts of the autopsy and give their opinion as to the cause and manner of death, that this is similar in nature, that she as an expert can speak to specific facts and give her opinion as to why that particular fact is of significance in her opinion. And so that's what I'm trying to correlate it to, very similar to a cell phone expert who can talk about the facts that come out, but can give their opinion on certain information. I'm trying my best to correlate how we can do those two things, because I do think an expert can speak of facts and how those facts can form an opinion.
All right. So are we finished with the portion? Has this witness testified to all of the facts that she's going to testify to as a fact witness?
Yes.
Okay. And so whatever you were about to elicit was
information that has already come out, but we're not.
right. I mean, you were getting an expert opinion on something?
Yes, sir.
Okay.
If the state proffers that they're going to stick to asking about expert opinions, then I'll withdraw the objection. It certainly sounded like to me She was asking about factual evidence about an incident in 2015.
Okay, but you're not establishing that fact through that witness. You're asking, why is this fact significant to you?
Yes, Your Honor.
Okay. I don't think that violates that bifurcation order. All right, let's get the jury back and the witness. Is there anybody that knows that we need the jury back? I don't know. I think.
Yo, that lawyer standing in for Weinstein is sharp.
We surprised y'all with a short break. All right, thank you. Go ahead, Ms. Holton.
So I think when we left off, I was asking, what was of note to you in that song?
The 100 rounds in a Tahoe.
And why was that, as an expert, of note to you?
Because of the murder of Donovan Thomas. When he was murdered, he was standing outside of his Tahoe.
Okay. I'm going to show you what's already been admitted as 6 Exhibit 8Y. I'm going to also show you what's been admitted as 6 Exhibit 12Y, 27Y, 26Y, I'm sorry, 218Y, 174Y, 193Y, and 221Y. Is that the Tahoe that you were just referencing?
Yes.
Okay. And why was that of note because of that particular wording in the song?
It was because it was actual crime that was committed with a murder happening, and the fact that it was a rival between the two. It was a rival between the YSL crew and the Inglewood Family Bloods crew. Donovan Thomas was an Inglewood Family Blood, and it was significant for us in our investigation.
And when you were talking earlier about sometimes gang members use music in order to Make sure we get the language right. In order to send messages to rival gangs, is this an example of that type of messaging?
It is.
Overruled.
Is
It
that-
is.
Okay. Was there anything else of note to you in this particular song?
I think the part about killing 12.
And why was that of note?
Because the police is referred to as 12. And if you're, I guess, rapping or singing about killing somebody in law enforcement, that's not nice.
And let me ask you, this was in 2016. Were you aware of any incidents of YSL members alleged to have shot at police after 2016?
After 2016, yes, we had a police officer shot, a gang officer shot.
Objection, Your Honor. Same objection I raised previously.
Sustained.
Y'all see, that was factual. That was not expert. She walking that line, y'all. She's walking that
Was there
thin
anything
line.
else of note to you in this particular song?
If you can refresh my memory with a copy of the lyrics, maybe.
I'll get you a copy because I think my copy has writing on it. My copy has writing on it, so we'll get you a copy. We'll go to the next song while we're getting you a copy. I'm gonna go to State's Exhibit 539Y. Is that just how it is?
Yes.
Permission to publish, Your Honor. When was this released on Mr. Williams' YouTube channel?
September 16, 2019.
What, if anything, was of note to you in this song?
We killed the biggest kitten of all kitties.
And why was that of significance to you?
Again, it reflected us back to the Donovan Thomas murder. He was a big person for the Underwood family, Bloods. He was a high-ranking member, well-known, well-respected, I guess, among his gang.
Overruled.
Was there anything else of note to you in this song?
It was a part about I did the jacking and the robbing. Now I'm rapping.
Okay. And let me ask you specifically, in 2013, were you made aware of any robbery in which Mr. Williams was a person of interest?
Yes.
Okay. Did one of those involve an Archillian Bennett?
Yes.
Okay. Yeah, we can approach.
Yeah, I think y'all might need to.
You know, I see that, Andre. I see you talking about the part where he almost got popped in Lennox, but that part, I'm curious to see if they're going to talk about that, because that doesn't really sound like a crime. Somebody almost getting popped at Lennox seems like, one, it would be hard to prove, but who knows? Maybe they have more evidence, so we'll see what comes out. But it doesn't sound like you can get arrested for having in your mind, I could have popped him. So I'm not really sure. They might bring it up, but I would probably object to that unless there's more evidence about that, because like, how could somebody almost getting popped at Lennox factor into the trial if you didn't do anything to them, they didn't do anything to you, etc. So that would be my thought on that one. There have been shootings at Lenox Mall, right? But the lyric says almost got popped at Lenox. The lyric does not say we popped them at Lenox. If the lyric said we popped them at Lenox or something like that, it would be different. But I'm not sure how the prosecution could use an almost, unless they have a video associated with it or some additional evidence. So we'll see. Do they have additional evidence to prove that this almost happened? Because you're always going to have evidence, not always, but the fact that something happened demands evidence. But the fact that something almost, well, everything almost happened. Everything that didn't happen almost happened, right? So, oh, there's a video. Andre said there's a video. So now if there's a video and they have it, okay, so you're saying they're talking about the time that they were standing on his car? But is there video? Okay, all right, cool. So we'll see. Yeah. Now that would be different if they have video evidence of a confrontation or something like that. Then that's not gonna be good. Ross says lyrics can have double meanings. Yeah, I mean, this is back to our conversation. I don't know if you were on earlier, but we had a long, extensive, probably 45-minute long back and forth about this. Lyrics are gonna come in, y'all. So, it just is what it is. It makes sense to me in certain situations, but I'm not gonna go back through my whole rationale for that. In broad daylight at the mall, doubtful there was even a real thought or plan. Plus, I don't know that establishing that one song said something about something that was real that happened means that everything in every song references something that was real that happened. So I'm not really sure how that lines up. I mean, the fact that a song references something real doesn't mean all of the songs that say something are talking about something real. This video and social media post where Yak stood on Lucci car. Remember that? He got mad and tried rushing out and someone almost getting popped. Hopefully, yeah, that's not good. I do remember they brought up so the jury just saw that image last week, but they were supposed to forget. They were supposed to forget about that. Should not even be making music with references to popping and violence. What's wrong with us? Trying to justify facts that record labels. I would agree if there's something that happened, but these artists, they just flow. And I'm not justifying it, but it seems like for sure it's a better idea not to include these references. But I think this stuff is part of their artistic flow. Damn, he's for sure pissed off right now. I've been someone kid born in jail while, but he's hollering all day until they move. Not sure who you're talking about there, Sam. Zeno, yes. So that's why the state brought in Diamante Kendrick. Okay. Well, let's see. Let's see if they talk about it. Yeah, I don't get the cat and kitten thing. I don't get that either. It might have rhymed. See, that's the kind of thing I was talking about earlier where I was saying that you need to use lyrics in good faith. This is definitely tricky. Andre, what is this? Is this a let me see what this is. Sorry about that. Oh, okay. Yeah, let's play this. Oh man, hold up. This is a long video. Andre, can you give me a timestamp on this, man? Can you give me a timestamp on this? This is a kind of a long. This is a Trap Lord Ross video. Let me see if I could fast forward it and see. If you can give me a timestamp, that would be good. All right, here's Lucci. I mean, here's
I want to buy your
oh my
house.
gosh.
I can pay you cash for your house, no matter what
All right,
condition it's.
skip that.
Fuck niggas in the mall. These niggas ain't say shit, nigga dolo. I go outside, folk gotta tell me niggas standing on my car taking pictures.
Now, a month after this, for a moment, it.
All right. Let's back it up a little.
Damn. Yeah, that shit coming out 15,000 to get fit.
Now, a month after this, the battle for Lennox Mall is reignited when YSL member Yak Gotti posts a picture of him standing on the back of YFN Lucci's 650 Maybach convertible parked outside Lennox Mall. In the picture, he is flipping off Lucci, but that's not all. Yak Gotti decided to take this disrespect to commercial levels, using the photograph of him disrespecting Lucci and his Benz as the front cover for his YSL Records single, In a Coupe.
All right, y'all. I'm not trying to get demonetized, so we're gonna leave it at that. Plus, Court is back. Thank you for that, Andre.
All right, go ahead, Ms. Hilton.
So before we broke, we were talking about an incident May. Oh, sorry.
Go ahead. I'm sorry. Go ahead.
Okay. All right. I'm going to show you what's been admitted as State's Exhibit 1AA. And you were speaking about brief. Do you know where this is or the location?
Look like Trussell Tree.
Okay. And are you aware of an Archillian Bennett?
Yes.
Okay. And I think you were talking earlier, based on your review of reports and information that you gathered as an expert, were you aware of a robbery of Archillian Bennett in May of 2013?
Yes.
Excuse me.
Sustained.
Were you aware of a police report involving Archillian Bennett?
Yes.
In which she alleged to have been robbed in 2013?
I object to what she said. It's a leading question and it's facts and evidence. Jury already heard from you.
So I'm trying to narrow down the issue so we can get to the answer as an expert that she's reviewed and she's aware of
All right.
this.
So the jury will recall what the prior testimony was. Go ahead.
And as a part of that, are you aware who was a person of interest in that armed robbery?
Yes.
Who?
Jeffrey Williams.
Okay. And I'm going to show you what's been admitted as 23AA. Are you familiar with the individuals in that picture?
Yes.
Okay. Who were the two individuals in that picture?
Look like Jeffrey Williams and DK, and his name's not coming to me right now, but his nickname is DK. He's a YSL member.
Okay. Does the name Walter Murphy sound familiar?
Walter Murphy, yes.
All right. Now I'm going to also publish for you what has been marked as 170 or admitted, excuse me, as 175C alpha starting at 4 minutes and 12 seconds.
Hello, this is a free call from
Adrian.
Hey.
So you got minutes on the phone. Bro, what's up, man? What to do, Brody?
You alright?
Hell yeah, man.
I just talked to a nigga thought, though.
What they talking about?
Shit.
Man, know how that nigga, man, them nigga that got a nigga killed, boy.
Fuck you talking about, man? I seen
Little
that
nigga
shit,
DK,
man.
little nigga DK shot at 12, nigga.
Yeah, he said it.
For no reason, boy. He shooting for no
Nigga
reason,
said-
though.
That's why they started shooting that child.
Man, that nigga just start busting for no reason. Call the little young guy there. I'm like, hell no, boy. Hit Big Fred, hit his ass. Me and Thug got there. We get out the car and run. I just went the wrong motherfucking way, man. I should have followed Thug there.
Fuck that
Everything
wall.
happened for a reason, though, man. They got to get this shit off his back anyway.
For sure, bro. Yeah. Hello?
Yeah, I'm here.
Yeah, man. Damn, bro. We had to go like that, man.
Nah. Everything for a reason, though, man. You know what I mean? It was all set up. I did the same
What
thing
they
I did. Sit around, goddamn, last night, goddamn, talking that bullshit. But I ain't gonna never goddamn do it like this. I never do this, man. Can't no
What they got you charged with, bro?
Shit, but little punk ass little driving license, suspended license, a little charge, goddamn, the aggravated assault. I ain't charged with none of that shit today. I could have gave AC name and been at home child, man.
Yeah, that's what I thought you did. That's why I kept telling the store, don't tell them
I
the
just
name.
know that I was a victim, man. I had to take out robbed, man, and they was shooting at me, and I was running for my life.
For sure. That what's up, nigga. Cause goddamn, I ain't see DK them pull out on that boy. All they know is Red. That nigga Red was trying to rob y'all.
Yeah, that's what they said, too.
For sure. They just let that nigga out, though.
Around, man.
They just let that nigga go, bro.
Yeah, they let the nigga go, man. Me and that nigga, he ran. I wasn't too far from him.
Nah.
He went to Mickey D, nigga. I went from around the laundromat to goddamn that Dollar King over there, trying to make it over there through Little Haiti for Cleveland E, goddamn, up through the top of that, and I gonna hit Jamal in my old apartments, goddamn, go down there and chill with Big Nick, you know. But shit, man, that whole goddamn come out of nowhere, boy, run me clean over.
That was goddamn, that was thug, man.
Big Nick out.
Yeah.
I hit you with the car.
Yeah, they ran me smack ass over, man. My mom broke my goddamn collarbone and shit, man.
You alright though, ain't it, bro?
Big ass knot on the back of my head.
That nigga skate brought the police back to the spot, bro.
He did.
Yeah.
Okay.
Hey, you went up there trying to get the fucking car?
Yeah, they what they call him? Bring him to the person who he let the car to.
Nah, he's my goddamn. I've been down here chilling with Bean. He been staying down here and all this and shit.
Them folks car fucked up.
Yeah.
You don't even look like a nigga to survive in that motherfucker.
Fuck you so much, nigga.
That shit,
alright, man.
that shit breaking news all day long, man. It's like that vivid on news all day long.
I'm on the news?
Yes, sir.
My picture and everything?
No, they just show you get in the police car.
Oh, shit, man. I made the news.
Well, that shit everywhere, man.
Damn.
Yeah.
Man, they look it out, man. They don't, like I said, everybody have for a reason, though, man. Fuck it.
For sure,
I
bro.
don't know
Get this shit out the way,
do
man.
shit with nigga like that anyway, so.
For sure, man. That what don't make sense, man.
Like, I can't even think about this. All I been thinking about all that, like, just told babe, you know what I'm saying? Like, this shit crazy. This shit don't even seem real.
Fuck, man, broke over these niggas, man.
You drive your own shit. I don't give a fuck what's going on. You feel what I'm saying?
Because, like, nigga, you just stay here. We went to Ken shop first, right? But you know, when you see shit, man, you gotta go on and get that shit. You know what I'm saying?
Like, go on and get, bro. I said the same thing.
Man,
Gotta go
when
on
you
and
see
get
it, you
it
gotta go on and get it right then. Man, we got them going back to the Ken shop. Okay, they coming out of Ken shop right there by the Chevron. Boom. Damn, man, they ride. I see them, I turn around, I'm following them nigga. I follow them nigga all the way up there on Summerdale. So, okay, cool. Soon we see the tire. I said, give me a chance and let me see what the fuck this is in the tire first before you even get out the car, DK. Man, that nigga done hopped out the car, man, and just started busting. Wow. 12 goddamn bag up, turn around, bag up. Niggas by that time now trying to turn around and get up out that motherfucker. They run and hit me. Boom. Bump the car. I run clean through the goddamn gate, through Summerdale on the opposite side. Boom. He shooting through the car. Boom, 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 boom. Man, I'm talking about, man, I'm talking about bullet car sprint clean through the window, boy, down like it had went through my head, boy. I got came through my head and came out my face, boy. Bullet car clean through that motherfucker. Boom. Then I believe one of them niggas in the back shot big club, man.
Big police shot.
12 shit, big club, DK had to shoot that nigga because 2-3 shots went off with the car. And we were jumping them hills and shit. So I was like, damn, boy. After we prayed, I'm glad one nigga didn't just hit me in the head and shoot me, boy, because nigga ran.
That nigga thought they got down Big Fred got out of the car. The police shot. They were still shooting.
Nah, that nigga probably shot Big Cook. Him, Big Fred, and goddamn DK had to scrap. I wouldn't even scrap my 22 at home and my AR in the trunk. You get that $150 out the cup holder, bro?
Huh?
You got that $150 out my cup holder?
No, so he had $150 to go buy the lane.
Nah, man.
Well, no money in the cup holder, bro.
Oh, my motherfucking money.
Yeah, he said he had the money to go buy the lane.
Nah, I think I had another $50, $40. He didn't have that because DK didn't even get him his 50. All that money was mine, and money came out of Buck hands. Well, he ain't had no business doing that. He made Buck goddamn come off 100. I told him, hell no, nigga goddamn go 50. You go 50.
Nah, Buck told me, you don't harm the fit.
No, they gave me nothing. I had a fit of my own money. I had $350. They got $340, $5. I got to let Babe come down here and goddamn go to property and get that shit. Come down here and find a piece of paper. I got to fill out a property release form or a waiver form.
And we're going to stop it at 10:46. In 2013, and have you looked at any reports of a armed robbery of an individual by the name of Derek Dotson?
Yes.
And who was a person, or who were some of the persons of interest in that particular case with the armed robbery of Derek Dotson?
Your Honor, can object on the bifurcation issue.
This
Overruled.
Confrontation clause, Your Honor. This is legal report.
Overruled.
Jeffrey Williams and Walter Murphy.
Have you heard of the name of Adrian Bean?
Yes.
And what about an individual by the name of Frederick Prothrow?
Yes.
And to your knowledge, was Mr. Williams ever charged with either the two incidents we just referred to?
No.
No, he was, or no, you don't know?
No, he was never charged.
Okay. Next, I want to go to 537 Yankee. What is the date of the release of this song? Or at least when it was posted?
Said premiered January 15th, 2021.
And were there any particular words of note to you in this song?
Yes.
What was that?
I shot at his mommy. He no longer mentioned me.
I'm going to show you what has already been admitted as 1 triple DI. Are you familiar with what that location is?
Yes.
And where is that?
That's 1007 Hill Street in Atlanta, Zone 3.
And how are you familiar with that location?
That location was YFN Lucci's mother's residence during the time that she was a victim of 2 drive-by shootings.
And would it be of note, hypothetically speaking, if the drive-bys were purported to be by members of a particular gang whose gang member wrote a song or sang a song that says, "I shot at your mommy, now you no longer mention me"?
Yes, that would be significant.
Overruled.
Why would that be of note?
Because it actually happened. It was a real crime that happened where the rival's mama was shot.
Showing you,
You understand the bifurcation
Yes.
issues, so.
I'm going to show you what's already been admitted as 4 DDI. And 5 DDI. 6 DDI. 8 DDI. 11 DDI. And I want to also show you 1 GG. Is that the same location?
Yes.
Okay. I'm going to show you 3 GG. Showing 6 GG. 14 GG. 17 GG. 20 GG. And 26 GG. Again, as an expert, what if there's a word such as "I shot at your mommy" and you no longer mention me, and you see particular evidence of that when you're doing your investigation? For you, in your opinion, what if anything, is being communicated?
Sustained.
Why is that of significance to you?
Because
as an expert, why is that of
I
significance?
don't know what the answer is going to be, but it is potentially going to be a 704B issue. So
I I'll move on, Your Honor.
All right.
Now, we spoke about the first song, Slime S, and you said you wanted to look at the lyrics to see if there was anything else of note to you. Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as 535 YB. Would that help refresh your memory to look at those words?
You ready for me to answer?
Yes, I'm sorry.
Just looking at the words, as far as significant for gain or furtherance of gains, the part about the neighborhood
Hold on.
60s.
Consistent with being, just what is of note to you without talking about whether or not
Just
that's
some
further?
lyrics about neighborhood 60s and troop and stuff like that.
What is the significance of Troop?
Troop was a NH60 leader in over off of Old National Highway.
Okay. You said an NH60.
Neighborhood rolling 60.
Okay. I want to ask you a few more hypotheticals and then we'll be concluding. Hypothetically, if there was a member of a gang who shot at or in the direction or shot a gang investigator that was trying to arrest him, and this person shot at him multiple times, would it be of any significance to you as an expert if there was a song by a member of that same gang and in that song it says killing 12? Would that be of any significance to you hypothetically as a gang investigator?
Your
as a
Honor,
gang?
I think so.
No, Your Honor, that was the one that you sustained it earlier for mentioning that Mr. Apt objecting, you sustained it earlier.
That's incorrect.
He asked.
You sustained a different objection I made. She was allowed to testify about her opinion about 12, and it's been asked and answered.
Sustained.
And I'm not talking about the word 12.
Sustained.
Okay. Just generally speaking, when you talked earlier about how the music plays a role sometimes in your investigation, again, are you looking at to see whether or not there is some information that may or may not support any music that you may listen to, that you may find as a part of your investigation?
Objection to our investigation and the contours of it is irrelevant.
I'm sorry, say that again.
I object to
The premise of her investigation. She can testify to facts. She can't educate the jury on what's important to her.
Okay, can you rephrase the question, please?
Sure. As a gang expert doing your work with gangs, if music becomes a part of your investigation, does it become important if there is any type of evidence or information that support what may be contained within the music?
But the same objection, knocked down a Ken's the jury anyway.
Sustained.
As an expert, was shooting at a police officer, and could that increase the status in a gang?
Yes,
How?
it shows your the other gang members that you are willing to put in work for the gang, put your life on the line, because sometimes if an officer fires back, then you can be killed. So you will risk your life for the gang. But if you can do it and get away with it, you get stain. And stain, the definition of stain is you get like not really rank, but you can get like appreciation, or you can get, street creds. With a lot of the gang members are looking for to be get street creds, not only from the higher ups in the gang, but from the gang members that they, roll with, or even just from the public.
Thank you. Court's indulgence for a moment.
Anybody comment on that getting stain? You can get stain. I never heard that before.
Cross-examination.
Never heard of getting stain.
Yes, Your Honor.
All right, go ahead.
Good afternoon.
Good afternoon.
May I ask you some questions?
Yes, sir.
Go and ask this. All right. I want to talk with you about Jeffrey's music.
Okay.
And how many total lyrics or songs has Jeffrey Williams made?
I have no idea. I don't keep up with it. I'm sorry.
No, that's okay. And you may have the same answer, so I apologize. How many songs or has he put out, or a record label put out for public consumption, besides how many were made, if you know?
I don't know.
I'm not just including it to you, I'm expanding it to your coworkers, your team, the prosecution team. Do you know if anybody ever had that type of information to your knowledge?
I don't think that was relevant. I think the actual relevance was the things that were said.
I think she's using it in the lay term of the word. So overruled.
I don't even understand. Okay.
You can continue.
I was just saying, I don't think that we targeted the music per se. I think it was just certain songs. We didn't try to keep up with how many songs were released over the years, or it was only particular songs that stood out, that had certain lyrics that kind of either taunted the other side, or, like I said, it's when you rap about stuff that actually happened, we paid attention.
Did you ever look to like a pattern? How many times in Jeffrey Williams songs, I'll just leave it at his, then I'm going to broaden it, but how many times did he talk about, you know what a lick is?
Yes.
Just tell the jurors, they probably know. But
A lick could be a jacking, a robbery, or putting in work. It could be a smash and grab. Anything to get money, it can be considered a lick.
how often in Jeffrey's music does he use poetry to talk about licks?
Like I said, I don't listen to the music that much just to be an expert on his music. These couple of songs, he talked about licks, but I can't tell you definitely how many times, but I understand that that was a way of life for him and that he.
John, I have a motion.
I'm going to excuse the jury and I'm going to excuse you, please.
Dang, he already dismantled this lady, yo. He already dismantled her, y'all. And you know what Brian still needs to say, in my opinion? How did you find these particular lyrics? Did you listen to all of his songs? Like, what was your process for identifying lyrics that you found interesting as it relates to your case? I really need him to get into that. Or somebody on the defense.
Yes, sir.
Your Honor, my belief is that I was asking about Mr. Williams' music and how often he would sing about or use poetry about licks. And the answer that came out is that is his, and I'm not quoting it, but so if I'm wrong, please apologize, but it just happened. I believe that's his way of life, something to that effect. I believe that's character. This is a gang expert. This is a 10-year, 12-year police officer, gang unit, ATF affiliate, and it's just repetitive. We just had the same exact issue come up with the former retired Detective Dennis, and I just don't understand. You know, I'm asking questions. I did not invoke character, and I get that's his way of life. Whatever the quote is. Okay, Mr.
I understand that was a way of life for him. Also, in the same answer, she's talking about not being an expert on his music. And I know she mentions lick as well. I don't think it comes anywhere near what happened with Investigator Dennis. I think that's a kind of vague, I do think it's somewhat non-responsive, but a vague answer that doesn't cross the line in the way that what Investigator Dennis said in his testimony, but I will have her back and instruct her, which frankly she ought to know better anyway. But I do think it was kind of vague enough and wrapped up in enough other things. I'll give a curative instruction if you all would like, or we can just move on. Or you'd prefer.
I would just ask for the mistrial. I believe it'll be denied, and that I could preserve it with a curative instruction. Yes.
Okay. We need to probably take a break as well. So if you want to work on curative language, I'll just be a couple of minutes and then I'll be back to consider potential curative language.
Okay.
And if y'all want to get together on it and come up with something that y'all agree to, fantastic. If not, just work on what you think would be appropriate, and then I'll take it into consideration. Let's take our break as well right now. And can you please instruct the witness to stay as far as possible away from things like that that might get into bad character evidence. Thank you.
Thank you.
We'll take a quick recess.
That was amazing, y'all.
10 minutes long. I'll be back before then.
Thank you.
That was amazing that Brian still caught that. And I mean, of course, that's his job, but I think he has. I think Judge Whitaker is wrong right here. I think she's wrong. I don't think it was wrapped up in enough stuff. I think, yeah, nah. Brian still was right. He was right, and I didn't catch it like that. Of course, it's not my job, but nah, y'all. I think Judge Whitaker dropped the ball right there, y'all. What happened? And Ward, let's reverse it. Let's rewind it real quick. We have a few minutes. I'm going to bring it back.
Williams made?
I have no idea. I don't keep up with it. I'm sorry.
No, that's okay. And you may have the same answer, so I apologize. How many songs or has he put out, or a record label put out for public consumption, besides how many were made, if you know?
I don't know.
I'm not just including it to you, I'm expanding it to your coworkers, your team, the prosecution team. Do you know if anybody ever had that type of information to your knowledge?
I don't think that was relevant. I think the actual relevance was the things that were said.
I think she's using it in the lay term of the word. So
I don't even understand. Okay.
You can continue.
I was just saying, I don't think that we targeted the music per se. I think it was just certain songs. We didn't try to keep up with how many songs were released over the years, or it was only particular songs that stood out, that had certain lyrics that kind of either taunted the other side, or, you know, like I said, it's when you rap about stuff that actually happened, we paid attention.
Did you ever look to like a pattern? You know, how many times in Jeffrey Williams' songs, I'll just leave it at his, then I'm going to broaden it, but how many times did he talk about, you know what a lick is?
Yes.
Just tell the jurors, they probably know. But
A lick could be a jacking, a robbery, or putting in work. It could be a smash and grab. Anything to get money, it can be considered a lick.
how often in Jeffrey's music does he use poetry, talk about licks?
Like I said, I don't listen to the music that much just to be an expert on his music. These couple of songs, he talked about licks, but I can't tell you definitely how many times, but I understand that that was a way of life for him, and that he...
John, I have a motion.
Yo!
I'm going to excuse the jury.
That was big, yo. He heard it right away. I understand that. Y'all, I kind of feel like people let her into that, y'all. He was ready for that. He playing the game, y'all. Brian Steele is playing the game, and he said, I'm gonna set a trap, and if you fall, you fall. I mean, I don't know. This is my take on it. It's like, are you really a professional? Are you really know what we doing in here? How often did he talk about that? A lot, because that's what they was doing, Your Honor. Your Honor. Yeah, it looked like he set her up, which he should. That's his job. What did she say?
Your Honor, my belief is that I was asking.
What she said was that it was a way of life for him, for Jeffrey, which is Young Thug, that he lived the life of a stick-up kid, of a robber, of a thief, of a person who's looking to make money illegally, to hit licks. Hit licks means to get money illegally. So she said that was a way of life for him. That is an inappropriate testimony, particularly by a current or former police officer. That's what got Dennis in trouble. About
Mr. Williams' music and how often he would sing about or use poetry about licks. And the answer that came out is that is his, and I'm not quoting it, but so if I'm wrong, please apologize, but it just happened. I believe that's his way of life, something to that effect. I believe that's character. This is a gang expert. This is a 10-year, 12-year police officer, gang unit, ATF affiliate, and it's just repetitive. We just had the same exact issue come up with the former retired Detective Dennis, and I just don't understand. You know, I'm asking questions. I did not invoke character, and I get that's his way of life. Whatever the quote is. Okay, Mr.
I understand that was a way of life for him. Also, in the same answer,
He got her
about not being an expert on his music, and I know she mentions lick as well. I don't think it comes anywhere near what happened with.
I disagree. Y'all know what? I disagree strongly with the judge. I think this is even stronger. I think this is even stronger than what Dennis said. Dennis said that Yak Gotti had just come out of prison. This lady said that Thug lived a life of basically a robber, thief, etc. You can go to prison for something you did wrong. But living a way of life of something is, you can go to prison because you did something, but you don't necessarily have to have lived a lifestyle to go to prison. You can go to prison for a mistake. Living a life of something is not, we don't typically chalk that up to a mistake. It might have been a mistaken way to be, but that's a being. So I think this goes further than what Dennis said. And I think Judge Whitaker is wrong. They're both gang experts. They're both former police officers, former detectives. They both should have the same level of knowledge of what to say and what not to say. I disagree with Judge Whitaker. I disagree with her. Plus, you know why Whitaker can't agree with Brian Steele? Because in Yak Gotti's case, he's a felon, convicted felon. Young Thug is not a convicted felon. So if she were to agree with Steele, this trial would be over today. If she were to agree with Steele, this trial would be over because Thug is not a convicted felon, I believe. Yeah, he has no record. So therefore, the way that Judge Whitaker was able to get out of calling the mistrial with Yak Gotti is, okay, well, yeah, the Detective Dennis did mention the coming out of prison, but he's charged on this indictment with gun possession by a convicted felon. So the jurors were going to know either way that he, at least is a felon, probably went to prison because that's what sends you to prison is a felony. So though it was bad, it wasn't that bad. In this case, she's saying that Thug was living a felon's way of life, but Thug doesn't have a criminal record. So therefore, if she were to agree with Brian Steele, then she would have to call the mistrial. If she were to agree with Brian Steele, she would have to call the mistrial.
I do think it's somewhat non-responsive, but a vague answer that doesn't cross the line in the way that what Investigator Dennis said in his testimony. But I will have her back and instruct her, which frankly she ought to know better anyway. But I do think it was kind of vague enough and wrapped up in
that was not vague enough or wrapped up in anything. That was not vague and it wasn't wrapped up in anything. They had just talked about Thug being they had just talked about in his music, he was talking about robbing somebody. Then they played the jail call. And then this comes on the heel of that, where she's saying he lived a lifestyle of a robber, of a stealer, of a thief, of a person hitting licks. This was not vague. It wasn't wrapped up in anything. This was all within a context of the last, say, 10 minutes or 15 minutes. I totally disagree with her in this case. I totally disagree with her in this case. I totally disagree with her in this case. They were painting a picture of Thug as a thief. I'm only saying thief because basically hitting a lick is stealing something from somebody, or it can also refer to like getting a big drug deal or whatever. But however you slice it, it's about committing felonies for money, basically, or valuables. So they had just presented that as the context on the prosecution side. So Brian Steele comes up and says, well, what is a lick? Tell the jury. And she's like, yeah, that's the life that Thug was living. What? And she thinks that that's not as strong as saying a person who's indicted as a convicted felon with a firearm was in prison. That's not as strong because the man is on the indictment as a convicted felon. Anyway, y'all know I get pumped. But I disagree with her on this in this situation. She just told the jury that Thug was living a a lifestyle which was based on committing felonies. Welcome to the live chat. Y'all hit the thumbs up. Hit the thumbs up.
I'll give a curative instruction if you all would like, or we can just move on. Or you'd prefer.
I don't know for sure, y'all. Now, this would be interesting to get into Brian Steele's head, whether that was a moment he wanted her to fall, or if he was like, I'm just going to lay out this whole line of questioning and hope she falls at some point. If I had to put my money on it, it wasn't like I'm going to get her at this moment. More so, I'm going to make my questioning stretch out where we're kind of walking this thin line, and she might fall at some point, and I'm ready to get her. I think he just was ready to stretch it out over multiple questions and, 10 minutes, 15, 20 minutes, however long, so that the moment she took a false step, he would be ready to get her. Can I be quiet? Yeah, I'm gonna be quiet. Now, what are you listening to? All right, I don't hear anything, so I'm gonna keep talking. So trying to give him a criminal background, make him have exactly. That's the point. That's the point. She's positing a criminal background that he does not have any criminal record to support. But the thing, AFBM, is even if he did have a criminal record to support the background, it wouldn't matter. She cannot testify to his prior criminal acts without first having taken certain steps. And those steps were not taken. So it wouldn't even matter so much if he did have a criminal background. The only reason that saved Yak Gotti is because his indictment charged him as being a criminal. That's the difference. Let me bring it back. Court's back.
If they can strike from their memories and notes, the last response, it was non-responsive of this witness, and we will do it again.
I'll just say disregard the last response of the witness who was non-responsive. And then pick up from there. All right.
Then, Your Honor, can I just reserve my motion for mistrial? Thank you.
And then feel free to re-ask it in a way that is not going to elicit the same thing.
Okay.
All right. Can we get the witness on the stand and the jury out? It'll be a couple more minutes. So we'll just recess in place for a few minutes.
Y'all, this is set up to be pretty daggone bad for the prosecution, because how is she going to say she's not an expert as to his lyrics? So, I mean, aren't you testifying about his lyrics here? How's she going to say she's not an expert as to his lyrics when she's testifying about his lyrics? I don't get it. So I don't know how the judge is saying that this is less than the previous situation. Y'all know something? I have read that judges are They might be more harsh when they're hungry and more lenient when they're full. You might be better off making a mistake after lunch than you are before lunch. In other words, sometimes it just seems like things are just arbitrary. Because if you really just sit down and listen to the argumentation on this, I really think that this could certainly be argued to have been a worse violation than the previous violation. You know, let's see here. Ocean says exactly, and still didn't touch that. The judge brought it up. Thug is not a convicted felon. She wrong. Yeah, I don't agree with this. I don't. She need her Tito's break. You think she back there, LTK? You think she back there having a sip, having a martini, or what would Tito's? You would have a Bloody Mary, maybe. And don't know how many songs he has is ludicrous. I mean, I would if this is a little bit difficult to understand, y'all, because they just picked out some random lyrics. Like that last example, shot at your mama. Okay. 100 rounds in a Tahoe, somewhat connected. But I thought that the lyric about what was it, hitting the lick or whatever, where they played the jail call, I didn't like that one. I didn't feel like that one was connected. Gail Duggan says she ain't going to agree with Steele because she determined to uphold the state. Her opinion saying vague, judge is so crooked. She knows what she's doing. She knows what she's doing. She knows if she agreed with Steele, this trial will be over. If she agreed with Steele, then right now they would be going home. So she can't agree with Steele if she wants this trial to go to a jury verdict. Ms. Lily says, yes, she just picked on certain songs. Yeah, so we heard 3 songs out of, how many songs does Thug have in the public? At least what? Plus features. Songs and features, would we say minimum 200, 300, 400, maybe 500, maybe more? I'm not understanding this, and it just happened to Dennis. Nobody understands. Nobody understands. This will never end in a mistrial. They're in too deep, and Fani will not let this. The one thing I don't get about this is Fani should not have any control or say so over this judge. Fani should not have any say so or control over this judge. Don't make nobody tell you to say, not to say anything or not talk. I'm sure the reason we hear is your commentary. Yeah, yeah, I know. I'm just messing with people. People are funny, y'all. So I just kind of play back. This case is not real. Only the young man I feel bad for. I said this morning there would be something else, but the only difference is I said that Judge Whitaker would be taking shots at the prosecution by the end of the week, next week, basically sometime this month. This would qualify, but Judge Whitaker just didn't do anything. She just wasn't fazed by it. It's not that big, not that much. And I'm surprised by that a little bit because I really don't see the big difference between this and last week, particularly if I had to say which is worse, I'd say this was worse, arguably. Steele is very intelligent. He already knew. Steele, I'm going to say, from my opinion, there's over a 50% chance that Steele did that. Andre, I've been saying she's biased toward getting this trial to a jury verdict. I've been saying that for, weeks, months now. She wants this to go to a jury verdict. So I think she's biased because the prosecution's making the majority of the mistakes. She's biased toward helping them because they're the ones that would be knocking this case out the box. So,
All right, thank you so much. Ladies and gentlemen, I'm going to instruct you to please disregard the last response given by this witness just before the break, as it was non-responsive to the question asked. And go ahead, Mr. Steele.
Thank you. How many songs, if you know, does Jeffrey Williams in his poetry talk about licks?
I don't know how many.
All right. In your testimony in DeKalb County Federal Court, I believe you said Fulton County. You might have said Gwinnett County. If I'm wrong, you correct me. You've testified as an expert in gang.
In Fulton, DeKalb, Federal, and that's about it. Three. Yeah, the
Okay.
3 counties.
I apologize. So in any of those times, have you ever testified about lyrics?
No.
This is your first time?
Yes.
And do you have any experience or study or expertise or training in the history of the rap music?
No.
And do you have any training or study or experience or education in African American literature culture?
No.
Okay. To prepare for today's testimony, did you ever speak with Jeffrey Williams' producers, the people who actually put out the songs?
No.
Do you know whether any of your coworkers ever did that exercise?
I don't know.
Have you ever spoken with the promoters or the marketers who market this music?
No.
Okay. Have you ever spoken with any record label personnel that's affiliated with Jeffrey Williams?
No.
How about, do you know whether Jeffrey Williams you mentioned 3 songs, I believe, Slime, and I'm just not going to say it, but SH blank T, Just How It Is, and Bad Boy. Fair to say?
Yes.
Do you know who actually wrote the lyrics to any of those songs?
I don't.
Okay. Do you know when any of those songs were actually created? By created, I mean actually done in the studio?
No.
All right. Did you ever speak with any of the co-artists on these songs?
No.
Now, when you talk about, let's say, let's take the song. I'm just going in order of the numbers. So 535 YA, which should be Slime SH blank T, okay?
Yes.
You testified that it was released in March of 2016 from what you were either told, investigated, found out, discovered. Is that fair to say?
I think we said that that's the date that it was uploaded to YouTube.
Okay. Do you know the date it was actually released?
No.
And on that, you talked about you were interested in a lyric. I just want to make sure that I don't misquote it, about a Tahoe. Is that fair to say?
That's fair to say.
And it's 100 rounds in a Tahoe. If I'm saying it wrong or you think it's different, just, correct me. Is that right?
That's correct.
All right. Do you know what the next line is to that song?
N-word, lighten up your tacos.
What does that mean?
I have no idea.
When it says 100 rounds in a Tahoe, does that mean that the bullets went into a Tahoe, or does it mean that there's 100 rounds of ammunition inside of a Tahoe that someone's driving, if you know?
100 rounds in a Tahoe, it could be either or.
And did you do any type, and I know you, Detective Underwood, did you do any type of investigation to find out, if you could, what is the essence of that line?
I did not. It was just ironic that crime happened with the Tahoe and the victim was the ops.
How many rap songs, I'm just limited to rap songs, and if you don't know, just say, I don't know, talk about rounds in a vehicle?
I don't know specifically how many. I haven't kept up with that.
The next line of that song is something to the effect, and if I'm wrong, again, correct me, give him surgery, not lipo. Do you see that? Is that something like that? And if I'm wrong, just correct it.
Say, give him surgery, no lipo.
No lipo, thank you. And then the next one, the next line or artwork is, they don't blame that, and I'm not going to say it, but B-I blank C-H for pulling you down. Is that fair to say?
Yes.
What does that mean as far as your expertise and analysis with the Donovan Thomas, God forbid, killing with the Tahoe behind him, that there's something to do with a B-I blank C-H pulling that person down?
They don't blame that B word for pulling you down. That could be a woman. It could be reference to a woman bringing somebody down, or.
How does the Donovan Thomas, tell the jurors, from your investigation, how does the Donovan Thomas killing relate to a woman pulling someone down?
I think on direct, we said that the entire song didn't reference the murder. You're making the song about the murder. We said on direct that first line was in reference to the murder.
So
that was it, just a snippet.
I didn't mean to interrupt you.
Okay.
Are you done? I didn't mean
I'm
to.
done.
Okay. So from your analysis, you or somebody, your teammate, found one line and ignoring the context or the other words or lyrics around the line. Is that fair to say?
No, we didn't ignore it, but that particular line stood out because of the words that were used.
Did any of the other lines assist that one line that you're focusing on with the Tahoe?
No, but it jumped off into, like F12 and killing 12. And so 12, Donovan Thomas wasn't 12. So we can't say this song was about just Donovan Thomas. We know that. We know that just that particular first line, and he did it a couple of times. He said it 2 or 3 times in the song. So he jumped around talking about a lot of different stuff in that particular song.
Do songs, in your experience, and it doesn't have to be rap music, do they sometimes repeat lyrics throughout the song?
Yes, they do. The hook, maybe, or yes.
What'd you call it?
The hook.
Okay. Now, you mentioned killing 12, and the line is something like killing 12 and then SH blank T. Fair to say?
Yes.
Okay. And 12, I think the jurors know, that's a symbol, a slang for police officers. Is that fair to say?
Yes.
All right. And is this unique to Slime, SH blank T, killing 12 in music of the rap industry?
I don't understand that question.
Is killing 12, that phrase, or killing 12, SH blank T, is that unique to this song?
I'm sure there's a lot of rappers that probably talk about killing the police, but this song had the YSL S word first, then killing 12 S word. Like it was referencing that's what YSL do, kill 12.
And which police officer, God forbid, was killed that you're referring to?
In this song, I didn't say one was killed, but killing 12 is like, I want to kill 12, or it could reference anything.
Do you have, through your investigation of this case, your knowledge and collective knowledge, do you have any police officer that, God forbid, has been killed?
No, but I have seen where YSL members have fired at the police more than once.
All right, let me do this. Could you talk about YSL members, and then we're going to come back to the other songs, if that's okay. I'm not trying to jump around on purpose. Can would you mind looking at State's Exhibit? I believe it is 418Y. And you just looked at it earlier and helped the jurors.
Okay.
Can you pull up the picture more if possible, if it's not? Okay. And you remember this, and this is in 2015 in Houston. Is that fair to say?
Yes.
Who is the person to the immediate right? Well, you see Jeffrey Williams in the center,
Yes.
center bottom. You pointed him out to the jurors.
Yes.
Who's the young lady to his immediate right?
I don't know who that is.
Okay. Let's start on all the way on what we would look at the right, wearing the gray RG. You know what RG is, that sweatshirt?
Rich Gang.
All right. You know what Rich Gang is?
Yes, record label from Baby, Brian Williams.
And who is that person, if you were?
Who, Brian Williams? Oh, I'm sorry. In the picture, I'm sorry.
That's okay.
Demikian Garlington, AKA D.
Tell the jurors the last time Jeffrey Williams had any contact whatsoever through your investigation with Demikian Garlington.
I can't tell you. I don't know. I don't know when.
Who is the person now above Demikian Garlington in the white shirt?
That's Kelvin Treadwell, AKA OG Bentley.
I'm going to ask you the same question. When is the last time Jeffrey Williams had any communication through your investigation with Mr. Kelvin Treadwell?
I don't know. Back whenever in 2015, when all this was going on, they stayed, in touch. But this has been, like you said, 10 years ago almost.
Do you know when that touch ended?
No, I don't.
The young man next to him, is that Trontavious Stevens?
Yes.
Also known as Tick or Slug?
Yes.
All right. The young man next to, well, do you know how much contact Jeffrey Williams has with Trontavious Stevens since?
I don't know.
All right. The young man next to Mr. Stevens, is that Mr. Demise McMullen, also known as Nard?
Yes.
And how much contact has Jeffrey Williams had with him since 2015?
I do not know.
The gentleman to the right of Mr. McMullen, is that a gentleman named Mr. Sledge?
Yes.
Also known as Muntuk?
Yes.
How much contact, or when is the last contact Jeffrey Williams ever had with that gentleman?
I don't know.
The young lady next to Mr. Sledge, I know you can't identify her, but a sister of Jeffrey Williams, fair to say?
Yes.
All right. And then we come down from the sister, and right in front of her, there's a young man in black with his right hand up all the way to the left. You see that?
Yes.
And that person is?
I think I said on direct, I don't remember. I can't identify that person.
Okay. And how about the person in the red sweatshirt right next to that person's left?
Yeah, I don't know who that is either.
All right. Did I do the person who is to the immediate left of Mr. Williams sitting down holding the bar?
Shannon Stillwell.
Okay. And do you know the last time, and I'm excluding obviously this trial, but the last time that Mr. Jeffrey Williams had any contact?
I don't know, sir.
All right. Thank you for that. All right. I want to go back to where we were. And I'd like to talk to you. I'm just going in order of the exhibit number. It's 537YA. I believe it's a song Bad Boy. Is that fair?
Yes.
And you said it's released.
No, I'm sorry.
You said it's released. Give us a year again or a month again.
We said that it was uploaded, premiered January 15, 2021.
Okay, so January 2021 is approximately 6 years after January 2015. Fair to say?
Yes.
All right. And in that, you highlight or articulate or focus us on a particular lyric. I just want to get the lyric. And that lyric is, I shot at his mommy, now he no longer mentioned me. Fair to say?
Yes.
All right.
Yes.
And you related that back to January, I may have, get me on these dates, January 22nd, 2015, January 26th, 2015, shooting at Mr. Bennett's mother's home, and his mother got shot on the 2nd or January 26th, 2015 date. Fair to say?
Yes, but that second part, he no longer mentioned me, it refers to the back and forth that he and Lucci did on social media for the whole world in Atlanta to see. They were going back and forth for a while.
Okay, I want to talk to you about that back and forth, okay? If the shooting happens in January 2015, and the lyric that you're telling the jury about and educating the jury is, I shot his mommy, now he no longer mentioned me, is it your understanding that since the shooting, he being, you're saying Mr. Bennett, right? YFM Lucy?
I'm saying that the mother is that's who he said. He no longer mentioned me. He's referring to Lucci.
YFM Lucy.
Yes.
Also known as, well, his given name is Mr.
Rayshawn Bennett. Right.
Okay. So you're saying since January 26, 2015, if I'm wrong, just correct me, Mr. Bennett no longer mentions Jeffrey Williams. Is that what the lyric means to you?
No, the lyric means to me that we have been going back and forth, talking about each other, targeting each other on social media, having words go back and forth. And I think that whenever Jeffrey Williams put something out about his mother. He said something about his mother on social media about he glad he takes care of his mother or something like that. So I'm thinking that he was just taunting or just like he was doing on the videos that he was making. He was taunting him in this song.
Okay, and I know you're giving a state of mind. You're trying to say what Jeffrey Williams was doing, but through your investigation and through this lyric, are you not saying that once the shot, God forbid, came to the mother, on January 26, 2015, this lyric means that he, Mr. Bennett, no longer mentions me? Is that what the lyric means? And if it's not, and if your answer just states...
I can't say what exactly it means. I'm saying what I saw as an investigator, as a gang investigator, when the back and forth and the gang beef continued way after the 2015.
Now, the words before in the art, do you know what the words are right before I shot his mommy, now he no longer mentions me?
I don't have that copy of those in front of me.
If I showed you a copy, would that refresh your memory?
Please.
Okay. You have it? May I approach?
You may.
May I approach you?
Yes.
Given you, if you want to see anything else from the song, just let us know.
Okay.
That refreshes your memory. Just tell me that it does.
Okay. I see where you got the arrow. Okay.
Can you tell the jurors if it's accurate, from your investigation, if it's accurate? Otherwise, we could pull up on Google, whatever you want. Tell the jurors what the line is above the line that you highlighted for the ladies and gentlemen jury.
It says, you say you won't smoke. I've been coming down the chimney.
And then the next line is the line about?
You got barbecue your B word. I'm so fried and they crispy.
How does the line that you highlighted for the jurors, how does that coincide, if you know, in context, with the line about the chimney and the barbecue?
The part about the smoke is significant because that's slang for you won't to keep starting stuff, or you want a piece of me, or you want, it's slang for, you know, when they say you want all the smoke, or I got the smoke, or you don't want no smoke. So that's significant. But the part about the barbecue and the fried and crispy, I can't say what that meant.
Detective, you told the jury that you don't study Jeffrey Williams' lyrics or songs. How did you come about learning about these chosen lyrics from these 3 songs?
It's not that I didn't study them or I don't study them, it's that I can read words and I see what the words say. And a lot of times if I'm investigating something, or if I know it's an ongoing beef between you and the ops, and you sending messages through your music or through the words that you're putting on paper or on wax or whatever they call it, it's noticeable because of the investigation.
Wouldn't you want to then go out and ask somebody who was there at the time of the creation of that song, how did this lyric come about?
No, it's self-explanatory mostly. I mean, it's words, but the words mean stuff. It means something.
From your vantage point of what you do for a living, those words mean exactly what you believe.
Yes, it's been several songs that have gotten people killed around Atlanta, for sure.
Do you know what rap songs are primarily, I'm not saying everyone, primarily about? Rap music.
What is rap music about?
Yeah. Did you ever bother?
It can be expression. It depends on, you know, I guess who it is and what they're saying. Every rapper don't rap about violence and guns and gangs and killing.
Does any other rapper rap about violence and gangs? And
It's a lot of rappers rap about guns and gangs and violence all the time.
And have you ever been to a concert, Jeffrey Williams?
No.
You ever been to a concert of any performer, rap performer?
I was just at Usher the other night, but he's not a rapper.
Okay. Well, have you ever been at any when you consider a rapper?
Yes. Maybe not recently, but I have been to rap concerts. I'm not really into rap as of late.
Do you ever notice the crowd, that they're all diverse?
Yes.
Do you know whether rap is the number one gross industry financially in the world?
I believe that.
Do you ever think about why is it popular?
Objection, relevance.
Sustained.
Do you know whether this type of violence and gangs and killing 12, is that popular?
It is, but it shouldn't be.
Let me ask you about just how it is, okay? I think that's the third one that you asked about.
Okay.
Oh, before we go to that, Bad Boy, who is the co-artist on that? The jurors saw a video. There were 2 people singing.
Yes. That's another rapper.
Who is that?
I don't know Bad Boy.
One more time. You don't have to look at anything.
I mean, I'm looking at the name of the person. I don't know him. I just know that he's a collaborator with Mr. Williams.
Do you know that person's performer's name?
No.
Do you know whether any of these lyrics were changed in any way after they were actually sung?
No, I don't know that.
Do you know whether that can occur?
I mean, anything's possible, but whenever they play it on the radio or play it on YouTube, or you can kind of look at what the words are, and the person is actually rapping it on a music video and you can see it visually, then the words are the words.
I'm saying after it's actually recorded, do you know whether sound engineers or record producers, do you know whether any of the lyrics sometimes get changed?
It's possibly, but like I'm saying, once it's released, the words are the words.
In 539 YA, it's just how it is.
Mm-hmm.
And in that one, you referenced, I done the jacking, now I'm full-time rapping. Remember that?
Yes.
Do you know whether any other artist has that exact lyric before Jeffrey Williams used it in the song?
I don't know.
You also targeted, in my words, mentioned the word wax. You just said that. Do you remember that?
Yes.
Tell the jurors what wax means.
It was just my terminology of whenever music is made or the tracks. I kind of reference that with the tracks that were made or or they put it on wax. It could be like on a record or, I'm old, so could it be a album or a cassette tape for all I know, but it's just a term that a lot of the artists use when they laying down the tracks or the music.
So this song that the jurors heard is entitled Just How It Is. Fair to say?
Yes.
And in that, you targeted the second time, we known to kill the biggest, and I think you said
I think I said kitty, but I think it's cat.
That's fine. I think you said something like kittens of the kitties or something, but it's
The biggest kitty of the cats, I think I said, but I had it backwards. I think it's
that's fine.
We killed the biggest cat of all the kitties.
Okay. And you told the jurors that in your vantage point, you believe that that may have some reference to Jeffrey Williams, from Jeffrey Williams to the Donovan Thomas killing. That's what you said.
Yes.
Okay. Were you aware of Jeffrey Williams being friends with Donovan Thomas in January 2015?
I am.
And when it says we known to kill the biggest, and I think you corrected, cats of all the kitties, the line before that, do you have the words in front of you?
I don't.
Would you need to see something?
Yes, please.
You're on me. May I approach? May I approach?
Yes.
I turned it this way just because I did what I did before I made an arrow, but this is the whole song.
Okay.
So.
Okay.
Okay.
Find that.
Y'all, this was bound to happen.
If you were ready.
This was bound to happen. There was no way this wasn't going to happen with this lady. She was not prepared for this. This is not her fault. This is the prosecution's fault.
Okay, it said, you want me to read the line before we known to kill the biggest cats?
Yeah, if it refreshes your memory, if that's accurate, yes, if you don't mind.
We don't speak about the S word on wax. It's all mob business.
And then goes right into.
We known to kill the biggest cats of all kitties.
So that line above, the one about we don't speak on wax, from your definition of wax, does that mean we don't speak on record, we don't go on something that's permanent to talk about mob business? Is that fair to say?
Yes.
But then this entire song is about criminality. Or most of it, I don't want to say all of it.
The song kind of, it talks about the beef that the interaction at Lennox, which happened. It tell you to ask the cops, the detective, they know all the business. So, on one hand, saying that we're not going to talk about it, but we talking about it.
That's my point. So it's interesting in that song saying we're not going to talk about anything, but yet it's being talked about, right?
Yes.
You don't know whether any of this music, these lyrics, I know you don't know who wrote them, but You don't know if they're just art, do you? And not autobiographical.
It can be art. It can be looked at as art. I agree that it's art, but I think that when actual crimes are committed and you brag about it in a song, or you reference it in a song, or you taunt your ops in a song, then it causes problems. Because like I said, I've seen where songs have gotten 12-year-olds, 14-year-olds killed here in Atlanta because of things that were said in a song.
Well, that's terrible. But where in any of these songs that you looked at, does it mention the op means opposition? Fair to say?
Yes.
Where does it ever mention IF gang?
What?
IF gang.
It does not.
I mean, that's your, and you're entitled to it, but that's your opinion. That's your personal opinion, right?
Yes.
Okay. Where does any of these songs mention Jeffrey's friend Donovan Thomas?
It don't.
Now, I want to go to Jeffrey's releases, album releases, and songs releases. If you're not familiar with them, I'm not going to ask you about them, but are you familiar with his songs, like the names and how they're spelled? And
I'm not. I'm sorry.
No, that's fine. That's fine. With regards to, you know who Dwayne Carter is?
I do.
Phenomenal performer known as Lil Wayne.
Yes.
Are you familiar with his music?
Yes.
Are you familiar that on or about the 26th day of April 2015, he was here in Atlanta and in a tour bus, and that tour bus was fired upon?
Yes, that was a part of our operation planners.
Okay. Now, you knew Jeffrey Williams was performing in or around Holly Grove, Louisiana during that same time, same date. Fair to say?
Yes. Yes.
All right. Now, were you aware through your investigation, through you or your teammates, your prosecution team, that earlier that year, 2015, 2014, Jeffrey Williams and the performer known as Lil Wayne did music together?
No, I didn't know that.
Were you aware that in 2016 and 17 and 18, Jeffrey Williams and the performer known as Lil Wayne did music together?
Objection, I assume effects not in evidence.
I'm asking.
Sustained.
I'm asking questions if she's aware. All right. Through your investigation, to you or anyone else, can you tell, ladies and gentlemen, jury, whether Jeffrey Williams and Lil Wayne did music together 2016, 17, and or 18?
I didn't see that in the investigation.
All right. Do you know if anybody ever spoke with Lil Wayne during your investigation?
I think they might have spoke to his people, maybe around the tour bus incident, but
Okay.
I'm not sure who and how, because that was like a Cobb County incident. So I think somebody there did.
I'm excluding like a tour bus driver or something. I'm saying like the let's do this. Anybody, to your knowledge, ever speak with you? I assume it's not you because you would have told us, but you or other people on your team ever speak with Lil Wayne's musical assistants?
Not that I know of.
All right. Were you aware that Lil Wayne put out, since the tour bus shooting, more recently, an album with Jeffrey or a song with Jeffrey Williams?
Objection, assume effects not in evidence.
Sustained.
Do you know whether Lil Wayne has put out a song with Jeffrey Williams since the tour bus shooting?
I don't.
Do you do any type of investigation, or do you have any training or experience into the promotion of music, specifically Jeffrey Williams rap music?
No,
And by that, I mean like something on YouTube, come to this event.
that
or-
wouldn't be relevant for my job as a gang investigator.
I couldn't hear you. I
I
apologize.
said that wouldn't be relevant for my job as a gang investigator. I don't study music. I don't, you know, like I said, when we investigate crimes, we look at the crime. The music might come into play once we're looking at the crimes that happen. But as far as us just focusing on music or targeting music, that's not what we do.
Let me show you what I believe. Well, can I have state's exhibit number? Do you mind playing for me the name? I'll go. Let me show you with the court's, Honorable Court's permission, what's already been marked and entered into evidence, but I don't have the number, so
Okay.
Ms. Knight is helping with the number, okay?
Okay.
Your Honor, is it okay if
Yes.
I play that once
Yes.
it is announced? While that's being pulled up, were you present for a February 28th, 2015 interview with Detective Dennis? There's others there. And Mr. Copeland, you know, Kenneth Copeland is Lil Woody.
Yes, I was there, but I think I was like in another room. We have a room where we have a monitor where we can watch the actual interview live. I wasn't actually in the room where they were interviewing him.
Okay, so you're watching via some sort of
Monitor.
connectivity, and you can hear what's going on?
Yes.
Okay. I may want to ask you about that, but make sure that we get this first.
Okay.
Your Honor, may I play 117E?
Yes.
As an errand. Tell me if you've seen this before. It's already in evidence, okay?
Yeah, YSL. Carter 6 coming out Friday, first show. New Orleans, Holly Grove. Fuck, nigga. Meet me there, better yet. Beat me there, you did. With them dicks, too. Yeah.
Have you seen that before?
Yes.
Okay. And did you do any type of work to determine whether that was choreographed and promoted by the record label or anybody with the record label? Do you
No.
know? Okay. All right. In that February 28, 2015, I call it interrogation, interview, whatever, conversation with Mr. Copeland or Lil Woody and one of your team members that you're watching on the other line or other room.
No.
Do you remember it coming up by Detective Dennis saying it's marketing? A lot of rap is entertainment, it's marketing. Do you remember all that?
Somewhat. It's been a while. But
Do you have any knowledge of how much money has gone into marketing the performer known as Young Thug? Do you know?
I'm
most of-
sure a lot.
And that marketing backs up a certain type of image for the music. Is that fair to say?
That's fair to say.
Did you ever speak with any of the marketers to prepare for this case at
I
all?
did not.
Do you know who Future is? A performer, fabulous performer, Future.
Future, the rapper?
Yes.
Yes.
Do you know whether that performer has any type of symbol, like an animal symbol? And if you don't, just
No, can't think of one.
okay. Do you know whether Lil Wayne has a symbol?
It's not coming to me right away.
Okay. Does a goat sound familiar? And if you don't know, just
That sounds familiar. It seems like I seen that on an album cover or something.
okay. And Future, an eagle. Does that sound right?
That sounds right.
And Drake, an owl.
Yes. I
And
remember the owl.
And have you seen Jeffrey Williams collaborate with all those different individuals, those performers?
I have.
And have you seen their album covers or pictures with the snake and the goat, the owl and the snake, the eagle and the snake? Have you seen that?
I've seen a couple of them, not all of them. I really haven't paid attention to them.
I want to go over with you. You were asked questions about the rodeo tour, or what known as the rodeo tour.
Yes.
And you were asked about whether crime slowed down in March of 2015, something to that effect. You remember that?
Yes, I do.
All right. Do you know what Jeffrey Williams' schedule was in January 2015?
No.
Do you know how many days he was physically in Atlanta area?
No,
How about in February 2015?
I don't know.
Is that going to be the same answer for the rest of 2015?
I mean, looking at this exhibit, he was pretty busy.
Well, that exhibit ends on around April 2015. Is that fair to say?
That's fair to say.
Did you ever, through your investigation, know that Jeffrey Williams was performing all over the world in 2015?
I did not really keep up with it, but we kept up with it, but we didn't keep up with it. So we kind of noticed like you said, the slowdown of the crime in March, which we saw that he was on tour and gone a lot. So
when was the uptick again in the crime?
It started back in April.
Okay. Mm-hmm. Do you know where Jeffrey Williams, whether he was in Atlanta in April?
According to this tour thing, he was April 15th, April 1st, April 2nd, and April 3rd. He was on tour. So the rest of April, I can't say where he was.
Do you know whether he was in Atlanta?
I don't know.
And that's going to be the answer for the rest of the year, right?
Yes.
Where was Jeffrey Williams physically living in 2014?
I have no idea.
How about 15?
15, I was a part of the search warrant team. Can I talk about that? That the residents?
Yeah. Your Honor, I think we need to move past.
Just answer the question of whether you know where he was living.
Yes, some parts of 2015.
Okay. How many residents did he have in 2015?
I'm not sure. I just know of one.
How about 16? 2016?
No.
Same answer throughout until May of 2022?
Same answer.
All right. Do you know whether he was living for a considerable periods of time outside of Atlanta during all those years?
I don't know.
Okay. How many times in and around January 2015, God forbid the killings, January 10th, 2015, okay? How many times did Jeffrey Williams initiate? I mean, he's the one to initiate the caller to Demise McMullen?
I don't know.
How about Kenneth Copeland?
I don't know.
Justin Cobb?
I don't know. I didn't look into that part of the investigation.
Okay. All right. Now, you were asked about whether Jeffrey Williams, you were shown a stack. It's Jeffrey Williams exhibit numbers 220, and then it starts with A and it goes alphabetically throughout. You were asked about January 11th, 12th, 13th, 14th, and 15th, whether you found any schedules of concerts. You remember that question?
That was on the flyers.
Yes.
Did we see any flyers?
Yes.
Because it was a list of flyers for the whole year, I think.
Yes. Do you know that who got those flyers?
No,
Do you know who Detective Racy is by any chance?
I do.
Now, January 11th, 2015. Do you know where Jeffrey Williams physically was?
I don't.
Do you know whether he was filming a music video?
I don't.
Sustained.
Same question on the 12th. Do you know whether what he was doing?
On the 12th, where he was? I don't know.
Do you know what type of work he was doing on the 11th, 12th, 13th, et cetera?
I don't.
Your Honor, may I have a moment? May I have a moment?
Yes.
Thank you.
Thank y'all all for being here with us. Please do hit that like button. If you're not a subscriber, do subscribe. Hit the like, please do subscribe, and we appreciate everybody.
Your Honor?
Yes.
I don't have any other questions. Thank you. Thank you, Detective.
All right.
Thank you.
Mr. App.
Thank you, Your Honor. Good afternoon, Detective. My name's Jay Apt. I represent Mr. Kendrick.
How you doing?
I'm well. How are you?
Good.
So I listened carefully to your testimony. When you were giving an answer about, or answers about a photograph depicting Mr. Kendrick standing on the hood of a vehicle, you said you wanted to focus on, quote, the crime at hand and who committed it, correct?
I didn't say it was a crime. I said it was disrespect.
Okay. So you don't believe that my client was committing a crime?
If he didn't damage the vehicle, no.
Uh-huh. All right, great. And you didn't, you perceived that that was an act of disrespect, correct?
Yeah.
Okay. Did you question Mr. Kendrick or any of Mr. Kendrick's associates about him doing that?
I did not.
Did you question Mr. Rayshawn Bennett about that incident?
No, I didn't.
And to be clear for the jury, Rayshawn Bennett is the person who you believe owned that car, correct?
Correct.
He's also known as YFN Lucci, right?
Yes.
So you didn't question him about how he perceived it?
No.
And you didn't question any of Mr. Bennett's associates or friends about that incident?
I didn't, but Mr. Lucci spoke out on a pod with how he felt about that.
Okay. But you don't know for you're assuming that it was gang related, correct?
I'm not assuming. I know what was going on when that happened.
You didn't question anyone involved, but you knew
I didn't
what was
have to
going on?
question. I knew that it was a gang beef going between YFN, Lucci and his crew, and also YSL and their crew.
When is the last time before that photograph that Mr. Bennett and Mr. Kendrick spoke in person? Do you know?
I think they ran into each other at Lennox, but that was just according to social media. But they actually talked about them running into each other or talking.
Do you know whether or not they ran into each other that day at the mall?
I think I saw something on social media saying that they did.
Is it possible that they made a bet that day and this was just someone winning a bet?
I don't know what was said.
You don't know, right? Because you didn't ask anyone, correct?
No, but the guy stood
Hang
on the
on,
guy.
let her finish her answer, and y'all are kind of talking over each other. So try not to do that. Thank you.
Sorry, Your Honor.
Sorry.
I don't know it, but I don't think they even made a bet because, like I said, it was a lot of animosity and tension between the two groups.
And you wouldn't know because you didn't bother to question any of them, right?
I didn't question them, no.
Yeah. So you don't know for certain whether it was gang related or a bet or what the reason was or the intent was behind Mr. Kendrick standing on that vehicle. That's fair to say. You don't know because you didn't question any of them.
I saw the reaction of Mr. Lucci when he was questioned about it.
Why not ask him? Why not go and ask him then?
I didn't have to ask him. I saw his reaction. He wasn't happy.
He didn't have to follow the evidence?
He wasn't happy.
It's possible he wasn't happy because he lost a bet and it had nothing to do with gang activity? Yeah, it is assuming facts. You don't know one way or another what the reason or intent was in my client's mind. Isn't that fair to say?
I don't know what his intent was, but he got a reaction out of Lucci.
You believe in the First Amendment, right?
I do.
You believe in our people's right to free speech?
I do.
You believe in musicians' ability to create lyrics for art, right?
I do.
But you stated in your testimony that you think rap music that depicts violence is popular, but it shouldn't be.
I agree. It shouldn't be glorified.
And
I stand by that.
You also said that there are songs which have killed children in Atlanta. Which songs?
I don't know specific songs, but I know that it's music. The reason for the beef, as far as the Atlantic Station situation, they were going back and forth on social media with songs and disrespecting each other. Next thing you know is gunplay and children are dead.
You're the expert, detective. Which songs? Which songs regarding rap violence caused the death of children?
I don't know the name of the songs, but I know that those particular kids were involved in music, talking about each other in the music. Then it's violence spawned because of the music.
Do you think you should be an expert on rap lyrics?
Sustained.
I never said I was an expert on rap music. You said that.
You understand that lyrics and even lyrics about violence can be used as art to depict, to be marketed and for commercial purposes without being factual, right? You agree with that?
I have heard of that and seen that, but
and that can be done in
it's
movies.
It's not a good thing. That's all I said.
Not a good thing.
Right.
You ever seen the movie The Untouchables with Robert De Niro?
Probably not.
No.
No.
Goodfellas.
Seen Goodfellas.
Okay. So do you think Robert De Niro should be charged with crimes because he depicts murder and violence?
No.
What about Al
didn't do
Pacino?
If he was charged when he stepped off the movie set and he went and did the actual things that he did in the movie, then yes, he should be charged.
But you said in earlier testimony that if it's depicting previous actual acts of violence, then that should be a crime.
Like I said, if Robert De Niro left the movie set and went out and shot somebody like he did in the movie, then yes, he should be charged.
That's not what you said earlier. You said,
I would say argumentative, Your Honor.
okay. Did you say earlier that someone who is rapping about a previous act of violence should be held responsible for that?
That's not what I said.
Okay.
I said that they put in the music or in the wording of the songs things that have happened, meaning whether it was a shooting, whether it was a drive-by, whether it was a smash and grab, whatever. I say that sometimes this can be a confession. Sometimes it can be taunting just to the other gang members or the ops or whatever.
So if it's taunting, then it should be criminalized. Is that your?
I didn't say that either.
Okay. So Bob Marley singing "I Shot the Sheriff" is okay too, right?
He shoot the sheriff in real life like that man did up in Kentucky, then yes.
Yep. Yeah.
Or if it's like the sheriff shot the judge.
You don't know much about Bob Marley's life, do you?
What do I got to do with anything?
Listen, you understand that you've already testified that you have no concrete evidence that the lyrics that were played in this courtroom earlier are directly related to any actual criminal activity, right?
I didn't say it was connected to criminal activity. I never said that.
Well, okay. So they're just art. They're just free speech then. We can agree on that?
It's free speech, but like I said, when you talk about a crime that actually happened and your group is the suspect, it's
what? It's what?
It's obvious that you were involved maybe in that crime.
It's obvious that you were involved if you're singing about it?
Could have been.
Yes.
Object to the characterization of it's obvious that you were involved, maybe. And I'm going to object to Mr.
Overruled. What else? Hang on. To Mr. App's misstatement. Is that what you said? Ask your question again.
Thank you, Your Honor. So what you're saying is if someone sings about an act of violence that previously occurred, then it's obvious that they were involved.
That is a misstatement. That wasn't.
Is that what you're saying?
Not exactly. I'm saying that if crimes have been committed and then you go brag about it in a song, it's hard to defend that you didn't have anything to do with what you're pretty much confessing in a song.
Okay, and I guess that's my point. If Robert De Niro plays Al Capone and he's playing Al Capone in a movie, is it then obvious that he's the one who's in the mafia? I don't understand. Why is it that singing about a previous crime that occurred somehow ties you to that crime? What evidence do you, and let me rephrase, what evidence do you have that either Mr. Kendrick or Mr. Williams actually committed the murder of Donovan Thomas?
I didn't give you any, I didn't tell you that I had evidence of that. Did I tell you that?
You testified.
I testified that they killed Donovan Thomas.
You testified that it was obvious.
Got me mixed up. I didn't tell you that.
So it's not obvious that they're involved?
Objection, Your Honor, because I'm not sure where we're going to go, and so I want to.
Well, a minute ago.
Hang on and let me listen to her objection.
Can we approach her?
Yes.
Ooh, I knew it. Yo, this is like a timeout, y'all. This is like on a football or basketball. This is like basketball. They just ran up 13 points in a minute. You like timeout. You got to get that timeout going, y'all. This Hilton was right. She actually didn't call for the approach, which she should have, but she got her approach. She needed that. She needed that because this dude came out flaming hot. Good God. Good gosh. Good golly. Oh my goodness. I have not seen a flaming hot come out like that. I mean, Brian Steele was tame compared to this. This guy's on fire. Goodness gracious. This is wild. But you know what? Y'all, this witness, she's holding her own. I mean, she's ill prepared. She's ill prepared for this, but she's not crumbling. She's not crumbling. She's losing she's losing every exchange, but she's not crumbling to pieces. They put her out there instead of Dennis. So anybody who said, I want everybody who came at me saying, oh, well, they took Dennis off, but they just put somebody else in his place. Please eat your humble pie. This is not the same thing. This woman is testifying to stuff that she would not have otherwise been testifying to
because they took Dennis off of the table. She is rattled. I agree with that, but I don't think she crumbled. I don't think she think she's maintaining her own, but she's definitely rattled. But see, y'all, do y'all see why taking Dennis off the table was so significant now? Now they tried to pull a juke move. They tried to, and it could have worked, but it didn't work. He did cook her. He did cook her. But the biggest thing is that I think the reason why she's still composed is because this is not what she was supposed to do. They tapped her in for this. So I think she knows within herself. Again, I'm kind of always reading people's mind. I shouldn't do that, but hey, got to fill the time some kind of way. She lacks education. Somebody said she lacks education. Yes, she wasn't supposed to be up here doing this, y'all. This is not what she was supposed to be doing. So if you are like, oh, she's not right for this, she's not prepared, correct. This wasn't what they had her on the witness list to do. She's kind of, I don't want to say doing them a favor because I don't know that for sure. But, yo, I would not want to be on his bad side. This guy's coming in just sizzling. Yeah. This is not fair to her, y'all. This is not what she's supposed to do. So she's like a substitute filling in for something that she's not ready to do. She's been on the stand 1,000 times.
We just want to make sure that with regard to Mr. App's questioning, he's going to confine his questions to things that have to do with his client, Mr. Kendrick. And you should likewise confine your answers to things that have to do with his client right now while he's the one questioning, okay? And not talk about any of the other co-defendants on trial here. And things like a search warrant that got the results of which were suppressed, don't even veer into territory like that. And I'm not going to go through all of the different possibilities, but just be mindful when you testify to be careful not to testify to anything that, as an experienced detective shouldn't be being talked about. Okay.
Okay.
All right. Any other kind of parameter anybody wants to mention?
Well, Your Honor, and I guess I'm speaking to the detective as well. Detective. Okay. I represent Shannon Stillwell. I am not asking this question, and he is specifically asking about Mr. Kendrick. I would not anticipate that the answer would include pronouns such as they or things of that nature. And I would ask that anything be strictly limited to Mr. Kendrick.
I understand.
All right. Anybody else?
I'll absolutely limit my questions relating only to Mr. Kendrick.
All right. Okay, I think we're ready to get the jury back. They may not be ready to come back, but
this guy is like the opposite of Weinstein. Weinstein is so chill and relaxed. He does throw darts, but not like this guy. What's this guy's name, y'all? I need a name for him. Man, could you imagine him and Love going at it? Can you imagine if Love and he were on opposite sides? That would be a battle royale. I really feel like he confused her a bit, y'all. I feel like he confused her a bit.
Yeah, somebody give us his name. Oh yeah, she's the one on stand, Queen. So I'm not making excuses for her. I was really saying, I think from her perspective, she like, look, I'm up here, I'm doing my best. I wasn't ready for this. So if you know that if you know you are not being tested at your core competency, it's easier not to feel bad, I think, because you like, well, I'm just trying to fill in for y'all. I'm trying to do what y'all ask me to do. As opposed to like, if this really went to the core competency that she prides herself on, then it would feel terrible if she couldn't deliver. But if you can't deliver on something that you already know is not really your core competency, it doesn't feel as bad. So I mean, that's really what I was getting at. Yeah, he representing for the Baldies. He representing for the Baldies. This is over. They came prepared today. They fit in the pudding. Yeah. This is. I mean, why did they get into the lyrics? They didn't even need to get into that. They didn't even need to open that door, y'all. Especially with 3 songs, with one line from each from 3 songs, and the surrounding context doesn't even support the line. You know what I'm saying? She done them a favor, stepped up and fell short. You're right. They just had to bring. Yeah, I mean, so she did them a favor. Apparently, she was supposed to be testifying to some shell casings or something. Dennis really effed up super bad. I hope y'all see that now. That Dennis situation from Thursday, and people saying that Page, that Judge Whitaker's kind of always walks. She had a chance today to walk back the Dennis thing. She didn't.
Thank you, Your Honor. So, Detective, you were saying that and I don't want to misquote you, but that if someone raps or sings about an act of violence that actually occurred, then it becomes obvious of what?
To me, it's bragging. Could be taunting or bragging.
And well, let me ask you this. Are you aware of whether Mr. Kendrick wrote any of those lyrics that were played in the courtroom earlier?
No, I'm not aware.
So you don't know if my client was even involved in writing those lyrics.
I never said he did.
And you're not aware of Mr. Kendrick in any way, shape, or form being tied to or involved in the murder of Donovan Thomas. Isn't that true?
I know he was arrested and charged or a suspect for it.
Were his fingerprints found anywhere?
I didn't work the homicide portion of that. You would have to refer to.
You don't know if his fingerprints.
I didn't get into the homicide investigation.
You don't know if his fingerprints were found on the Tahoe or any evidence in the case?
No.
You don't know if his DNA was found?
No.
You don't know if any ballistics were found that were tied to Mr. Kendrick, correct?
No.
In fact, you're not aware of any eyewitnesses who saw Mr. Kendrick commit that crime, correct?
I don't know of any.
And you went to great lengths to give an expert opinion about what the state refers to as exhibit, I believe, exhibit 535 YB, which is the song called Slime. And I apologize, I may be less genteel than Mr. Steele is, but it's a piece of evidence. The song's actual name is Slime Shit. Is that right?
That's correct.
Okay. And you stated earlier, you don't know the date that song was released, right?
No, I only see the date that it was uploaded to YouTube, like I told Mr. Steele.
You don't know the date it was written?
I don't.
You don't know who wrote the lyrics?
I don't.
And so if that song, if I told you that track was released officially on September 16th of 2015, and that...
Sustained.
I'll withdraw the question. If, hypothetically, if those lyrics were released in 2014, before the murder of Donovan Thomas, then wouldn't it be fair to say that the Tahoe mentioned in the song had nothing to do with Mr. Thomas's murder, right?
That would be fair.
You're not suggesting that whoever wrote the lyrics was psychic and predicted the murder of Donovan Thomas, right?
I did not say that.
Okay. Thank you. I have no other questions.
All right, are there other defense attorneys with questions for this witness? Come on up.
Good afternoon, former agent.
No, I'm actually a retired investigator, but I was a former task force officer.
Retired investigator. Okay, retired investigator Underwood. My name is Max Shard. I represent Shannon Stillwell. Okay.
How you doing?
I'm fine. How are you?
Good, good.
All right, good. First of all, I just want to get one thing out of the way. Brief, and I know you were answering a question. You brought up some Atlantic Station incident that has nothing to do with this case.
Oh,
correct?
no, it has nothing to do with this case.
Okay.
It was just referencing gang violence.
Okay, cool. You, in preparation, you knew you were going to be testifying eventually, and you provided a CV.
I did.
To the state, correct?
I did. It's probably been
worked for the DA's office in Fulton County, correct?
She used to.
And right, and she's also worked for the state of Georgia, correct?
Yes.
And you know her to be on the witness list for this case, correct? Okay, so she taught that class.
She taught one of them.
Okay.
I've been to more than one.
Well, who specifically talked about how gangs use music? What individual, what professor, or was it an artist that talked about that? Who was it?
It wasn't a professor, it was law enforcement.
Oh, law enforcement. And who was the law enforcement?
The one that I do remember recently was Marissa. She taught one at APD.
All right, Marissa Viverito, who used to work for the DA's office. Okay. So there was no one from the music industry, no artists or anything there. Okay.
No.
How gangs, you were asked if you had training in how gangs use music to promote fear in other gangs. Again, who were the musicians or anyone that spoke to you about that?
No musicians.
Okay.
The classes that I've taken have been all from law enforcement when it came to gangs. My other classes at Columbia Southern were professors, but they didn't talk about gangs.
Okay. And how gangs use music to promote fear in other gangs. What date was that? Who taught you about that?
I told you what class. I don't remember the instructor on one of them, but I do. Like I said, the most recent one at APD within the last 3 years. It might have been while she was still here. She taught that one. That's the one that stands out. But I did go to one down in South Fulton as well, but it was like a GGIA training.
You were asked how gangs use. You were asked about your training or education and how gangs use music to promote cohesiveness. Who taught that class? Is that the same answer?
It would be the same, yes.
Okay, so no one from the music industry, and it seems like
every class was law enforcement.
And the one that you're speaking of is Investigator Viverito, who's on the state's witness list for this case.
That's one of them.
Okay. And the same answer would be for your experience when the state asked you how gang members use music to send messages to rival gangs. Would those be your same answers?
Yes.
Okay. All right. And then you were asked by the state here, among other things, to talk about lyrics in this case, and you've been speaking about specific lyrics.
Yes.
Okay, in that Bad Boy video, you didn't recognize the other artist?
No, I don't know who that is.
You ever hear Juice WRLD?
I've heard of it, but I don't. That's not anybody that came on the radar because he haven't probably committed a crime here in Atlanta.
Okay. So as I understand it, in preparation of this testimony, and correct me if I get the timing wrong, sometime last week, the state gave you some music videos to review or some songs to review?
Yes.
Okay. How many?
The 3.
Okay. It was just those 3?
Just these 3.
Okay. And they were all songs by Jeffrey Williams?
Yes.
Okay. Did they not ask you to review a song called Homicide, written and performed by Lil Woody featuring Fagiano?
Never heard of it, no.
Have you ever watched that video?
I haven't.
Okay. Are you aware of this song?
No.
You aware that in that music video, in that song, Woody talks about putting money on someone else's head?
Not aware.
Are you aware that the person he talks about putting money on their head is a heavy-set African-American male?
Not aware of that.
Are you aware that the person he conspires with in that video to kill the heavy-set African-American male is Trevante Turner?
And I'm saying objection vague as to, are you talking about what happened in the video?
Yes.
This video,
I haven't seen the video.
Okay, so you're not aware that Trevante Turner played the role of the hitman in Woody's video, where
I haven't seen that video.
he depicts killing a heavyset African-American male. Okay. No further questions. Thank you.
All right, are there any other?
They watching the chat, y'all. We helping to solve the crimes.
Go ahead.
We helping to solve the crimes.
Mr. Steele asked you when he was questioning you if any of these lyrics mention Donovan Thomas Jr.'s name inside of those songs? You recall
I
that line of
recall that
questioning?
question.
When you're listening to songs that may become a part of your investigation, do the ops usually say specifically the person's name, or is it more of a hidden message? What has been your experience when you're listening to the music that comes a part of your investigation?
My experience is not directly, saying the person's name is like sending a message, but like if that particular person or that person's group or person's gang know that I committed a crime or know that we have beef, then a lot of times they know it's obvious who they're sending the message to.
And when we say it's obvious, is it obvious to the opposition gang who the message is being targeted? Is that what you're saying?
Yes.
Mr. Shard asked you about whether or not anyone from the music industry came and taught your class. Do you remember him asking you a series of questions about that?
Yes.
The classes that you took, were they focused on music or focused on gangs?
Focused on gangs.
And have you ever had anyone from the music industry come and talk to you about gangs?
No.
Court's indulgence.
All right, any recross by anybody? All right, thank you for your time. You're excused. Call your next witness.
Your Honor, the state calls Sharon Ladders to stand.
All right.
If you're in this chat, you should feel so good right now. There's no doubt that we were on point when we were reviewing that music video today. It came up in trial today. I can't say we were looking at the chat, but it feels so gratifying.
Welcome back, Miss Latners. You're
It
still
feels so
under oath.
gratifying that we were talking about this and it comes up in the trial. And this lady didn't
You
even
can go
know
ahead and
about
sit
it.
down. You're still under oath from your prior testimony.
Good afternoon. Before coming to the witness stand, did you have an opportunity to review a CAD report and some 911 calls?
Yes.
Ms. Latners, I'm going to approach you with what's been marked as 1 November 1 November Delta, and a disc marked that contains, I should say, 1 November Alpha, Bravo, and Echo. And Ms. Latners, just look up at me if you've had opportunity to review that. Ms. Latners, are those the items that you reviewed before coming to testify this afternoon?
Yes.
And what are they?
Cover of the CAD report for February 23rd, 2019, and the 911 calls.
And is there any markings on that 911 disc that you marked on?
Yes, I placed my initials on it.
And is it a fair and accurate depiction of the CAD reports and associated 911 calls for that incident?
Yes.
Your Honor, at this time, the state moves to tender into evidence 1 November, 1 November Delta, and the disc that has 1 November Alpha, Bravo, and Echo.
All right, those are admitted.
Thank you, Your Honor. Ms. Latners, I'm going to first publish 1 November. Ms. Latners, what is the date for this CAD report?
February 23rd, 2019.
And what did this call come in as?
Amen. Shots fired.
What was the call type and description when the call was complete?
Person shot.
What was the location for this person shot call on February 23rd, 2019?
50 Mount Zion Road, Southwest, Brandywine Townhouses, Atlanta.
In what zone is that, Ms. Latners?
Zone 3.
Now, what time was this CAD report a officer generated or 911 call?
911 calls.
What time was that call received by APD dispatch?
Call went up to dispatch at 04:37 a.m. hours.
Were officers dispatched at 04:37?
Yes.
Was the call received at 04:36:40?
The call came into 911 at 04:35. 911 sent it over to Zone 3, dispatch at 04:36.
And Ms. Latners, what time were those officers that were dispatched arrive on scene?
It shows 04:42 a.m. hours.
Now, Ms. Latners, I wanted to draw your attention on, you see on page 2 of this CAD report,
Yes.
at the bottom, you have unit ID 1394, and it has a code of a LC. Do you see that, Ms. Latners?
At the bottom of page 2,
Yes, ma'am.
1394 is the sergeant for that zone.
And what does that LC indicate?
Location change.
And what is, can you explain to the jury what that time and what that time is and what it reads afterwards?
Unit 1394 advised at 6:10 a.m. hours, he arrived at Grady Hospital.
Now, Ms. Latners, if you turn to page 3, do you see the CAD narrative?
Yes.
Can you describe for the jury what that first entry is at 4:35:54 a.m.?
The person advised the 911 call take a shots fired in that area at 50 Mount Zion Road.
And Ms. Latners, if you look 2 lines down at 4:36:40 a.m., what is the remarks indicate following that?
Call advised he heard 10 shots in the area.
Does it say 10 plus shots, Ms. Latners?
Plus shots in the area.
And if you look further down at 4:38 a.m., what does that CAD narrative remark indicate?
Well, it shows the call came from a T-Mobile. Then it says address at 2835 Old Hateville Road, Southwest, and they gave a phone number out, the person who called. It's a duplicate call.
And what is that last line at 4:38 a.m.?
It looked like second rounds of I heard from the hills of the apartments, did not see anything.
And Ms. Latners, if you turn to page 4, do you see at 4:39 a.m. it starts with male caller?
Yes.
What does that remark section in this CAD narrative indicate for the jury?
Another caller called in, advised male caller David requested to speak with officer at apartment Y Yankee 5. He gave out his phone number.
And beneath that, where it starts at 4:47 a.m., what does that indicate? Starts with unit.
Advised a unit told his dispatcher, advised male inside a blue Charger in passenger side, possible 50 was shot to the head.
So that's possible signal 50 to the head.
Yes.
And is there a related CAD indicated beneath that at 4:48:56 a.m.?
He advised this incident is related to CAD number 190540456.
And Miss Latners, if you look a couple lines beneath that at 4:54 a.m., that starts with BLU. Do you see that, Miss Latners?
Yes.
What does that indicate for the jury?
The officer advised the dispatcher blue Dodge Charge gave out the tag number, temporary tag number 2454029, which is a paper tag.
And Miss Latners, what is immediately beneath that 1 minute later at 4:55 a.m.?
He advised his dispatcher possible vehicle, possible code 19, which is a stolen vehicle out of Cobb County.
And Miss Latners, at 5:07 a.m., do you see the CAD remark that starts with unit ADV?
Unit advised share cases near building X-ray.
And Miss Latners, what at the very bottom, or a couple lines from the bottom at 6:10 a.m., it has unit advise. Do you see that?
Yes, unit advised the victim is 48, which means a person is dead at 0609 a.m. hours.
Now, Miss Latners, is some of the 911 recordings that are on that disc pertain to this CAD report ending in 454 from February 23rd, 2019?
Yes.
Your Honor, at this time, the state is going to publish one November alpha.
All right.
Is it ready? Atlanta 911 operator 7198. What is the address of the emergency? I live in an apartment called, they used to call it the Wood, but they call it the Crystals now. And the address is at 50 Mount Zion Road, Southwest. Someone out here shooting, about 10 shots. Okay, do you want to speak with an officer? Yes, ma'am. You do? No, ma'am. Can you have someone just come out here? Okay, we will. Thank you. Hmm? We will. Thank you. You're welcome.
Ms. Latin, Your Honor, the state is going to publish one November Bravo at this time.
Thank you.
Atlanta 911 operator 7357. What's the address to emergency? This is Atlanta. This is 911. What is the address to your emergency?
The address is 50 Mount Zion Road, Southwest. Apartment Y5.
I can't. Apartment 15?
Y5.
Y5. Do you need fire, police, or ambulance?
Police.
What is your name?
David Goodman.
David, what's your phone number?
Your Honor, I'm just briefly using the phone number.
That's fine.
Is there a gate code, sir?
No gate code.
No gate code. Okay. All right. Let's see. And what's the name of the apartment, sir? Crystal Apartments.
You said Crystal Apartments?
Yeah.
Okay, what's going on out there, sir?
I just heard a bunch of shooting. I'm not sure if it was aimed at my apartment, but it sounded like it was aimed over at our apartment.
Okay.
I just want to make sure.
Did you call already, sir? Because it's showing that we did get calls in reference to this.
No, this is my first time calling.
Okay, yes, sir. We did get a call about. Do you want to speak to the police when they come out?
Yeah.
Okay, and let me confirm. You said you are in Y 5, correct?
Yes.
All right, we can help out to you, sir.
Okay.
All right.
This night. And Your Honor, the state's going to publish 1 November Delta.
All right.
Ms. Latner's with, is 1 November Delta the CAD report that was related to the first CAD report we discussed with the jury?
Yes.
And are the last three, what are the last three on this incident number for this CAD?
0456.
Did this come before or after the first CAD report we discussed?
After.
What is the location for this CAD?
Is advised Oak Drive and Pendleton Circus Southwest.
And what was the call type and description?
Shot fired.
Is it the same zone?
Yes.
And was this a 911 call or officer generated?
911 call.
What time did this 911 call come in?
0436 a.m. hours.
And what time did officers arrive?
0457 a.m. hours.
Ms. Latner's turning to page 2. Do you see the CAD narrative remarks?
He advised multiple shots fired in the area, no further.
And then is that last line at 4:48:56 a.m. reference the first CAD we discussed?
Yes.
And Ms. Latner's at the very top or near the top on the front page. What is the disposition for this CAD report?
Code 12.
Is that an investigation?
Yes, it is.
Was there also a 911 call that corresponded with this CAD report, Ms. Latner's?
Yes.
Your Honor, this time the state is going to publish 1 November echo at this time.
All right.
Atlanta 911, I'm 37087. What is the address? Hello?
Can you hear me?
I can barely hear you, ma'am. It sounds like you're whispering.
Yeah, because it just woke me up. There's a shooting going on in my neighborhood, and it sounds like it's coming from Oak Drive.
Oak Drive and what other cross street?
Pennington, Old Hateville.
All right, how many shots did you hear?
Oh, it was around, and then there was it sounded like it was another gun that was weaker than the first round. That about 5-7 shots, and then there was a second gun that was going off, and that was about 3 or 4.
Okay, did you hear anything else besides the shots being fired? Any vehicles speeding away? Anyone yelling?
Just the shots.
Okay, we'll get someone out there to check the area.
All right, thank you.
You're welcome. Bye-bye.
Stop at 1 minute and 21 seconds. No further questions from the state, Ms. Latner. Thank you.
Any defense questioning?
Good afternoon, Ms. Latners. I'm Attorney D. Williams. I'm going to be very brief because I know you want to go.
Yes.
So looking at the CAD report, do officers have access to the contact information of 911 callers?
Say that again.
Looking at the CAD report, do officers have access to the contact of the 911 callers?
Most of the time, officer want to talk to the caller, he would ask his dispatch to call the caller back.
And do all the 911 calls go over the radio or just to dispatch?
The 911 calls goes to dispatch. Dispatch the officer out.
Okay.
Two different sections.
Two different ones? Okay, thank you. And then upon the request from the DA's office, your office turned over all the records regarding this incident?
Yes.
And all calls that require an officer on scene, are they entered into a CAD report?
Say that again.
All calls that require, I guess, are dispatched to a scene, are they entered into a CAD report?
The 911 call creates the CAD report for calls to come through 911. If an officer pulled out on a call, their dispatcher will create a CAD report for them.
Thank you, Ms. Latners.
You're welcome.
Anybody else? Go ahead.
Oh, help me.
All right, let's not comment on the various attorneys.
Hello. How long do 911 calls preserve?
Well, since Atlanta take over 1 million calls a year, our system can only hold so much. So the system purge out the 911 calls itself. We don't purge it out. The system does that.
How long does it, when you say purge, you're saying call on January 1, 2015, let's say, January 11th, 12:04 a.m. January 11, 2015, 12:04 a.m. How long will that call last?
We should hold the call. 911 should hold the audio for at least 3 to 4 years.
3 or 4 years.
Years.
So in my January 11th, 12:04 a.m.
What year?
2015.
We would not have.
We're going up to approximately 2019,
We'll have 2019.
and then it's gone.
2015, we don't even have that system anymore.
Thank you, Your Honor. Thank you.
Anybody else? All right, any redirect?
Your Honor, one question. Ms. Latners, would CAD reports and 911 audios, are they subject to FOIA request?
Are they subject to what?
To Freedom of Information Act request?
Yes.
No further questions, Your Honor.
All righty, any recross?
Do you know whether Mr. Jeffrey Williams was arrested on May 9th, 2022 in this case?
I can't answer that.
Do you know whether May 9th, 2022 is after January 11th, 2019?
I can't answer that.
Yes, you can. Thank you. Thank you.
All right, you are excused.
I can leave.
You can leave. No idea whether they'll have you back again or not, but call your next witness. Yeah.
Okay. And how do you know her?
I grew up with her.
Do you know whether Mr. Jeffrey Williams was arrested on May 9th, 2020?
Yeah, we're a little bit behind because of the internet issue, so I'm gonna
Do you know
fast
whether
forward to
May 9th,
catch us up.
2022
Sorry
is
about
after
that.
January 11th, 2019.
Let's catch us up. Mr. Abate is coming.
state your first initial and your last name, and spell your last name. All right? Into that mic.
My first initial start with an M. My last name is Smith.
Say, good afternoon.
Good afternoon.
Can you tell the jurors how old you are?
I'm 23.
And can you tell the jurors, did you grow up in the Atlanta area?
Yes.
And where did you go to high school?
I went to Forest Hill and Maynard.
Okay. And back in February of 2019, can you tell the jurors where you were working?
McDonald's on Moreland.
Okay. And what were your hours or the shift that you typically worked?
3 p.m. to 11 p.m.
Okay. And I want to ask you a few questions about people you may know or may have known back in February of 2019. Okay.
Mm-hmm.
Can you tell the jurors, do you know someone by the name of Miss Tahira Hartfield?
Yes, sir.
Okay. And how do you know her?
I grew up with her. I went to school with her. She was a friend back then.
Okay. And are you guys the same age?
I'm not sure.
Okay. And you said you grew up with her. You went to school with her. How many years would you say that you knew her?
From like the 5th grade to probably up to that time.
Okay. So 5th grade up until at least February of 2019?
Mm-hmm.
You gotta say yes for the record?
Yes.
Okay. Now, can you tell the jurors, did you call her by her first name or did she have a nickname?
I mean, she had a nickname, but I call her by both.
Okay. Can you tell the jurors the times that you called her by her nickname? What was it?
Brazy.
Okay.
But I rarely called her that because I don't know her by that.
Okay. Did other people, when you guys were hanging out with your other friends, call her by that nickname?
Yes, sir.
Okay. And can you tell the jurors, did you have an Instagram back in 2019?
Yes, I did.
And did Miss Hartsfield, did she have one?
Yes.
Okay. And were you friends with her on Instagram? Were you familiar with her Instagram account?
Yes.
Okay. Now I want to show you. I'm sorry about that. I want you to look at State's Exhibit 21 and 22N. Okay?
Yes.
And by looking at those, can you tell me, do you recognize what's depicted in State's Exhibits 21NN and 22NN?
Yes.
Okay, and let's talk about first 21NN. What is State's Exhibit 21NN a picture of?
Tahira Hartfield.
Okay, and is that her Instagram account that she had back in February of 2019?
Yes, sir.
And in 22NN, can you tell the jurors, do you recognize that one?
Yes.
And how do you recognize the picture in 22NN?
This me.
It's you?
Yes.
And is it your Instagram account back in February of 2019?
Yes.
Okay, and does both 21NN and 22NN represent the Instagram account for your friend Ms. Hartsfield as well as yourself back in February of 2019?
Yes.
At this time, out of the state would tender what's been marked as State's Exhibits 21NN and 22NN.
M or N?
N, I'm sorry.
All right, Nancy. Those are admitted.
Okay. Now, can you tell the jurors, back in February of 2019, did you know anyone by the nickname Little Rod?
Yes.
Okay, tell the jurors, how did you know Little Rod?
I met him through Tahira.
Okay, and can you tell the jurors, do you know Little Rod's real name?
No.
Okay, did you always call him Little Rod?
Yeah.
Okay, and can you tell the jurors, did you know somebody by the nickname of Bally?
Yes.
And can you tell the jurors, how did you know the male whose nickname was Bally?
I was introduced by Tahira through both of them. I met them through her.
Okay, and do you remember, if we're talking about in relation to the shooting in February of 2019, how long, I guess, had you known the males with the nickname Bally and Little Rod?
I had just met them within that same month.
Within that same month?
Yes.
Okay, and can you tell the jurors, the male that you knew as the nickname Bally, did you know his real name?
Mine, but I'm like learned it from the stuff
Okay.
that's going on now. Yeah.
Okay, so did you know his last name back in 2019?
No.
Okay, so you just knew him by his nickname as Bally.
Yeah. I met them through her, so I didn't know them personally.
Okay, and you said you met him in the same month. Can you tell the jurors within that month how many times had you hung out with Bally and Lil Rod?
I mean, that first day I seen them, from that day, like the second day, we was going over there to Blake like them house every night. Like, it was never a dull moment. Like, we was having fun. So when that situation occurred, it was just like came out of nowhere.
Okay. And you said you would go to whose house and hang out and have fun and chill?
Blaylock.
Okay. And can you tell the jurors how many times do you think that you went to Blaylock's or Bally's house?
I'm not sure.
Okay. More than once?
Yeah, it was more than one.
Okay. And did you ever have an opportunity to go to the person you knew by the name of Lil Rod?
I mean, we all just used to be right there at Blaylock house.
Okay. And do you remember, I know it's been some time, where or what general area that Blaylock house was?
I just knew it was on Cleveland. I'm not familiar with over there because I don't hang over there. I just went to school over there. I was introduced to over there by them. I don't hang over there. I don't know nothing about Cleveland for real.
Okay. And you said off of Cleveland?
Mm-hmm.
Yes?
Yes.
Okay. Now, in the times that you spent with Lil Rod and Bally, can you tell the jurors in your interactions with them, did they tell you they were in a gang?
I mean, I'm not sure.
Okay. Do you remember the detectives after this incident asking you if you knew if Lil Rod and Bally were in a gang?
I'm not sure.
Okay. Do you remember telling the detectives that both Lil Rod and Bally were members of the YSL gang?
Yes.
Okay. Now, let's talk about some other people that you may have known back in 2019. Did you know a male named BJ?
Yeah.
Okay. Did you know his real name?
Bernard.
Okay. And how did you meet Bernard, or the person whose nickname was BJ?
I was longtime friends with him. Like, he used to come over my house and stuff. We grew up in the same neighborhood.
Okay. Was he friends with Miss Brazy?
I mean, I really don't know. I could just only speak for me, but we always around each other one time, yeah.
Okay. So I guess a better question is, did you and Miss Brazy and Mr. BJ, did you guys all hang out fairly often?
She didn't used to be with us, but when I used to hang with him, like, I used to see him in apartments and stuff like that. It was like a hey and bye situation.
Okay. Now, can you tell the jurors, back on February 23rd of 2019, did you work that day?
Yeah.
The night of the shooting?
Yes, I did.
Okay. Did you work your regular shift or the hours that you talked about today, 3 to 11 p.m.?
Yes.
And can you tell the jurors, after your shift at McDonald's was over, what did you do next?
I went home, took a shower, and I was there. Like, really the whole house was asleep. My mom, she was up and out. Like, my sister, them, she was downstairs asleep. Everybody kept really telling me not to go out the door and go out the house with her that night. But me, I just wanted to be hard-headed, go with my friend, have fun. I went with my friend, and that's what went down.
Okay. And when you say go out of the house with her, who are you referring to?
I was with her, and we got in the car with Lil Rod.
So who's her?
Brazy, Tyra.
And so when you got home from work, was Brazy already at your house?
Yeah.
Okay. Can you tell the jurors why was she at your house?
Because she was homeless, and she was already like asking me could she stay there and stuff. But my mom had already been telling me like she had to go prior to that, because I guess she was doing stuff or giving them little signs when I was at work about what was going to go on and stuff like that. So my mom told me she had to go, but she was staying with me.
Okay. And you said you guys were leaving the house. Who picked you up?
Lil Rod.
And can you tell the jurors, if you got off from work around 11, you went home, what time would you say you left your house that you live with your mom and Miss Brazy?
I can't really remember what time we left.
Okay. Do you think you, after you got home from work, that you were home for an hour or 2 hours or longer?
Probably like an hour or two.
Okay. And can you tell the jurors, do you remember what kind of car Lil Rod picked you up in?
Yes, it was a van.
It was a van?
Yes.
Remember what color?
No, I don't.
Okay. And I should have asked you this earlier, so I apologize. The people you're referring to as Lil Rod and Bally, were they, do you know if they were around your same age?
I'm not sure.
Okay. Did you go to school with either one of them?
I'm not sure. I was introduced to them by her. Like, I didn't know them like that.
Okay. When you say her, who are you referring to?
Tahira.
Okay. Now, after Lil Rod picked you guys up, can you tell the jurors where did you go next?
I can't really remember.
Okay. What, I guess, what was the plans that night after you were leaving your mom's house?
I know, okay, we pulled up to Ballot House, we got out the car, we went in the house and stuff like that. We in the house, I was talking to Blaylock then. Boom. After that, went downstairs, played the game, I dozed off. In the midst of me dozed off, I hear Tahira on the phone saying, pull up, we finna do one. Do one mean fuck.
Okay.
Sustain.
Let's not tell me what anybody said. So you talk faster than any of us in the courtroom, okay?
Mm-hmm.
So let's just back up just a second. So you keep saying Blaylock and Bally. Is that the same person?
No.
Okay. So
Yes, it is, yes.
okay. So the person you know is Bally is his real name or the name he was given at birth. His last name Blaylock.
Mm-hmm.
Yes.
Yes.
Okay. Now you said that y'all went from your house when Little Rob picked you up. You went to Bally's house. Is that what you said?
Mhm.
Yes.
Yes.
And can you tell the jurors? Do you remember? I guess where the general area where Mr. Bally's house was?
I just knew it was some apartments. I don't remember, but I kind of do. Like, if I go there, I remember, but I don't really remember.
Okay. Can you tell the jurors? Do you know or do you remember? You talked earlier about where you knew that Little Rod's house where he lived was off Cleveland. Do you know if the apartments you just described where Bally lived was close to the Cleveland house that you described where Little Rod lives?
Yeah, they stay across the street from each other.
Okay. Now, when you got to Bally's house, was it still just you, Miss Brazy, Lil Rod, and Bally? Was anybody else there?
I'm not sure. I just knew it was us four, though.
Okay. And you said once you got there, you dozed off?
Mm-hmm.
Yes?
Yeah, I went to sleep, and after that, I heard, like,
Well,
Tahira.
don't tell me what anyone said.
I heard her in the background, boom. After that, I heard what she said. I got up. In the midst of me getting up, Blaylock attacked me. I went out the door. I see a Dodge Blue Charger pulling up. Next thing you know, I went to the car because BJ rolled down his window. And he was like, Mariah, where they at? Whoop, whoop. He was asking me where somebody was. Boom. After that, me and he was talking about going to do, like, get some weed or whatever. Boom. After that.
Hold on 1 second. Miss Smith. So
yes.
You said there was a conversation. Was Miss Brazy, was she talking to somebody in the room or was she talking on the phone?
She was never outside with me.
No.
When I went out the door.
When you
Oh, she was over the phone. Yes, she was over the phone.
Conversation that woke you up was with Miss Brazy on the phone with was it a male or a female?
I'm not really sure. I don't know.
And you said then you went outside and there was a blue Charger?
Mm-hmm.
Gotta say yes or no?
Yes.
Okay. And when you got outside, did you know anyone did you know a blue Charger was going to pull up?
No, I didn't.
Okay. And when you got outside and the blue Charger was there, did you recognize anyone inside the Charger?
Only BJ.
Okay. And was it just BJ in the car or were there other people in the car?
It was two other people in the car, but I didn't know them.
Okay.
Never seen them.
Okay. Was this the first time you met them?
Mm-hmm.
Yes?
Yes.
And do you ever get into the car?
Yeah.
Okay. And can you tell the jurors, once you got into the car, did you get introduced to, you said there was two other people in the car?
Mm-hmm.
Yes.
I mean, I can't really remember. I don't know. I just know we was all in the car.
Okay.
And we drove to the other side.
Was BJ driving? Was he in the passenger seat?
BJ was driving.
Okay. And do you know who was in the front seat when you got in?
And Jamari.
Okay. And who was seated in the back seat with you?
Brazy was by the door. I was in the middle, and little boy Red was on the other side.
Okay. So let's talk about that. So you said that you went outside and you met BJ and the people you met that night as Jamari and Red.
Mm-hmm.
Can you tell the jurors, when does Brazy enter into the picture? When does she come outside?
She came outside when I got in the car.
Okay. And did she also get into the car?
Yes, she did.
Okay. Where in the car did she sit?
She sat by the door. I was in the middle.
Okay. So was she the back with you?
Yes.
Okay. And so can you tell the jurors when everyone's in the car, where are you guys going next?
I guess we was going to get weed.
Okay.
After that, we pulled over there, whatever she led them to, some apartments I never been in. I'm sitting in the car for a little minute. Next thing you know, she get out the car. She leaves. She come back and get me as soon as I got the car.
Hold on, before we get there. So how far did you go from where BJ in the blue Charger picked you up and took you to buy some weed? How far was that trip?
I mean, it was across the street, literally across the street.
And I think I heard you say that Ms. Brazy directed BJ where to go?
Mm-hmm.
Yes?
Yes, she did.
Okay. And when you guys got there, do you remember inside the car, did you or anybody else give anyone any money to purchase marijuana?
No.
Okay.
I don't remember.
Okay. And so once you get there, can you tell the jurors, do you all go inside to an apartment or?
No, she get out the car first. Then next thing you know, she come back and get me out the car, and the car just got shot up all of a sudden. But when we get out the car and we started running, I seen Blaylock and Leroy running towards the car, like literally shooting the car. I saw them.
Okay. And had you ever been, you said this was an apartment complex. Had you ever been there before?
Never.
Okay. And I want to show you what's been marked. That's State's Exhibit 10, N as in Nancy, N as in Nancy, through 19, N as in Nancy, N as in Nancy. All right, let's start with State's Exhibits 10, 11, and 12, and N, okay? Do you recognize those?
Yes, I do.
Okay, and how do you recognize them?
Because this were right here on this thing, I can't really.
Well, don't show us.
Okay.
You can
Have you-
show it to Mr. Abbasi, who's questioning you, just don't show it to the jury.
Yes, ma'am. I remember this right here because this where we was parked at. This the breezeway I ran down to go in the back with Tahira. We was in the bushes, hiding right here until Leroy came to get us. She led us through a cut. We got in the car with him. They took me back to Blaylock House.
Let me ask you this question. In State's Exhibits 10, N through 13, N, do those pictures fairly and accurately depict the apartment complex that you've described where you guys stopped to buy marijuana?
Yes.
Okay. And at this time, we're on to the state with tender, what's been marked as State's Exhibits 10 through 13, N.
Those are admitted.
Okay. Now, I want to show you State's Exhibits 13, 14, and 15, and can you tell me, do you recognize what's depicted in those photographs?
Yes.
Okay, and how do you recognize the photographs in State's Exhibits?
Just the car that we was in that pulled up.
Okay, and is that vehicle or that's depicted in State's Exhibits 14 through 16 and fairly and accurately depict the blue Charger that picked you up that night?
Yes.
This time around, the state with tender, what's been marked as State's Exhibits 14 NN through 16 NN?
Those are admitted.
So you said you did recognize and the vehicle depicted in States Exhibits 13, 14, and 15 NN fairly and accurately depict the charger that picked you up?
Mm-hmm.
Okay. This time, Your Honor, the state would tender what's been marked as States Exhibits 13 through 15 NN.
14 through 16 or 13 through 15?
I misspoke. It is.
All right, those are in a minute. 14 through 16, right?
It's 13 through 15. I apologize.
Okay, so what was, I thought it was 10 through 13 the first time around. Was it only 10 through 12?
I apologize. I
That's
got
okay.
confused this late now. It's so 10 through 12 NN
Okay.
are the max.
All right.
And then the car is 13.
Okay, those are all admitted.
Okay. So I want to put up on the screen in front of you here in a second, States Exhibit 10 NN, okay?
Okay.
And it's going to pop up right in the computer right in front of you, okay?
Mm-hmm.
Being put up. Ms. Smith, could you tell me, so you said you guys parked, the car parked?
Mm-hmm.
Yes? Gotta say yes for the record.
Yes.
And how long was Ms. Brazy, how long was she gone from the car when she left to go to the apartment?
I'm not really sure.
Okay, was it a few minutes? Was it an hour?
Probably like a couple of minutes.
Okay, and you said she came back?
Mm-hmm.
And can you tell the jurors, when she came back, why did she come back?
When she came back, she got me out the car. As soon as I got the car got shot up.
Okay, and why they are pulling that up on the screen, I want to show you State Exhibit 17, 18, and 19. All right, so while that's getting put up there, can you tell me, do you recognize the photographs in State Exhibit 17 and through 19? And can you tell the jurors, how do you recognize those photographs?
Cause that's the breezeway we ran down.
Okay, do those exhibits, the photographs in State Exhibit 17 and through 19 and fairly and accurately depict, I guess, the apartment complex and the breezeway you said that you guys ran after the shooting started?
Yes.
Your Honor, at this time, the state would tender what's been marked as 17 NN through 19 NN.
Those are admitted.
All right. Okay. So can you show the jurors, do you see the red line that's in the middle of States Exhibit 10 NN?
Mm-hmm.
Yes?
Yes.
Okay. And you see where it starts near the parking spaces?
Yes.
Can you tell the jurors, is that where the car parked, the Charger that you guys were in when you arrived?
I'm not sure what spot, but it was somewhere right there.
Okay, was it in that general area?
Yes.
Okay, and you talked about, I guess, after the shooting started, you saw Lil Rod and Bally, I guess, come running at the car, shooting at the car, right?
Mm-hmm.
Yes?
Yes.
Can you kind of show the jurors the area which you saw them come running towards the vehicle with guns?
I mean, I really don't remember when I ran through the breezeway. I just knew I seen them.
Okay.
Like, I don't remember.
And in 18 and can you tell the jurors, is this the breezeway that you're talking about as soon as it comes up? Do you see the breezeway?
Yes.
And is it the area in the middle of State's Exhibit 18 and in where there's an opening with stairs?
Yes.
Okay. And can you tell the jurors, you said you ran through that breezeway, and where did you go?
In some bushes with tire.
Okay. And the bushes, in relation to, I guess, the building that we're looking at, where you ran through the breezeway, where is this, I guess, the area with the bushes in the field?
I mean, the bushes was right there, literally, in the back. Like, as soon as we ran through the breezeway, the bushes was right there. It was a field in the bushes.
And State's Exhibit 10 and N, which will be in front of you in 2 seconds. Can you kind of show the jurors, orient them kind of where you ran through the breezeway and past the buildings?
I mean, I'm assuming these the bushes right here.
Well, I don't want you to assume. So can you kind of circle the area or point to the area on the photograph?
You can't see it on the screen?
Oh, I forgot your screen isn't interactive. Okay.
Yeah.
So I'm gonna walk over here, okay? And I want you to tell me where to stop. So if this is the breezeway and you ran through it.
The bushes right there.
These bushes?
Mhm.
So the bushes at the top left-hand corner of State's Exhibit 10 and N?
Yes.
Okay. And did you go to those the bushes or the area where the bushes were by yourself?
No, I was with Tahir. I ran in the bushes with her.
And you said you ran towards those bushes because you heard and saw Lil Rod and Bally shooting at the Charger.
Correct.
Can you tell the jurors how many shots did you hear?
I'm not sure.
Okay, did you hear one shot, two shot?
Multiple.
Okay, more than 10?
I'm not sure. I just know I heard shots.
Okay. And how long did you guys kind of, I guess, wait or stay in the bushes?
Not for long. Like, after it happened, she led me through a cut with her, and we got in the car.
Okay. And prior to kind of going, I guess, through the cut into the car you just talked about, can you tell the jurors, as the shots are being fired at the Charger, who's inside of it?
BJ, Jamari, and Red.
Okay. And as the shots are kind of ringing out and being fired towards the car, can you tell the jurors, do you see the Charger that BJ, Jamari, and the person you knew as Red were in? Does it stay there or does it move?
It stopped. The car stopped, and only 2 people got out.
Okay. And when you say it stopped, how far did it get from the area you described where you guys had parked?
I'm not really sure. I just know I seen the car after.
Okay.
When we was in the bushes and stuff.
Okay. And can you tell the jurors when you saw the car after when you guys were in the bushes, do you see anybody get out of the car?
Only 2 people.
Okay. And do you, at the time the 2 people get out of the car, do you know who it is?
BJ and Red.
Okay. And
I didn't know at that time, but now I know.
Okay. So at that time, you only knew 2 people got out of the car.
I never knew who they was, though.
Okay. And you said you guys were in the bushes for a little while, and then you said your friend, Miss Brazy, she led you through a cut? Yes?
Yes.
And how far, I guess, from the bushes, or how long does it take you to get from the bushes and through the cut to the car?
I'm not sure.
Okay, was it a long walk?
I mean, I really can't remember like that. It's been so long.
Okay. And once you said, how did the car know, I guess, to where to pick you up?
I don't know. I was following her.
Okay. And who was driving the car?
Lil Rod.
Okay. And can you tell the jurors, was it the same car that Little Rod had picked you up in earlier that night from your house?
Yes.
Okay. And once you got in the car, who was in it?
Just Lil Rod, me, and Tahir. That's it.
Okay. And where did you, Lil Rod, Miss Brazy, and you, where did y'all go next?
They took me back to Blaylock House.
Okay.
And we was there. They left, locked me in the basement, and went back to the scene.
Okay. And you said they locked you in a basement. Why did they lock you in the basement?
I don't know.
Okay. Um, how long were they gone?
I mean, I'll say like 30 minutes at the most because the mom came in, she was screaming and stuff. It's like she knew what was going on and she locked me back inside the basement. After that,
Whose mom?
Blaylock.
Okay. And did you tell her what happened?
No.
Why not?
I mean, she was in a rage. She was looking for her son.
Okay. And did the time that you, I guess, are locked in the basement, did you have a phone?
Yes, I found like a little phone in there. I called my mom. I called her 2 times, but she never told me that no police is at her house right then. After that, I called my grandma. My grandma told me to call my mama back. I called my mama. My mama yelling and screaming, homicide at her door at this point. I tell my mom where I'm at. At this point, I'm scared. I really don't know what to do. I didn't tell them that I talked to my mom when they came back. They just kept telling me that we was going to the basketball court. They come back. I played like I ain't talked to nobody or nothing. We all get ready to go out the house. The police pull up. Everybody take out running except me.
Now, you said you found a phone in the basement to use. Did you have a phone that night? Your own phone?
No, I didn't have no phone. No.
Where was it?
I mean, I didn't have my particular phone on me. I don't even think I had a phone
Okay.
at that moment.
And when you got back to Valley's house, and before they leave you in the basement, is Valley and Little Rod, is there any conversation about what just happened?
Yeah, like they was getting calls from people. People was telling them about.
Speculation, hearsay.
Let me I'll ask a more direct question, okay? So, and I should ask you this first. So, when you guys get to Valley's house, is he already there?
Yeah.
Okay.
Mhm.
And you three go back, I guess you, Miss Brazy, and Lil Rod, you all go down to the basement. Is that where Valley is? Yes? Okay, so I just want to ask you these direct questions. So what do you hear Little Rod and Valley discussing about what happened with the shooting?
I mean, I really don't know what to say because they keep saying objection every time I say something. So I really don't know.
All right, I get it.
You don't worry about what they say. Just stop, and then if he asks you another question, unless you hear objection again, go ahead and answer.
Okay.
Just tell me what Valley and Lil Rod say. Don't tell me what anybody else said, okay?
Yeah. I'm not sure. I
Okay.
really don't know.
Do they say? Well, let me ask you this: are they talking about the shooting of the Charger?
Yes.
Okay, what do they say?
I mean, I just hear Blaylock saying, "Oh man, I ain't know that was him." This and the third.
Okay, and does Lil Rod say anything?
I'm not sure.
Okay, and as they continue to talk, would you say they're kind of bragging about the shooting?
I'm not sure.
Okay. And then how long, I guess you guys, let me back up. You said you're going, when they get back, you said you go to a basketball court?
We didn't never make it there
Okay. And why didn't you ever make it there?
because the police came.
Okay. And you said when the police came, everybody else ran?
Yes.
Okay. And do you go with the police
Yes.
anywhere from, I guess, the area where the basketball court is?
Yes, I went with them.
All right. And where do you go?
Down to homicide investigation.
Okay. And do you remember, do you speak with a Detective Hogan and a Detective Casey?
Yes.
Okay. And when you, I guess, are talking with Detective Hogan and Detective Casey, does your sister, I guess, come down to APD
Yes.
headquarters?
Yes, she did.
And when you first begin to talk with Detective Hogan and Detective Casey, is it just you and the two of them in the room?
I'm not really sure.
Okay. And tell me this, when you initially start I guess, answering the questions that the detectives have for you, can you tell the jury, are you honest? Do you tell them the truth about what happened that night?
I mean, at first I was kind of shook up. I kind of lied a couple of times, but when my sister came in there, I felt more comfortable and told the truth.
Okay. And do you, I guess, kind of tell them a series of stories and lies about what you knew happened with the shooting of Jamari?
Mm-hmm.
Yes.
Yes.
Okay. And why do you tell them several different stories or different lies as they're questioning you?
Because I was scared.
Self-
Response.
Self-serving what?
Overruled. You can answer. You can answer.
Could you ask me again?
So why don't you tell them the truth as they continue to ask you questions?
Because I was scared. I was feared. I never been in nothing like that. I don't even get in trouble. I don't even have a record. So,
What were you scared of?
I mean, life. Things go on.
Now, you said your sister, they let your sister eventually come in the room with you?
Mm-hmm.
Okay. And when she comes into the room, can you tell the jurors, I guess, why do you feel, or do you begin to tell them what you told the jury that you saw Bally and Lil Rod do to your friends inside the blue Charger?
Yes, I did.
Okay. And what about your sister being in the room, I guess, makes you feel more comfortable to tell the truth?
Yes.
What about her being in the room?
I mean, I felt more comfortable
Okay. Why?
because that's my sister. She was there with me.
Okay. Now, do you remember during the speaking with the detectives, are you able to give them like the Instagram names or usernames for Little Rod and Bally?
Yes.
Okay. And I want to show you, do you, I guess, do you look up Lil Rod's Instagram and give them pictures
Yes.
or show them pictures? Okay. Let's see. So I want to show you in State Exhibits 23NN and 24NN. Do you recognize those photographs?
Yes.
And how do you recognize those?
Because that's Lil Rod.
Okay. And are those the photos of Little Rod that you showed and sent to the detectives on February 23rd of 2019?
Yes.
And do those photographs fairly and accurately depict or are copies of the photos that you showed and gave both Detective Hogan and Detective Tracy?
Yes.
Your Honor, this time the state would tender what's been marked as States Exhibits 23 and 24, N as in Nancy, N as in Nancy.
As admitted.
All right, so I want to publish those photos. Now, in States Exhibit 23, is this how you, I guess, how Little Rod looked back in February of 2019?
Yes. I'm not sure if that's how he looked, but that was a picture of him.
Okay. And is that the same with States Exhibit 24, N as in Nancy, N as in Nancy?
Yes.
Okay. And do you see in both of those photos, person you've described as Little Rod is holding a gun?
Yes.
And can you tell the jurors the guns that you see in either one of those photos, does it look similar to the gun that you saw Little Rod with on?
I'm not sure. I'm not familiar what type of guns they had.
Okay. Now, I want to talk to you a little bit about, we just talked about the guns. Can you describe to the jurors, do you remember telling the detectives or describing for the detectives I guess, the type of guns or the size of the guns that you saw that night?
I'm not sure.
Okay. Do you remember describing?
Sustained.
Well, during that interview on February 23rd of 2019, do you remember describing, I guess, the length of one of the guns that you saw Little Rod with?
I'm not sure.
Overruled.
You can answer.
You can answer.
I'm not sure.
Okay. When you say you're not sure, do you not remember?
No, I don't.
Okay. So you don't remember describing for Detective Hogan and Detective Tracy that you saw Little Rod with a long gun?
I probably did. It's been so long.
Okay.
I don't know. I'm not sure for real.
And do you remember specifically talking about the statements that you heard Little Rod and Bally saying after they got back to, or after y'all got to Bally's house? Do you remember telling the detectives about that?
I'm not sure.
Overruled.
I'm not sure.
Okay. When you say you're not sure, do you not remember telling the specific statements that you heard Little Rod and Bally talking about at Bally's house to the detectives on February 23rd of 2019 during that interview?
I don't remember.
Okay. So do you don't remember telling Detective Hogan and Detective Tracy that you heard Little Rod say, "We really just popped them N-words"? Do you remember?
Yes, I did.
Okay. And then Bally, you heard Bally say, "Hell yeah, one."
I'd ask for a limiting instruction. It's not going B2E. This is spilling beans. I would object. Anything used against Mr. Wood.
I don't know what the full thing is going to be.
I don't object to I guess the limiting instruction we've been giving as it relates to any statements previously made by any previous co-defendants.
I don't think that was exactly his objection. Y'all come up to the bench real fast for me.
You know. Okay.
So we have not seen DA Love today, really, y'all. We saw DA Love, but she didn't do anything. Like, we actually saw her, but nothing came out of it. Y'all think about that. Another screw up. Ben told y'all that. Par for the course. I'm feeling particularly justified, vindicated, I should say. I know y'all going to get tired of hearing me say it, but I'm going to say it any old way. Y'all, are they in the chat? Like, are we? I think it would be smart for them to be in the chat, right? Because we kind of like a hive mind. I mean, not just our chat, but if you think, you'd have to decide which chat you want to monitor. But if you think that you might be able to be in the chat, would that be against the rules? Because if you get into a good chat, y'all, that's like a hive mind. And it's not that we know more than them, but we certainly can think of things to say that they wouldn't think of on the spot for sure. Right? And you get access to the hive mind. You get access to, here we have 1,000 people. Not everybody's chatting, but, you know, people pop in, a couple of hundred people that are chatting. And then you also have Kat, and you have Dear Woke Christian, and then you have Lead, and you have AV, and everybody has these different communities, and some people float around. Infamous Sylvia. And yeah, it seems like it would make sense to, yeah, say what's up to Steele, say what's up to Sharp, say what's up to all of the people. I definitely think that it makes a lot of sense to be in.
All right, ladies and gentlemen, you know, I've already told you a couple of times that sometimes witness comes in, a testimony, evidence only comes in for a limited purpose or against only particular people, and this is another one of those circumstances. So you have just heard and are going to hear about statements by Blaylock and defendant Ryan, and you may consider those statements only against defendant Ryan and only as to count one. You may not consider either of the statements from Blaylock or Ryan as to any other count, and you may not consider them in any way in determining the guilt or innocence of any of the other defendants in this case besides Mr. Ryan is to count one. Okay. All right, let's get the witness back in. I wish we'd done that beforehand, but yes.
Y'all, that's wild how that lady just waited until after the approach to call an approach. What's up with that? She's like, I'm going to wait until we're finished and then do my thing. Yeah, we have a second approach. Wow. I'm making a thumbnail, y'all. I'm working on a thumbnail right now. So y'all bear with me. So these guys were cooking, huh? Got to get my thumbnail on. Bob Marley in the thumbnail? You know, I'll tell y'all what the thumbnail is going to be today. I'm about to make it right now. I'm putting the 3 attorneys who cross-examined the witness. I'm putting the 3 of them. Oh, man. I'm going to put the 3 of them, if I can pull it off, because I'm by no means an expert at this. I would like to put the 3 attorneys who cross-examined the witness. I'd like to put all 3 of them there. I'm going to see if it's possible, though. Might not be possible. I'm going to put all 3 of them. I'm going to put a chef hat on all of them, and they all going to be cooking. We'll see how possible that is, though. I'm going to see if I can make that happen. I'm going to see if I can make that happen. Bob Marley would certainly be a good one. But I don't think that is the angle I want to go. I really want to go with, I like when we do the cook thing, you know? I like when we make them cook. Because that's what these guys were doing today. They were all 3 cooking. Crap. Yeah. It's look, I'm not an expert at this though, so like it's definitely not gonna be like the same as if like a true professional had done it. You know, I'm just a dude who does a little something with this stuff. So it's gonna be a little bit bootleg, as we call it, but it'll work. I'm working on it now. It should be done in about 5 minutes or so. So I have Shart, I have Apt, and now I'm gonna put Steel on, and then they all gonna be cooking. So this is another one of the witnesses who you can't see their face, huh?
Okay, so I just referenced, sorry, are you ready? I just referenced statements by Blaylock and Defendant Ryan, and what the court means to say is that according to this witness, statements were made, the court's not making any kind of finding or comment or determination whether the statements were in fact made, whether they exist or not. Okay, obviously it's up for you to determine all of the evidence in the case. So, okay. Back with the witness. All right, go ahead, Mr. Abadi.
Thank you, Judge. Now, Ms. Smith, we think we left off. Do you remember talking to and telling the detectives that you had then heard Bally, the person you've called Bally or Blaylock, say, hell yeah, one of them N-words dead twin?
Yes.
Okay. All right. And I want to show you State's Exhibit 20, N as in Nancy, N as in Nancy. And do you recognize the photograph depicted in 20 NN?
Yes.
And how do you recognize that photo?
That was the little boy that was shot in the car.
Okay. And does it fairly and accurately depict the person you met that night as Jamari in that photograph?
Yes.
Your Honor, the state would tender what's remarked as State's Exhibit, what did I say, 22 NN? 20 NN, I'm sorry.
20 NN, it's admitted.
Now, Ms. Smith, can you tell the jurors, did you set up BJ, Jamari, and Red to be shot that night?
No.
Okay. Did you know that Bally and Little Rod were going to come running out, shooting at the Charger with BJ, Jamari, and Red?
No.
After all of this happened, Ms. Smith, can you tell the jurors, did you fear for your life after this?
Yeah,
Okay, tell me why.
because my mama house got shot up multiple of times. I was working, I was receiving threats. People went to my sister's job. It was just a lot of stuff that happened pertaining to this situation.
Thank you, Ms. Smith. I don't have any further questions.
All right, are there any defense questions for this witness? No, we need to go ahead and get moving on this, so it's time.
Good morning. Good afternoon. I'm attorney Angela D. Williams, and I represent Rodalius Ryan. And I'm going to talk to you about what you testified to at the trial in September 2021. Do you remember testifying?
I kind of don't.
You don't remember?
No,
Do you
I don't.
That's fine. Do you know how to read?
Yes, I do.
Okay.
We should probably approach for a real quick second.
All right. I think we're going to break here for the day and start back again at 9. So I'm going to excuse y'all with your same instructions as always.
What?
And Ms. Smith, I'm sorry to have to make you come back tomorrow, but we're going to need you back here at 9 tomorrow as well. I think it was just going to take too long to get through it all today. So sorry about that.
Yes, ma'am.
All right, you're excused. Yeah. So the issue on the floor had been Misty Williams' reference to a trial and how that needs to get handled. And I had asked at the bench, was the state intending to ultimately tender Mr. Ryan's conviction at trial for this murder? Because if that's the case, then they're going to know there was a trial. And otherwise, and if so, we need the limiting instructions still. And if not, then we need to figure out how we're going to refer to, if testimony is going to get used, how to refer to it.
Prior proceeding.
Right. And that would certainly work. So what's the state's intention with regard to whether you're introducing the conviction?
The state intends to do so, Your Honor, but I obviously wasn't going to mention it or do so until sorry, I can't hear.
Basically, yes, is the answer.
Yes.
All right, then we need the limiting instruction, and we're going to need that probably, before tomorrow. And yes, sir.
Your Honor, and I'm not trying to step over Miss D. Williams' case. From my perspective, I'm not sure under what legal theory the conviction would be entered. Mr. Ryan is, to my knowledge, unless he testifies, it wouldn't be for impeachment. The legal determination by another jury, I don't understand the relevance. I mean, this jury needs to make a decision, and this is listed as an overt act, to my understanding, in this indictment. So we're inviting the jury to know that a separate jury made a factual determination on one of the overt acts. And I view that as problematic.
Well, I think that, as to Mr. Ryan, that's evidence against him, and he's frankly already been confronted with it. The issue is with regard to anybody else.
Well, from my perspective, and I understand what you're saying, Your Honor, but why would we're hearing from witnesses in court.
I mean, I guess in the same way that some other co-defendants' guilty pleas have come in.
But those would be admissions. This is not an admission. This is just a determination by a separate jury, which I don't believe that's not evidence as I understand it.
What's the state's response?
So instead of just giving you an off-the-cuff answer, I'd like to do some.
All right, so we're going to have to arrive really early in the morning because these are some pretty critical issues that I have raised over and over with y'all, that we were going to have to deal with this when it came to Mr. Ryan's conviction. And I think Mr. Kendrick might have a plea or something as well. So I don't want to wait till first thing in the morning for them. But of course, that seems to be the way we do a lot of the things we do in this case, off the cuff. To get something to everybody as soon as possible, including potential limiters. All right, where are we on the Wooney Lee evidence? Since I assume he's going to get reached sooner rather than later this week as well, right?
Your Honor, I had sent out a document we had received from the state, which had the compilation of everything they originally submitted that they wanted to offer into evidence with Mr. Rooney Lee. I think the state has possibly gone through and eliminated some pages, but they've not finished doing that as of earlier. So if they want to specify which pages, then we can raise our objections. It was a document I sent earlier, 31 pages.
So, Your Honor, I have, and he's going to be testifying in this trial. And so, unlike the Blaylock Instagram that we hashed out before putting up this act, the predicates for introducing his Instagram, for the most part, there is a couple that I do believe are co-conspirator statements. He's also testifying that they would be via impeachment in terms of the right predicate questions. And so when what this PDF that defense counsel and the state are working off of is items that the state had identified, I think back in August, or when we made this larger co-conspirator statement of party opponent Dropbox link that we shared with all counsel. And so that what I am doing is, as the state continues to do, looking at what the state had organized as potential either co-conspirator statements or items that would address in Instagram with this witness, the universe of items that need to be pre-litigated, so to speak, in terms of these are group threads, messages that he makes to other parties. So what me and Ms. Abbasi were doing was just, I was going through them, given court's previous rulings and thinking through the efficiency of this witness and what the state wants to use. And so
Might we reach him tomorrow?
we could reach him tomorrow, Your Honor. I think it's most likely to reach him Wednesday.
Okay.
But we could reach him tomorrow.
So then our lunch will be spent at least partly hashing out whatever y'all don't sort out.
Yes, Your Honor.
Okay. Okay.
And I do think one key thing with this witness is pre-hashing out. It's essentially what questions the state can ask is kind of predicated on these items, because the state, other than just a small few, can't introduce any of these Instagrams unless we ask the question. So, for example, some of these are firearms. If we asked this witness a question about, has he ever possessed firearms, ever sold firearms to other YSL members? I'm using hypotheticals for purposes of this. The court may let us ask one of those questions. He may agree we can never get these in. The court and the state would not intend to ask him repetitive questions on that. And so I highlight that in terms of this evidence for him is just like, for example, if he said something contradictory on the stand, the state could use as impeachment purposes a wide range of items.
Right.
So I just highlight that for the court in terms of the efficacy of going through his specific Instagram before he testifies.
If y'all end up concluding that this is just kind of normal trial evidence, that if it comes in for impeachment because he needs to get impeached, then it comes in just like anything else, that's fine. If it's stuff that we're going to have to litigate other issues about, even if it does come in, then obviously I'll need to know that.
Yes, Your Honor.
So y'all need to be thinking about and working on that before lunchtime tomorrow.
I just need to know which ones the state actually
Well,
intends
y'all
on.
can get together on that. Okay, so witnesses, and I know we haven't gone through all of the Monday witnesses, but witnesses 3 and 4, you now intend to call both of those people or no? Or is that just still an either or? It was an either or before. You don't know?
It's like, yes.
Your Honor, it was an either or before. depending on how these witnesses testify, the state may need to call both of them. And
Okay.
so, out of an abundance of caution, they are both
All right.
included there.
And then ADA Hiles, is he like taking the place of some other witness? 'Cause
Yes,
I
Your
didn't
Honor.
see him on this list before.
So, Your Honor, he testified in the initial trial specifically about
Mr. Ryan's trial?
correct, Your Honor.
Okay.
And so there's trial transcripts. He actually testified at the motion for new trial as well. And so when defense counsel and by defense counsel, I mean Ms. D. Williams, Ms. Sabasi, and myself,
Mm-hmm.
given the guardrails, so to speak, of his testimony is well lined out, he's essentially describing these Instagram records that both
All right.
so that witness is replacing what initially on that list was going to be either investigator Viv Brito or Sprinkle for the Jamari Holmes murder.
Okay. Thank you.
Yes, Your Honor.
And just FYI for the media, it is okay to show that witness whenever he takes the stand. Hiles. All right. And can I also just ask, as long as we're talking about scheduling, I know y'all are going to circle back on your big order of proof and exhibits list to Mr. Arnold at some point, and y'all have indicated the date. Other than him, is there any other witness in the first 50 that the state still intends to call? Are we through with those acts and counts and what have you? How about if y'all just take a look at that tonight and let me know in the morning?
Yes, Your Honor.
Okay. Because it appears to me that we're through most of 1 through 50, like I said, other than Arnold, but they're, just let me know. Okay. All right. I think we need to be here at 8:30 in the morning. And that probably is, we're still, I mean, I'll see whether we end up starting at 9 or not. Hopefully we can, if y'all can get me things.
Yes, Your Honor.
All right. Okay. See everybody at 8:30.
Thank you, Your Honor.
All right, y'all. So today was another one of those crazy days. Crazy days. I was being on live stream for all day, y'all. It's like, oh, y'all go check out the video. I had like a mishap with my internet. Stuff went crazy. The video, I think it came out halfway decent. I was working on it while we were on stream. Y'all just open the video. Just give it a quick like for me, please. It will help. You can watch it all the way through. That will help even more. Give it a thumbs up. I do appreciate y'all. I will see y'all today. I'll see y'all tomorrow. Thanks to my mods, Andre. Thank you for Miss Lily. Papa Bear, you always with us. Solitude, you always with us. Thank you to all of I'm going through shout out all of our members. Paula, thank you. Nosy Rosie. Oh, you came back, Nosy Rosie. I was just about to say I'll be seeing you on other channels, but you're welcome over here all the time. Destiny member, thank you. Thank you for everybody who contributed. Clizzle sent a bunch of these super chats today. Alchemist supported us. Is that Rochelle or Rachel became a member? Not offer for the truth of the matter, 403. Amy Celeste helped out, not offered. Once again, I thank all of y'all. GA Powerade also. So y'all, we'll be back tomorrow. I thank everybody. Really humbled, really like this community we're developing. And thank y'all for working with me through my technological issues. Have a good night. Have a good evening. Sleep well. And we'll be back tomorrow. Bye-bye. Unless y'all just want to hang out. I mean, I guess it wouldn't. Y'all just want to chat. I could just turn off my camera. Yeah, I'm gonna just turn off my camera. Nah, I'm gonna end it. I'm gonna end it. Y'all can leave some comments. I'm gonna go ahead and end it, y'all. I'll see y'all tomorrow. Have a good evening. Bye-bye. Clown card thumbnail. The more members we get, the more clown card thumbnail.
All right, members of our jury, I have an instruction that I need to read to you at this time. You have.
All right, y'all. I'm gonna go because this is some other content that I'm not sure what it is. So, this is Sarah Boone. I'll see y'all tomorrow. Have a good night. Bye-bye.